Uh,
Good.
Okay, we ready to start?
Yeah, let me say something before we get going though, because this is being recorded. I want everybody to understand, particularly any plaintiffs' lawyers that are listening in, that we're talking not at the standard of care, but at a much higher level, sort of an aspirational level. We're trying to give information, and we are going to be rendering opinions that may not necessarily be matters of law. And so again, understand this is an educational program. It's not meant for legal advice. It's not meant to set a new standard of care. It is simply to educate members on what Linda and I believe to be important issues relating to the new contract.
Great.
Do we get a bonus for the recording? I'm kidding.
John, you want to introduce yourself?
Yeah, my name is John Giardinelli. I am privileged to be an association counsel and have been for quite a long time. I represent a number of realtor associations, and more importantly, I represent a number of realtors themselves in brokerages, and I look at everything from a defense standpoint. We don't sue realtors. That would be rude, frankly. And so we are defense lawyers primarily. And I just want to make it clear that everything we're talking about today is from the standpoint of risk management and how to stay out of trouble and serve your clients as best as you can. And I am privileged to work with one of the finest brokers that I know, Linda DiStefano. And Linda is actually a real estate salesperson and a real broker. She's actually in the trenches. And so she's going to give you the practical information that you need to have to solve the problems that I'm going to bring up. So that's who I am.
And I'm Linda DiStefano. I have a broker's license, but I am the manager and training director for Century 21 Care. And I've done that for about 20 years now, where I've also been privileged involvement with Tri-Counties Association of Realtors. I'm a former president 2 times, and also I've had the privilege of representing you at the state level since the year 2000. And the committees that I'm involved in at the state level are Forum on Forms, which is where we actually give information to the committee, the Standard Forms Committee, and the attorneys who are involved there, what's happening out here in the trenches, what the agents need, what the changes they require or need in contracts. That's a great committee, and I've watched a lot of the forms get developed and used over the years. Also, risk management, as John mentioned, I've been a member of the risk management committee for about 20 years as well. And that's exactly what I do every day, probably what all of you do every day, is get involved in the forms and risk management to stay out of trouble. So we're fortunate to have John. He guides us along, not only at the association, but at our brokerage as well. So hopefully you'll learn a lot today. We have a lot to share. I did want to share that what John and I had the privilege of doing is sitting in classes. We've actually taken 12 hours intense training on this new contract with the attorney Neil Kalin at CAR. And the best part of that was Neil was in the room when all the changes were made. So he not only told us what the changes were, but why they were made. So you may have a lot of questions today. Hopefully between John and I, we can answer those questions regarding why changes were made and what was the idea and thought process behind it. I don't like to be told myself, just do it this way. I like to know the reason why, and it helps me get through it better. So without further ado, John, you want to talk about our introduction here? Laura has it on the screen for us, and how we'll take care of this situation, getting everybody trained today.
I will do that. First of all, I want you guys to give yourself some grace. The fact is that most of you are familiar with the current contract, and it's going to take some time. I know that Lynn and I have gotten a tremendous head start because we've been involved in the process. Couple of things real quickly. First of all, I want you to understand not everything's changed. The form has changed, and a number of the ancillary and subsidiary forms have changed, but the transaction itself still remains the same. You're going to take a listing. If you're on the seller side, the listing agreement has not changed. You're going to You're going to be doing your marketing just like you always have. Got to keep careful eye toward the words you use and the manner in which you do that. You're in, still following all of the rules in terms of being truthful and all that. You're still going to negotiate. It's the primary value that you bring to the table are your negotiating skills. And so that's not changing at all. You're still going to have an escrow, and the way escrow operates isn't going to be significantly different than the way it operates now, although they're going to be given some different instructions. You're still going to go through a process of closing, and you're still going to go through a process of disclosure and investigation. None of that has changed. There's still going to be a deposit to deal with. Same rules are still going to apply. You're still going to have a maximum of 3% that the seller can keep as liquidated damages. There's still going to be issues regarding when that money goes in, how it's to be transferred in. All of that is not changed at all. The basic process is still the same. Let's go on to the next slide, please. There's still active contingency removal, and you need to be really careful about trying to play with that. We had a case the other day in a mediation where they thought they were going from active to passive, and it didn't work, and everybody ended up hiring lawyers and all of that. So you have to understand that it's still an active contingency removal. Although some of the forms are being modified, you still have to send a notice to perform. You still have to go through that whole process. You're still going to verify funds in the same old way, making sure that everybody's got the money that they say they have. They've given you some extra tools to work with in this contract that Linda's going to point out. You're still going to go through your buyer investigation. You still got to make sure that the buyer is comfortable with the condition of the property, whether they're in all of that. You still need to send notices to perform, as I've mentioned. You still need to deal with allocation of cost. Having a little bit of an issue with our screen, so we'll get that straightened out, I'm sure. So let's move on to the next slide, please. So again, there's many definitions. You're still going to use electronic signatures. You're still going to have mandatory mediation if you want to get your attorney's fees. So none of that's changed. What's changed essentially, although there are some significant substantive changes, I think Linda said somewhere around 25 actual contractual changes, most of which we'll point out today. But what's really changed is the form. The form is, in my opinion, and I don't know if Linda shares this, in my opinion, much better than it currently is. I mean, when I say currently, the one you're using today, it flows better. So let's go on to the next slide, please, and we'll talk about what is changing. The format. That's the biggest single change. They're going to be adding what's called, they're using the term grid. I call it a matrix. You call it a grid. You can call it whatever you want. It is starting on about the second half of page 1 for the next 2 or 3 pages. It's a grid, and all of the negotiating points are going to be on that grid. So you don't need a separate summary form any longer. That form's being sunsetted because that summary, which is part of the contract, is actually going to be in those first few pages. There's very little to check off. And I know Linda has been very clear that she and I and many other risk managers are concerned that you still need to read all the pages, right? There's a 15-page contract and a 1-page broker page that are part of this, so a total of 16 pages, but it's not going to be 16 because there's going to be addendums. There's going to be other stuff. So it's going to be whatever it's going to be, but it's just, it looks different, and you're going to have to get used to that. I guess it's like when I shaved off my beard, my wife had to get used to looking at me differently, right? People, you just look at people differently, but it's still the same transaction. It's really not about a form. It's about your skill in facilitating this transaction. The other thing that's changed, I think for the better, is all the contingencies pretty much are in the same place. and all the default dates are now the same. It's no longer 21 days for this, instead it's all pretty much the same. They've added some pretty cool stuff where you don't have control, where you're going to have 5 days from a later of 2 dates. So it's really going to be pretty cool, I think, because again, you're not going to have to go looking for contingencies in various places. They're all going to be the same. And there's a lot of new language just to avoid disputes, and they've sort of listened to what was it, Linda? Something like 2,000 separate comments that came in.
At least
2,000 comments from you guys all over the state of what they were seeing in terms of problems with the form. Will there be changes down the line? Absolutely. You know, as they realize some of the ambiguities, you know, at some point they had to stop and they had to say, okay, here's the form. But you know, and I know there are going to be changes, whether they be in the forms themselves or in the contract itself. So let's move on to the next slide, please. Again, I've always had these problems when people call me for, you know, disputes that have taken place. Because remember, I only see the dark side. I don't get to see the things like Linda sees, where people have actually gone through and closed a deal. I always have problems, and personal items were always a problem, because, you know, is that supposed to be left behind? Is that a fixture? Is, you know, and so they've cleaned that up tremendously. Reorganized all the paragraphs, so subject matter flows through. It's like when you were in high school and you took grammar classes and they told you how to organize a paper. They've done a much better job of organizing this paper. They've reorganized signature pages to make it much less complicated if there's an entity involved. And then they've added a broker section, and I think they've done a pretty good job there. A couple of ambiguities there that Linda and I will point out today, so you won't feel confused, because if you just looked at this on your own, I think there'd be some confusion. But I think Linda and I can straighten that out for you. And then overall, as a lawyer, I'm always concerned, and I know Linda is as well, about risk management. You know, you're never going to eliminate risk. There's always going to be claims. There's always going to be lawyers and people who want to sue. On the other hand, they've done a much better job, I think, if you do this correctly, in managing risk. I just received an announcement that there's somebody who's not muted, there's some background noise. I don't think it's coming from here. It could be, because we bought a new house, and of course it wasn't new enough for my wife, and so there's contractors here today, but they're in the back of the house, I'm in the front, so we should be okay. But if you're making noise, if you're not muted, except for Linda and I, everybody should be muted.
I have everyone muted except you and Linda.
Okay, good then. I don't know where the background noise is coming from. But anyway, so let's move on to the next slide, please. And okay, we're not going to go over them all, but this is the part of the table that came from the RPA guide, which is a very good purchase if you're thinking about buying something. It is a complete, it's like, what, Linda, if I recall correctly, 100 and some odd pages, almost 200, and it contains a paragraph by paragraph description. So if you ever do have an issue and Linda and I aren't available, or somebody else, you can always read, and you can get an online version where you can actually click onto forms and work. It's more expensive, obviously, and then there's also a paper version that you can buy. And I'm sure Laura can help you find how to buy those. But this is a list of every form, not chronologically, but alphabetically, that is referenced in the contract. So let's just pop through these slides really quickly, and you can see that Linda and I have put a list of every form that is potentially can be used in this in your PowerPoint. So you can look at it. You can see that there are, I think, 73 forms. Now, this is my baby, and I did it for two reasons. Number one is I was challenged by a friend of mine who's an engineer, and you know, engineers think like that. And so this is basically a matrix that lays out the way a transaction looks. And the other reason I did it is because I got tired of hearing people say that my clients don't earn their money. Remember, I represent realtors. And I believe that a realtor like Linda or the people that I get to work with at the association are worth their weight in gold. Although Linda is a Ram fan, and that, that's a problem for her. The fact is that if you guys know what you're doing, take a look at this form, because that's what you have to keep an eye on in every transaction, right? You're going to have a seller, and the seller is going to be replacing their home. And so they're going to become a buyer. Then you're going to sign a contract. Normally, it's the exclusive listing agreement. And that contract is actually between the seller and the listing broker. And of course, there's an agent. Well, that agent may end up transferring later on. And so you've got all those issues to worry about. You could be a dual agent where your company and or you represent both sides. All kinds of issues there, some of which we'll touch on today. You're going to place that listing in your regional multiple listing service. You happen to be part of the largest in the world, CRMLS, also the best in my view. Then that MLS reciprocates with others, but then sometimes, and you're going to need to know this for purposes of getting paid, does the MLS reciprocate? Big Bear, some of the resort boards, boards out in the desert may not reciprocate. Then, of course, you're going to have a buyer's broker if it's a different office, and the buyer's agent who you're going to have to deal with. Maybe you're going to have multiple buyers and multiple sellers, and so you're going to have to deal with that. And then if you're not the first broker dealing with these buyers and someone else has already shown them the property, you may have a procuring cause issue. Now, we're going to have a class next year on procuring cause. It's going to be about an hour and a half. I'm going to give the program to Linda so she can teach it as well, or whoever else Laura wants to teach it, but it's a class on protecting your commission. And so that's important, but we're going to maybe touch on that just a little bit today. Then, of course, you're going to have a relationship with a buyer. Now, if you're Linda or you're me, it's going to be in writing. It's called a buyer representation form. But in California, for some strange reason, it's not mandatory that you have a buyer representation form. I wish it was. And someday it probably will be, and we're moving towards that. I know CAR's talking about some stuff like that, but you're going to have a contract, whether it's oral or whether it's written, with a buyer. And then that buyer, of course, is going to possibly be a seller somewhere else, which means you've got to deal with a contingency for the sale of a buyer's property. And then the buyer's going to be hiring all sorts of service providers, title, lenders, inspectors, handymen, all of those kinds of people, and all those relationships and potential liability issues. And then we finally get to what we're going to be talking about for the rest of the day, the contract that we're dealing with today. And Lynn and I put together the hypothetical that it's an $800,000 purchase price, which seems to be the median price in California right now. Don't change it. Don't change quick. Go back, please, one slide. We're going to have an $8,000 deposit of 1%. We may throw a curveball at you regarding an increased deposit. There's going to be a down payment of $80,000. We'll talk about that. And then there's going to be financing. Again, but as a seller, in addition to the RPA with the buyer, you both have to deal with escrow. And then, of course, there's all sorts of other little issues depending on your transaction. Is the seller a landlord? And is a non-party occupying the property? That's a big issue right now, obviously, in California. You've got lender issues. You've got PACE and Hero loan issues, and you've got occupancy and eviction issues. So as you can see, even the simplest transaction, an all-cash deal, can be very complicated because of all the other things you guys have to keep an eye on. So if anybody ever says to you, you don't earn your money, show them this form, my treat, right? It is, you guys are busy. And inside all of those relationships is your skill, your knowledge, none of which has changed. And of course, the liability for dealing with all those issues. So let's move on to the next slide, and then we'll get started on the actual form. Again, reread the Code of Ethics. Linda and I and Laura have put together programs with the DRE for you guys, And it's clear that the code of ethics is the basis for California law. Article 1, keep your client first. Article 2, don't lie. Article 3, cooperate. Article 9, put everything in writing. Article 10, treat everybody the same regardless of the color of their skin or their sexual preference. 11, be competent. 12, advertise truthfully. And 16, don't interfere with everybody else's contracts. These are all critical, complicated issues, and it's worthy of your attention. And they're going to change things periodically, and you should read. Laura will put the new code of ethics on the association's website as soon as they're available. They may already be available for all I know, and you should read them every year. You should read the MLS. Go on to the next slide, please. You should read the MLS rules very carefully, because they dictate how you enter your listing, how you make offers, what you can and cannot do, what you do with other people's listings, all of that. And there's important issues and a lot of hot topics right now. How does your seller want to allow for access, right? Because that's going to be a critical part of how this contract is going to be negotiated and shown and all that. What kind of pre-approval are you going to require? The contract now has some, and Linda's going to show you some really great ways to pre-elect pre-approval, which is perfectly legitimate so long as you don't steer somebody to a mandatory. Linda and I are going to talk about that. And then the coming soon issues and the registration issues, all of those things can cost you money, which nobody has a lot of today, unless you're Jeff Bezos. And so you need to be careful about the MLS rules, and you should read them. I just wrote an article before I came on today about the love letters and how those play into these issues. And so you want to understand the MLS rules very, very carefully, because it's going to give you a lot of authority and power in terms of how you handle your transaction. Moving on to the next slide, please. And then, of course, you just have issues. You got market issues. I don't know what the market's like in the Tri-Counties area right now, but I'm guessing it's still pretty hot, maybe not as hot as it was. And so because of the hot issues, this is a lawyer's paradise, because you guys have been waiving contingencies. Not a really smart thing to do. You're doing escalation clauses without understanding them. You're using unfamiliar forms. You've got to deal with your buyer's financial strength, and a lot of people are having difficulty qualifying and getting into the game because the market goes up and up and the affordability goes down and down. What's your seller's motivation? Are they moving? Are they divorcing? Are they losing their jobs? Are they like me and have literally moved from their home state to a whole nother state and have to deal with all those issues? Confidentiality, dual agency. Again, if I were the king of California, which I'm not, never mind. I would probably ban dual agency, or at least certainly limit it in some ways, because it causes problems. How does someone like Linda, who's the epitome of professionalism, but how does even someone like Linda represent two parties equally who may have adverse interests? Always a complicated issue. The number one reason you're going to get sued is if you're a dual agent. So you want to think about those kinds of things. Next, I think this is the last slide, Linda. What issues are going to cause difficulty? There's a whole new form that we're going to show you today, because everybody has recognized that tenancy issues can be critical. And because the landlord doesn't have the same control that they used to, you've got to deal with evictions. And we're going to show you a new form. It's actually not a form as much as it is an addendum. And whenever we talk today, Linda or I are going to use the word addendums periodically. An addendum is actually a modification of the contract. So you have the basic 15-page contract plus 1 page for brokers, and then you have an addendum. You've just added, in this case, 2 pages to the contract that are different than what's in the body of the contract, and the addendum will control that subject matter. Okay, so I want you guys to understand that addendum is Latin, so lawyers can charge more money, but it basically is a part of the contract. Are there entity issues? you're going to deal, is a buyer or the seller a limited liability company or a family trust or a corporation? Is there going to be an assignment? There's going to be a new signature process. It's much easier now. It's a good change because it's easier now for you to do it there. You may use another form, but you don't have to anymore if you do the things in the contract. So let's move on to the next slide. Again, always, I as a risk manager, I hate it when agents go outside their geographical area of expertise because you don't know perhaps what the local issues. I know I deal with, say, Temecula. Well, Temecula agents moving into your area don't have the same problems in Temecula with point of sale or rent control or relocation fees. What about the unique characteristics of the property that have nothing to do with the form? The age of the house, zoning issues, neighborhood concerns. What's the buyer's intended use? Are you going to have problems where the preliminary title report needs to be looked at more carefully? So those issues are all preliminary to what we're going to talk about today. And if we ever decide to do a really big program, I think these are the issues that we'll want to deal with. And I know we deal with them in our risk management programs. So they're very, very important. Moving on to the next slide, please. And again, you know, protect your commission. If you're not the first buyer's agent that working with these buyers, you need to make sure by calling the other agent, hey, you know, what's going on here? You know, because if they claim that they're the procuring cause, you may be looking at a situation where you do a whole lot of work, incur a whole lot of potential liability, and end up getting no money. There are, like I said, we've talked about dual agency. There are cultural issues, right? California is an incredibly diverse state, which means that people look at things differently, not so much because they're different, which is okay. You know, God is a phenomenal artist. He sewed a quilt together that has many different colors and many different nationalities, and it's called the human race. And so we have many different ways of approaching things, and people are just different. There's no one way anymore like there used to be. We have generational issues today more than we've ever had before. We have elder concerns because many people my age are selling off assets, and you know, of course, some of them aren't as smart as Linda or I, and they don't have the capacity to understand what they're doing any longer. And then, of course, at the very front of everything today is fair housing, and that's not going away. You know, it's always been, it'll pop up whenever an issue comes up in the news, and then it sort of fades away. It isn't fading away any longer, right? In fact, starting on January 1st of 2023, not this coming January, but next year, you're going to have to start taking some additional classes, including one on implied bias. It's going to be mandatory as part of your 45 hours of ongoing education. So again, so much. So let's move on to, I think, where we are. We're here. So yay, you get to hear from Linda now for a bit, and then I'll jump in as she wants, and we'll start talking about the form. So what we've done is we've put the various paragraphs one at a time up on the screen. That's why the PowerPoint is so long. You have the contract, you can read along and make notes as Linda and I speak. Linda?
Yeah, I just want to make sure everybody sees that Laura in the chat did give you the contract we're going to be working from today, and you can download it and use it. I know in the classes I've taught already, a lot of people used a lot of yellow highlighter and making changes, and so they'll remember things where they are and where they've been moved to, because hardly anything's where it was before. So that's one of the main reasons why we have to teach the class, because you'll be able to find things. A lot of you are well familiar with the current contract. This one's going to be a little different, like John laid out, that it is set up differently. Things are in a different place. You won't check or mark anything in the contract beyond page 4. We just, as an overview before we get started in individual paragraphs here, most of the information that would have been on a cover sheet before is going to be in your first 3 or 4 pages. But the most important thing to remind the clients and yourself is don't ignore the rest of the pages, because that's where the meat of the matter is. We're just talking about what the terms are going to be in the first 3-4 pages. So let's get started. Once again, they changed the contract. They're changing the contract. One of the items I've noticed is to bring the contract into this market. A lot of items in the new contract are surrounded around things we're dealing with on a daily basis as realtors. So let's take a look. This is also your joint escrow instructions. I know I'm a working manager and part of the brokerage. What we hear a lot of times from our agents is, oh, we can't get started with anything because we haven't received escrow instructions yet. Well, you're sitting with the escrow instructions in your hand. When you're writing the contract, you are writing the escrow instructions. What comes from escrow is a supplement to the escrow instructions. And if they make a mistake on anything that they type for us, it does say in their paperwork, it reverts back to this document. So when we talk about timing, we're talking about from acceptance of this contract, not waiting for somebody else to do something. And that's very important. A lot of people say, well, we didn't open escrow till this date, so the timing, no, it's never. Just remember, it's never as of when escrow opens, because that's not a date certain. The only date certain would be when there's a meeting of the minds. So all of the contingencies we're talking about today, the timelines we're talking about today, are hinging on when there was a meeting of the minds between the buyer and the seller. It could be on the original contract. It's accepted as written. So that would be the date you would start your time clock. The date that something happens is day 0. Tomorrow would be day 1. So let's look at the contract. Date prepared. That's when you are typing up the contract. It may not get signed for a few days, but that's the date prepared is when you are preparing the contract. This is an offer from, that hasn't changed much. What you want to make sure you do is make sure you have consistency throughout. If they're applying for the loan as John A. Smith, make sure you put John A. Smith on the contract. We get a lot of lenders, and we'll talk about that as we go along. A lot of the changes are going to help our lenders, and we can help the lender, so there's not a delay in funding at the end of the transaction by following what a lot of things we're going to talk about today. So have the name, the person, you may know the person and you use a nickname for that person. Don't use a nickname on the contract. Make sure that the contract is going to match what they're applying for their loan name under. The property area where it is, the address of the property, that all remains the same. If you'll notice, the assessor parcel numbers, that line has been made bigger because sometimes a property that you're selling involves more than one parcel number, and there was no room on the other contract. So they made it a long line. And coincidentally, this week, I had a transaction come across my desk that had 2 parcel numbers. So, because I thought, yeah, it's a lot of space there for parcel numbers, but as it ended up, we could have used that space this week. It was all crunched in. If you'll notice, it says postal or mailing address may be different from city jurisdiction. Buyers advised to investigate, which is a smart thing. I'll give you an example. Diamond Bar didn't become a city for quite some time. And part of Diamond Bar, when it became a city, gobbled up some of Walnut. And in Diamond Bar, people may have a Diamond Bar address with a Walnut zip code. So that would be something that the buyer would want to investigate. And going further, the terms of the purchase are specified below and on the following pages. That's very important. But buyers and sellers, my favorite part, this change was made a few years ago, but I still enjoy it. Buyers and sellers are referred to herein as the parties. Brokers and agents are not parties to this agreement. And I'm glad they kept that in there, because answering questions for your buyers and sellers is the wrong thing to do, risk management wise. If somebody calls you and says, hey, will they reduce the price to X? I don't know. Let me talk to the seller is the answer. Not the seller will never go for that. That's not the correct answer. So I'm glad that's there. We are not party to this agreement. Only the buyers and the sellers are. So moving on, a note was made on this section regarding agency disclosure by the attorneys that attention to your transaction coordinators. A lot of times transaction coordinators are asking for paperwork that's really not required to be given by the other side. And it does state regarding agency disclosure that the agency disclosure that's signed by that company's client necessarily doesn't have to be passed on to the other side. Now, John, I have a question for you on this one. It does state that the buyer's agent is not legally required to give the seller's agent the AD form signed by the buyer. Then it goes on to say seller's agent is not legally obligated to give the buyer's agent the AD form. Now, I understand from the seller's standpoint that the agency disclosure is signed at the time of listing. So it wouldn't be required to be in the buyer's side of the transaction. But doesn't the agency disclosure go along have to be the first document the seller receives when an offer is coming in? So wouldn't they already have the agency disclosure from the buyer and signed by the buyer?
Are you asking me, Linda?
Yes.
I agree with you. I personally, I think that a lot of brokerages handle the whole agency disclosure issue incorrectly. For me, what's the secret? You know, the fact is that there are laws that say you won't get paid. There are regulations from the Department of Real Estate that say that it is a breach of fiduciary duty to not provide these forms. The way I look at it is, and I'm going to quote the attorney for the multiple listing service, Ed Zorn. When he was a broker that had his own office, he would tell his clients, you don't get in a car unless you've filled out an AD form, right? Fill it out and then exchange it as quickly as you possibly can, because it's important that the clients understand who's representing who, because oftentimes they're confused, particularly if it's the same office with different agents.
Correct.
Right. So again, I think the law says that the last date to provide an AD is either when you're taking the listing or when you're writing up and presenting an offer on behalf of the buyer. Okay, but that's the last date. There's nothing that says you can't do it sooner, exchange it quicker, get that stuff out of the way early, because again, what's the seller going to be interested in? Maybe they won't even read the AD, right? What they're interested in is how much and when, and how are you financing it, right? So again, get that surplusage out of the way as quickly as you can. Stop being difficult. If you're one of these people that just doesn't want to do it because it's busy work, just cooperate, get it out of the way.
Got it. Got it. And then the confirmation that changed a few years ago too. I just wanted to point it out, like John just pointed out, that now you can see if it is a dual agency situation, but it's not necessarily you that finds the buyer for your own listing. You can at least identify who the other agent in your company is under your agency. So that was why that area got expanded there. So you put the firm that listed the property and the listing agent's name and then the selling agent's company, and it could never be anything other than a dual agency situation. I couldn't represent a buyer solely and then sell one of our company's listings and they represent seller exclusively. That relationship doesn't exist. It must be dual agency, because they're not talking about the agency, or they're talking about the company, the agency.
Just keep in mind that the broker is actually the owner of and the primary fiduciary, even if the broker has no involvement with that client whatsoever. So everything flows from the broker and the client. So even if in a very, very major case called Hariki, where the brokerage itself had 5,000 agents and the broker probably didn't even know half of her agents, the fact remains is that she was the broker and therefore fiduciary, and that everything flowed from her to her agents, and they are therefore in a combined dual agent relationship. Also want to point out, Linda, that what's nice about this confirmation 2B is that you can use it if there's going to be multiple team members working on a contract, or even if you're cooperating, maybe you've gotten a listing and it's not just a pure referral, but you're going to be working with an agent in another area. Maybe a Century 21 agent, say, for example, in your case, referred you, but she's going to continue to work with you. So again, there could be situations where there are more than one agent working on a transaction for a client. It'll give you this gives you the opportunity to indicate in paragraphs 2B and C that there are more than either different brokerages or different agents. And again, license numbers are critical. And again, if you look at the additional agent form, it's a place on that form. We didn't put it up here, but there's a place on that form for license numbers of additional brokers, additional agents, and the like. So very, very important.
Correct. And you can indicate, and I'm seeing that in our office, we're finding other brokerages are contacting us in our area because they're out of area. Will we share listings? And we've had a number of shared listings with other brokerages approved by the broker, of course, but we're seeing that. So more than one brokerage, now that is 2C, more than one brokerage, you check the blocks, representing the seller or the buyer. And when there is a form that has to be used with the contract, it's going to indicate the code for the form, and the form would be here ABA, additional brokerage acknowledgement. And since we just started this, we're going to tell you, they tried to name the forms and put the code as to represent what it does, but sometimes there's a crossover. So some forms get a little bit different code than others. And you think, why didn't it have that code? Well, another form maybe got that code. So just be aware of that. And when you're looking at the purchase contract, anything that comes pre-checked, that document will be in the bundle in zip forms. So your potentially competing buyers and sellers is still there and it's already checked. So when you pull up a purchase contract in zip forms, you will see this document attached behind the agency disclosure. And then anything you check when you're using zip forms, if anything you check, it requires a document, zip form will automatically load it. And I will say this, and I talk about this in all my classes, and I've talked to the zip form people. I feel one of my pet peeves is that I get contracts in that I'm looking at and it has something written, printed, and then somebody writes something on a line, but they don't check the block. So what is it? Like the attorneys explained to us when we discussed it, is if you don't check the block, are you really meaning to make that change? Checking the block is like raising your hand and saying, hey, look over here. We want something to be changed. So make sure if you're writing something on a line and there's a block in front of it, check the block. Now, my issue with zip forms, I feel, is if we are required to check a block when something's placed on a line, why, when someone places something on the line, doesn't the block automatically get checked? So I'm still working with them about it. They all agree with me when we talk about it, but the change never comes. So I'm trying to help you out to remind you to click the block when you're putting something on a line and you want to make a change on behalf of the clients. Another favorite thing of mine on page 1 is this form is 16 pages. The parties are advised to read all 16 pages. And I'll just upfront tell you what we're adopting in our office is when we are going to electronically send any document for signatures, we're trying to have the agents email the document first, keep the copy of the email in our file, and tell the client, I'm going to be sending you these documents for e-signature, either for your initials or signature. But tell them, please read the documents. Ask me any questions. I will be on the phone with you while you electronically sign and explain to you what you're signing, and do it. And that's coming from the risk management side, and keep all this documentation in your file. John?
I had a conversation with the Department of Real Estate because this issue comes up all the time where a client will complain to the department, hey, my agent never explained anything to me. And they told me that once they get copies of your file, they can actually, if you use DocuSign, they can actually measure the amount of time between when you send a document for signature and when you got it back. And if that time period is measured in a very short span, they know you didn't go over those documents with your client. And frankly, DocuSign allows for incredible expediency, and that's a good thing. But somewhere along the line, you cannot abdicate your responsibility to go over this document. This is a 16-page form, and there may be addendums that substantially add to that. If there's a tenant, there's going to be another 2 pages. If there's a sale of a buyer property, there's going to be another couple of pages. So it conceivably could be 20, 25 pages. If you send those out and get them back without going over them, you're potentially going to be in trouble in the civil courts, code of ethics, and before the Department of Real Estate. Laura, I know you're there, and I'm going to cop to a mistake that I made. So here it is. Can you go forward 2 slides? Because I put the PRBS form in the wrong place. There we go. This is the form Linda's talking about. You're a fiduciary to at least one side of the transaction, maybe both. And I know that lawyers, we have to send out what we call a conflict of interest letter to our clients whenever we have a potential conflict of interest. This is your conflict of interest letter, right? This tells your client, your seller and or your buyer, hey, you know what? We may represent multiple buyers in our office. Linda comes from a good size office. It's conceivable that multiple buyers could be represented looking at the same house. It could be conceivable that there are multiple sellers. Maybe you have a listing that's in a certain tract and another agent, or you have another listing in the same tract where you're trying to sell both properties, and your sellers are literally competing against each other, which is a conflict. Dual agency, the mother of all conflict, is referenced in this form, as you can see. And then again, a common misconception is that, hey, my offer is going to be confidential. No, it's not. No, it's not. In fact, it's probably going to be used to up the purchase price in many cases. So this is your conflict of interest letter. It is going to be, as Linda said, bundled. And I want you to read it, or don't, and make sure you keep a lawyer's number handy. You're going to need that lawyer at some juncture, but read it over. And this way, if your client has questions about, who you're representing and all that, you can point them to this form. It's an excellent form. It is bundled, so you're going to use it. But I want you to make sure that you understand what's in it, because it's a good, thorough explanation by some very fine lawyers at CAR. And it is your conflict of interest letter. CAR did that for you. So now, Laura, if you could go back 1 slide to where Linda left off, that would be just groovy. And as you can see on the very top, it says what Linda just said. It says that the parties are advised to read all 16 pages.
And
right?
guess what? It says it again above the buyer's signature.
That's exactly correct. It says it in 2 separate places. So, ladies and gentlemen, I'm going to allow Linda the joy of introducing you to the grid. Here it is. This is the grid. This is what's causing all the controversy. I think it's the smartest thing CAR has done in a very long time, and they do a lot of smart things.
Agree. So look at the grid. The top tells you the paragraph number that is going to be referred to. In other words, when we talk about a topic, let's start with the purchase price. If you go to paragraph 5, it's going to explain about the purchase price. Remember, that used to be on page 1 up above. The purchase price, and then all the terms would follow. So the grid is going to combine everything and put all the details that the seller wants to know when an offer is presented. So the paragraph, title, and contract term would be, in this case, we're just looking at line 1, the purchase price. Then the terms and conditions. So what is the purchase price? And or additional terms. If it's an all cash offer, remember, all cash offer used to be a paragraph on the page one of the contract. Well, if you go to paragraph number 5, there's where your paragraph is going to appear, talking about when the cash has to be proven and so on, either with the offer or there's a delay, maybe a 3-day delay. So you're not seeing all the terms mixed up in the grid. You're just asking, they're asking, what does the buyer want to pay for the property? And then refer to that. We're going to look at all those paragraphs today as well. So once again, purchase price goes in the first section of the grid. And then when you're referring to, for example, say your seller wants to counter the purchase price. Rather than just say a whole paragraph about the purchase price, you could just merely say 3A, 2B, X amount of dollars. And then you could do that throughout the contract. And we've kind of had that practice in our office for years now, because if you start rewriting the paragraphs from the contract, you're taking away the legal protection. So just refer to a section if you want to change a timing or an amount, rather than you rewrite what you think the attorneys meant by the contract. Hopefully that's helpful advice to you. So when you're referring to purchase price, you could simply say 3A, 2B and the price that you want it to be.
So today, our little hypothetical, you're going to write in the words $800,000 right there. And if it's all cash, you're going to check off. And remember, I actually talked to the guy who's drafted this, primarily responsibility for drafting this contract. His name is Neil Kalin, an absolutely brilliant lawyer. And I asked him one time, what is cash? Because, a lot of people think, well, I'm going to pay cash for the house as soon as my escrow closes on property number 1. Or I have cash in my pension account. I'm going to pull it out, borrow money from myself, basically, and I'm going to pay all cash. That's not cash. Cash means cash. Laura has $800,000 plus her closing costs in the bank right now, right? Period, end of story. And as we'll see in a few minutes, she's going to send a letter or a proof with this offer to the seller saying, here's the Bank of Diamond Bar, and I have $800,000 in it, and here's my proof. So again, cash means I got the money today, right? If you've already sold your house and you put the money into an account and then make an all cash offer, that's fine. That is all cash. But if there's a contingency still to be met where the property has to be sold, that is not cash. And Linda's going to show you later where you can put that, but it's not here. The next paragraph, close of escrow, and I guess Linda, you and I can go every other one.
Sure.
I'm hoping you end up with increased deposit.
I'll do it.
Close of escrow, they made a nice change here. Instead of defaulting to a date, 90% of you put in the days, 45 days after acceptance. And as Linda mentioned, day 1 is the day after acceptance. So if you reach an agreement today where all signatures have been provided from the buyers, and now it's being presented to the listing agent, that is day 0, the next day, and the sellers have signed everything, all counteroffers, all addendums. That's day 0, next day. So let's say today we reach that agreement. We have a contract. We're ready to go. Tomorrow is day 1. And so everything is counted from that. And so that's where you would put, say, pick a number, 45 days after acceptance, okay? If you are aware of the date of closing, which is more rare, or you've rewritten the whole darn thing because you've had so many counteroffers, now you can put in a date. Just make sure it's not a Saturday, Sunday, or a holiday. But they made that change. I think it's a good one. And so that's there now. And then, of course, expiration. Linda, you can mention what's going on there.
I wanted to say that sometimes there needs to be a date if someone is in their property for 2 years and they're coming up on the 2nd year and they can't close any sooner than a particular date. There is conversations when buyers and sellers are negotiating that it may have to be after a certain date for capital gains purposes. So that's where I see dates usually. If it's one buyer, whether it's a 1031 exchange, whatever the case may be, other issues with close of escrow may play in, and that's why they left the date in there.
And the good news is I found out on Friday, because I did a program with the lobbyists, the federal lobbyists, that that's not going to change in the foreseeable future.
Hey,
There was some debate and some argument about changing 1031s and 1034s and steps up in basis, and all that's been, it's still a danger. It's still out there. You still got to be vigilant and write checks to your lobbyists so that you can get good representation. But as of right now, NAR has beaten all that back, so you're in good shape. So expiration, Linda, what's going on there?
Expiration of offer. Remember, this used to be above the buyer's signature on page 9 of your contract. Now it's page 1. And this is important because it does revert to, like the current contract does, 3 calendar days after buyer's signatures or a particular time and date. Now it's 5 o'clock, back to 5 o'clock, but you can put a later date or a sooner date. The issue with the expiration of the offer is, in the past, we have put upon presentation, and the attorneys didn't like that. So now you have to give the seller time to consider the offer, and that's fine. But a lot of times my agents will say, well, my buyer wants me to write 3 offers on 3 different properties. Well, there's 2 caveats to that. They can write 3 offers, that's fine. But in each offer, they have to put under additional terms that the seller is aware buyer's making multiple offers on several properties. So that's going to eliminate your offer pretty much, because the seller's not going to take the buyer seriously. So how you can fix that, and we've talked about this at CAR, is put a sooner time that the seller can respond to the buyer's offer. So give them 24 hours and then tell the buyer, hold off. If they don't respond within 24 hours, you can make the offer on the second property you're interested in. Doesn't mean that this first seller may not come back a week or 2 later and say, hey, do you want to renegotiate? There would be a possibility of that. But if you are working with a buyer and they want you to make multiple offers, be very, very clear with them. If they can only buy 1 property, they may be putting themselves in legal danger. And do you agree with John?
Yeah, Linda, it's one of the reasons why I'm so excited whenever I get to carry her luggage, because she just has these great tips. Well, one thing also, don't forget, there's a form. If for some reason you want to withdraw that offer before it's accepted, there's a form for that. CAR has put that in your bank of forms. And to my knowledge, it's not being modified, so it's still there. And again, you just need to be really, really careful. Bottom line is one of the things that we've been telling people in our risk management programs is slow down a little bit, right? I mean, there's so much to consider today. Don't be in a hurry. You're talking about what probably is one of the largest, if not the largest, transaction in many of your clients' lives. So slow it down a little bit. Make sure you think through some of these issues, because if you're going to make multiple offers, number one, there are ethical issues involved and so forth. Now, as far as the initial deposit, today we said 1%. So again, 1% of $800,000 is what? $8,000, if I'm not mistaken. I can't count it on my fingers, so somebody can double check me, but you're going to provide an $8,000 deposit. You can, in fact, put 1%, and keeping in mind that that's for calculation purposes. It is not necessarily part of the contract, because the $8,000 is the controlling figure. But if there's a counteroffer, then you need to think through, does that mean that the deposit goes up to 1% of that number? Let's say it counters at 900,000, just to make my math easier, right? Does that mean we're going to have a $9,000 deposit? And that money is going to be provided in 3 business days. This is one of the few places in the contract where you don't count Saturday, you don't count Sunday, and you don't count holidays. So it's 3 business days after acceptance, and it is by wire transfer, not electronic transfer, because of all the cyber issues that have been coming up. So, and of course, in all of those places, you can put a different date if you choose. But if you leave it blank, you're going to put in $8,000. You may or may not want to include the 1%. That's your call. And you then will have business days after acceptance. So remember, today's day 0. So tomorrow is Wednesday, right? Today's Tuesday, right? Yeah. So Wednesday, Thursday, the money would be due on Friday. But if day 0 was tomorrow, then you would go all the way to Monday, because Saturday and Sunday are not business days. Okay, so that's how you do your calculation. In talking to a friend of both Linda's and mine yesterday, I firmly believe that putting together a calendar for yourself after you've reached an agreement is a great idea. So you don't have to keep all these, because you've got multiple transactions going on. You got all kinds of things going on. And as we're going to talk about this afternoon, time is of the essence. So again, you got 3 business days after acceptance for your client to, and that's what it's going to say in paragraph 5A1, that your client's going to do the transfer, not you. Not going to go into your trust account under most circumstances. It's going to go directly to escrow. Now, Linda, you get to talk about the increased deposit.
I will, but I want to touch on something real quickly, because they put an or and a block. So if you're putting something on the line, maybe the buyer needs a little more time to put the money in. You would check a block and then put 5 days. If that's agreeable with the seller when the offer is presented, that'll be fine. I will give you a hint. One of our agents, smartly, I think, on day 1, would put a notice to perform on the buyer for their deposit into escrow. And the reason behind that was that your notices to perform can be a minimum of 2 days. It can't go any sooner. It's got to be a minimum. You've got to give someone 2 days when you put them on notice, regardless of when you put them on notice and regardless of what the contract says. So you give a 2-day notice on day 1, 1 and 2 equals 3. And what you can do is advise the seller, if the buyer's money is not, because there's multiple offers and people are offering over full price and they've risked accepting this particular buyer, and then they don't perform on the first thing that they need to perform on day 4, the seller then can authorize a cancellation of the transaction. But you can't, if you wait till day 3 and then put a 2-day notice, you're at day 6 before the seller can move on to another buyer. And who's going to say that buyer's going to wait around? Other buyer's going to wait around for another week. So I think this is a pretty sharp thing that agent was doing. On day 1, she would put a notice to perform. And if the money wasn't in by that 3rd business day, boom, seller had the right to move on to another buyer. Of course, have to fill out the cancellation of contract. But they have the right. John, you want to mention anything?
I think that is a great idea, because again, if you don't, then come day 3, if that money's not there, you need to do a notice to perform, and you've actually given them more time. Exactly. One other thing, Linda, and I just noticed that it says here, within 3 business days after acceptance by wire transfer, or if you were to put 5 days, 5 days is defined in the contract as a calendar day. So if you're gonna want to continue to use business days, you need to put or 5 business days after acceptance.
Right. Or
otherwise,
you could put your extension of time next to the 3 or 5 days.
Right.
And or how you want to put the money in. Some people want to drive a check over to. You could put personal check the block, put personal.
You can. And the bottom line is just be precise and think through. Because if you're making a change to this contract, you got to make the change correctly. So if you're going to put in, it says within 3 business days, that's the default. Okay, that means that's what it is. If you wanted to put 5 business days, if you put or and you write something in, make sure you're consistent with the body of the contract. All right, initial increased deposit. So here's what I'm doing. I've agreed, Linda, that my offer says that I'm going to give you 1%, $8,000, but I will agree to go up to 3% once all contingencies are removed. How do I do that?
Okay, so what you want to pay special attention to is now the form. Currently, the form is called a receipt for increased deposit. And it's going to be named now after the new contract comes out, the delivery of increased deposits. So the code for the form is going to change to DID. And the most important part of this is if there's going to be an increased deposit, regardless of when and regardless of why, make sure that when that money goes into escrow, that receipt is signed. Right now, it's called the receipt for increased deposit. There's going to be a delivery of increased deposit. And the reason behind this is if by chance the seller has a claim against the buyer's deposit, if this receipt for increased deposit now or delivery of the increased deposit is not signed, that document's not signed, the only thing the seller can go after the buyer for is the original $8,000 deposit in this scenario. If the seller can prove damages above the $8,000 and that form is signed, they can go after them for the entire money that's in escrow up to 3%. Is that correct, John?
Yes. Yeah.
Okay. Okay. But the increased deposit, we don't see it very often, but I do know, and I'm going to speak to John legally about this as well. John, if people are in escrows are trying to get the seller, particularly the buyer, wants the seller to stay in an escrow with them. In other words, give them an extension of time and they say, well, I'll make my deposit non-refundable. What we've been told by the state attorneys is do not construct that language yourself. Have an attorney write the language for non-refundable deposits.
If you actually read the section under paragraph, the second column, when you go to that section, it actually says that. It actually says, and personally, I won't do them because you've got to make sure that every dot is connected. If you're dealing in a residential 1 to 4, it's clear that the state legislature wants to make liquidated damages, which is what we're talking about, refundable to the client as long as a default does not occur. And we're going to get into that a little bit later, but
paragraphs, yes.
But the bottom line is that if you're considering any amount to be liquidated damages and you try to play games with the pass-throughs and some other stuff, and I actually work with I worked with an agent in Diamond Bar a couple of years ago where they were trying to figure out how to pass through the money to the buyer. You can do it once contingencies are removed. That's perfectly fine. When I sold my house in California, that's what we did. We said that we wanted a deposit of X%. And once they removed contingencies and we made sure it was on, we gave them a little extra time because it was a little more complicated transaction. But once those contingencies were removed, boom, we got the money. That's perfectly okay. What you can't do though is play games with immediate pass through before default. I saw a comment that said that Attorney Ed, I assume that's Ed Estes, says that all deposits in California are refundable. That's correct to a point. That is not a rule of law. Many deposits are not refundable, but at a certain point in time after certain events occur. So that's the complete statement, is that once I remove contingencies, technically speaking, legally, deposits can be made non-refundable, whether they're passed out or we wait till some other time, cancellation perhaps. But that's the deal. So just be careful about deposits. Are a complicated area. When we get to liquidated damages this afternoon, we'll go over it a little bit deeper, but there's some very specific legal rules in a residential 1 to 4. It's different in commercial, different in vacant land, different in other types of transactions. But if we're talking about our mom and pop 1 to 4, you got to be really careful about playing with deposits. So then loan amounts.
Mm-hmm.
Okay. Okay. Well, today we're borrowing $740,000. And this, if you look at this whole column all the way across, you'll see that it's referenced in the body of the contract at page 5C1. It's going to be, I think we agreed $740,000 first trust deed with an interest rate of fill in the blank, whatever your client's willing to pay, if it goes, because that's important. And again, I know Linda, you and I have had these conversations. Why do I need to fill that in? Well, because if you go to cancel later because you couldn't get the loan, you want to be able to prove you acted in good faith. And I'm going to pick a number, Linda. I don't know what prevailing rates are in California right now, but let's say it's 3.5%. Okay. So if I put 4%, I'm willing to go as high as 4%, and I'm willing to pay so many points, 2 points. And although it does default to 0, I'm going to put in a certain number of points. And if I can't get that loan, then it's clear I acted in good faith and I can cancel and I should be able to get my deposit back. So I'm going to write $740,000 first, 4% interest rate, what, 1 point? I'm picking numbers. I have no idea. Okay. And then you go to the right-hand side. And again, it's what percentage of the purchase price. But keep in mind that if there's a counteroffer that changes the purchase price, that number, you need to be careful about going back and making sure everything lines up correctly. And then again, there's more information there. Am I paying a fixed rate? If I check off a box, will it be adjustable? It defaults to fixed rate. It defaults to buyer paying 0 points or up to 1 point. And then I will do all this within 17 days after acceptance. Linda, that's a big change, isn't it? Because it was 21 days. It is now back to 17. And it defaults to conventional. So if you're having a $740,000 first trust deed, that's conventional. You don't do anything with that last column. You only deal with that depending upon if it's financing other than your standard bank approved financing, FHA, VA. You're going to use some specific other forms for that. You're going to have seller financing. Maybe I own my house free and clear, and I'm going to carry back the first, right? Which is rare, I understand, but it's doable because some people have a portfolio that allows them to do that. And they don't, they're certainly going to get better rates than if they stuck that money in the bank somewhere. So that's something to consider. Very little danger unless properties plummet or you didn't get enough of a down payment. Why? Because I'm in first position. It gets a little more complicated, which this is working out really good for me today, Linda, because you get the tough stuff, right? You get to deal with the secondary financing. So that is, I'm going to take part of that if you don't mind.
Yeah.
It's not fair to you. There's a really complicated legal issue. I'm going to let Linda talk about the numbers and all that.
Yeah.
But if you're doing seller financing on a carryback on a second, let's say that I have $700,000 first, I have a $60,000, and the seller's going to carry back. Oh, pick a number. It doesn't really matter. Any portion of the purchase price. But in second position, the only remedy, the only thing that the seller can do is foreclose on their second. Well, think about that for a second. If you don't have the ability to service the first that's above you, you're going to get wiped out, and you have no right to sue absent fraud on that second trust deed note. Remember, you get a note and a deed of trust. The security gets wiped out in a foreclosure of the first. It is incredibly complicated. I've defended a number of cases over the years where the broker didn't properly advise their client on seller carryback, and when the seller got wiped out, they turned to the broker and sued the broker, claiming you didn't properly advise me. And what's the proper advice? Go talk to a lawyer. Right? Linda DiStefano, as good as she is not qualified to give legal advice, even though she probably knows a lot more than most lawyers, because she doesn't have that little license in her hand that says, I'm a lawyer and I'm going to give you legal advice. So even though it says it in the body of a lot of the forms, put an email together to your client saying, look, this is very complicated. Please, before you agree to accept an offer with seller carryback, go speak to a lawyer for an hour and let them explain to you what is called non-recourse financing. Okay, because it's very, very complicated. With that, Linda, I'll let you go back and talk about how to fill out the blanks and all that.
Want to go back to 3E1 section and the loan amounts. A few things here. When you have an FHA VA loan buyer, there is two forms involved. It's the FVAC form that would have to be sent with the offer. And that form does not allow an FHA VA buyer to waive the appraisal. That form says that the house has to appraise for the amount the buyer's making the offer for. Now, can the buyer offer to pay over appraisal? Yes, they can do that. And there's a section in the contract they can do that. But that form has to go with the offer, FVAC, and it's on the right-hand column. It tells you that. And the HID form, which says get inspections. But I want to go to the current contract states there's an FVA form. Well, that form's going away. The FVA form, after the appraiser gets in there, and if they find that there's issues that FHA VA have to have the seller complete, that would have been on the FVA form. That is now going to be revised in the RR, request for repair. So your FVA form is going to be part of now the request for repair. Request for repair is being updated. So when it comes out, take a look at that. Also, my pet peeve again is we do not get rates. And I've taught this class at another company, and one of the agents says, well, nobody ever puts the rate in there. Well, guess what? That's really putting your client, your agency, and yourself at risk if you are not putting the maximum, and John, as John stated, what the buyer wants to pay for an interest rate. Well, remember, they also have to qualify for that interest rate. They may be willing to pay 10% so they can get the house going in. If they don't qualify for it, now the agent could be liable if you put a buyer in escrow that doesn't qualify for the loan that they're going for. So make sure you're finding out up front before you put your buyer in the car. Find out from the lender, because you may have to write the offer at 10 o'clock on a Saturday night and the lender doesn't answer the phone for you so you can complete the contract. Ask the lender right up front. They've already talked to the buyer. We don't want them to put in what the interest rate is, because a lot of times we get pushback from the other side who are representing buyers when it's our listing. They say, well, it's in the pre-qual letter. No, there may be an interest rate the buyer's being quoted in a pre-qual letter or a pre-approval letter, but that's not the rate they're asking for here. What is the rate that the buyer is willing to pay and can qualify for? And that rate has to be there. And think this, if you're on the listing side of this transaction, you don't counter that. And how we counter it here is buyer to provide what the maximum interest rate terms are prior to the final acceptance of the seller. Why? Because if they're running around looking for, I'll use it, a ridiculous credit, ridiculous amount, excuse me, maybe 2% 30-year fixed loan. And the seller takes themselves off the market because they love the terms other than, you know, the term for the loan, but they love the amount that the buyer is willing to pay for the property. And you allow the terms to be left blank. And on day 17, the buyer says, well, I need to cancel because I can't get that loan I was looking for. Well, explain to the seller why you didn't find out what loan that buyer was looking for up front, instead of on day 17 when all the other buyers have disappeared and you need to put them back on the market. They're not going to have a very happy camper on your hands. So make sure when you're working with a buyer, you find out what the interest rate is, the max interest rate they're willing to pay and can qualify for. And for the seller's sake, what that buyer is looking for. They may judge the offer they want to accept based on what the max interest rate is that all the buyers are willing to pay. And in a fluctuating market, that's an important piece of information. So hopefully I help you there. And most importantly, in this section, it is no longer 21-day contingency. It is 17 days, basically for everything.
Right.
Using contingencies for investigations and returning all the documents and everything, 17 days now. John, did you want to add anything?
Just let's move on to occupancy type, because I think that, again, one thing I want you to take away from, if the seller's carrying back financing, especially if it's secondary financing, or as it's called here, additional financing, you want to make sure to send them to a real estate lawyer to get some advice. Now, occupancy type, very important. Okay, it defaults to primary. I'm moving in. This is going to be my house. And from that statement are many critical issues regarding tenancy and eviction, financing, short pays if that becomes an issue down the road. If it's going to be a secondary home, it's going to be my vacation home. Then you would check off that box. If it's an investment property, and we'll talk a little bit later about the other contract forms you can use, but if it's an investment property, you would check off that box. And then, Lynn, I'll just finish off page 1.
Sure.
Do your arithmetic. Make sure your numbers add up. And the only reason I point that out is I have a paralegal assistant who's been with me for 33 years. She's constantly checking my work, which I appreciate because she's my safety net. And one time in doing something like this, I added it up incorrectly. I forgot a $5,000 deposit. So again, my numbers did not jive. So make sure your numbers jive. And then at the bottom of every page, and ladies and gentlemen, I'm proud to announce we are at the end of page 1. You will initial because we want to make sure that everybody's on the same contract, because sometimes buyers will sign a contract over here, the sellers are signing a contract over there. The contract provides for what lawyers call counterpart signatures, which means the two signatures together equal one contract, even though they're two separate stacks of documents. And we are now, ladies and gentlemen, moving on to page 2.
Well, do you want to take a break now, John? We're almost at 10:30. So
I'm carrying your bags, Linda. You tell me.
hey, how about we take a 10-minute break? We'll see you back here at 20 of 11. And also bring your questions with you. And I'll take a look in the chat and see if anybody put any questions we can address.
We've been answering them. I think we're pretty good. Laura, correct me if I'm wrong, but
There's 2 in there right now.
Okay.
Okay, we'll answer them as soon as we get back.
Okay.
Great. 10 minutes. We'll see you back at around 20 of 11.
Oh.
Hey, John,
Yeah,
there's some interesting questions in the chat that we need to address. If you look at what's the difference between the total final purchase price and the total of the price in 3A, that's a good question. But it's twice, the purchase price is twice on the current contract too. So it's just repeating after deposits and down payments and everything. It's repeating at the top and the bottom what the actual purchase price will be. That would be.
repeat, I'm looking for the question. Okay, the first question I have that we did not answer, because I did answer Enriqueta, I think that's her name. I did answer her question about Attorney Ed said, can hard money loan be we can.
Can you move your chat up? In other words, go down, yeah, keep going on your chat. There's a little bar because there's current questions. The most current question was at 10:26 a.m.
Okay, let me go to 10:26 and I'll find it.
Actually, 10:26, yeah. When shall we use the RPA form? We want to address that.
I don't have that question for some reason. The last one I have is 10:25. I don't go past that.
Huh.
I wonder why I don't have it. I don't know.
Did they send the question directly to you, Linda? Or
Maybe
does it say to everyone? Because if people are sending questions,
to
okay,
everyone.
then John should be able to see it.
Mm-hmm.
Huh.
Who's it from?
Oh, the first one, I like to have a copy of this new form to follow the class.
That's David. I sent that to him.
Thank you. And then when shall we use the new RPA form? We explained that at the beginning, but they may not have been here. Halfang to everyone. Halfang Lee asked that question at 10:26. And then another question, what's the difference between the final purchase price total and the 3A purchase price? There is no difference. They have to match. And then further down, I like this question. It protects the buyer if the interest rates were to increase drastically. The buyer has a cap on the interest rate that they are agreeing to with the purchase contract. That is correct. That is correct. Because
Right.
interest rates fluctuate. And then
You can always modify it in another document, but but that does exactly. And it, it serves that other function, which is it establishes the baseline for your good faith.
correct. Right.
So
And then
the only thing I'm concerned about right now is, me, we just finished page 1. We have 15 pages to go.
yeah, we'll move along.
Okay.
We'll move
I mean,
along.
I think we're doing good,
I think a lot of attention needed to be paid to this first section, where the others we're gonna slide through them. There were more notes on this page 1 from when I took the classes, so I think we'll be okay. This was a good one. My question is same as Gloria's, but also representing the seller. What can we do or counter to the interest rate cap to protect the seller? She says, I have been putting that the buyer to take the best prevailing rate. Well, best prevailing rate should not be used in contracts, because does that mean if the rate jumps up to 25%, the buyer's got to buy if it goes up there? No. Best prevailing rate, it needs to be a number. So we'll answer that.
Okay. All right, we can just go through. You can ask the question, and I'm pretty good at figuring it out. One thing that that there's really no correct answer for is you're going to have that 1 week to 10-day period around the 14th of December where you're going to have offers come in on the old form, then the new form comes out, the new forms come out. So the new forms don't exactly link up with the old form. So, we might want to warn people that they're going to need to strategize how they're going to deal with that. And then December 14th seems to be the day CAR is sticking with right now, although they did change it. So,
Okay, 16th, they said now? Is that?
no, I still have the 14th.
Yeah, that's what I heard, 14th.
But now they're using the word the week of.
Yeah, okay.
So it could be any time that week. Who knows?
I thought.
I mean, they're working their butts off. I know they're trying really hard. It's not that. It's just, it's going to be the week of the 14th. So week after next.
Yeah, your advice was very good, John, for listing agents after the contract is actually in zip forms that everybody should be using, that the seller will not accept anything other than the new form be used.
That's the way we handled it last time when they made the change from passive to active.
I remember.
We said, please write. Well, first of all, if they're using zip, they aren't going to be able to write form contract.
Correct. But people are going to take copies of the old form and try to use it because that's what they're familiar with. And
if somebody writes an offer on Sunday the 13th, you may want to tell them, please rewrite this on. But then again, people need to not use that as an excuse to try and double in and all that. I mean, I'm going to be busy at the end of the year.
Yeah. Hey, and the other question I see in here, which is very important because their numbers are their calculations off. It says you mentioned that you can on day 1 put a notice to perform for the earnest money. Yeah, and then it says, do we still have to wait 2 days after the due date to send out a notice to perform? No, you can send it 2 days prior to the date in the contract. Well, we'll explain that.
I'm glad you already raised the issue. I was going to cover that when we got to the section on notice to perform.
Oh, that's
that you can send any notice to perform 2 days before the due date.
Correct.
Because it's a 2-day notice to perform. It simply means perform on the day that the contract says you're to perform.
Correct.
Because if you wait to the 17th day, you're really giving them 19.
Exactly.
Yeah, so,
Exactly. You
yeah.
can't do any, actually another one too, because it takes the next day that they can cancel. So, yeah. So,
Also, Laura, I think in my haste to get this to you guys, we've been through the next couple of slides, we may be skipping over, just so you know.
Okay.
Just to be, I'll have you do them one at a time. I'll just say skip, 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 and then I'll take full responsibility and blame Linda. But let's move to the next slide and see which one you got. Okay, now that's the one that okay. Yeah, see what I did there is I went and I put each, because I thought that's what we were going to do, but we just covered it in that first. So
Can I skip all these?
yes.
you can skip that. Yeah, there is one I'm going to want you to stop and skip that. They have that, so we can mention that. Okay, skip.
And we should be where we are. There, right there.
There we are. That's where we really are. So
Where we want to pick up. So
Yeah.
John, let's address, it's after 20 of 11. We want to.
let's rock and roll.
So a few questions we want to answer that came in the chat. What's the difference between the purchase price and the total price? There is no difference, just like it is on the current contract. It's up above and down below. It's just a little closer to down below on this contract. And you take into consideration what the earnest money is and what the amount of the loan would be if there is a loan. And those two numbers have to match. Second question that we didn't see was, how do you counter if the contract comes in with no interest rate that the buyer is looking for or is wanting to pay for the property at the max? How do you counter that? How we do it is that if the seller is even doing a multiple counter, we will put the seller, this is not a final, prior to the seller's final acceptance, buyer must supply loan terms from the section in the contract, and we refer back to the section. And then if they don't approve of what, in a current market like this, if they're saying, well, I'm going to go out and look for a 2% 30-year fixed loan, that doesn't exist, the seller wouldn't take themselves off the market for a buyer that's asking for that. So that's kind of how we're handling it. John, do you have any other ideas?
No, I think that's exactly, again, don't be in such a hurry. Look at these contracts and ask yourself, is this a full contract? If you don't include interest rates and points, and then we'll talk about some other things as we move on down the line, it's not a complete offer.
Correct.
First of all, you're doing your buyer a disservice because they're going to have a more difficult time proving that they acted in good faith in terms of cancellation if they can't get the loan that at least is in their mind. And then secondly, from a seller's perspective, as Linda just correctly pointed out, it's not a complete contract. So I would simply send it back saying, look, please resubmit with a complete contract, including whatever additional things that you need them to add in it. And if they're not willing to do that, then that essentially acts as a rejection.
John, what we're seeing in the marketplace right now is lenders are coming back and saying you didn't give us a complete contract before we fund. Now we're having delays at close of escrow. I just had a delay the other day and I called it on day one. I saw it in the contract that the address of the listing brokerage was missing from page 10 currently from the current contract. Do you know they delayed funding because they didn't have a complete contract at the lender? So these contracts aren't just being looked at by buyers, sellers, and the agents and brokers. They're being looked at by the lenders and scrutinized, and they are delaying funding. And that's a bad time to have a delay at the end of an escrow, and nobody's happy about it.
To me, not filling out that indicates you're an amateur. I'm sorry. Yeah. Again, it'd be like anything else. You send out a contract with blanks still in it. You send out. To me, that's not a complete contract. The reason that they put that information there is so that you can control the information and the agreement. I mean, if your client's saying, "Look, I have 800 credit. I'm rock solid. I don't want to pay more than X." Right? Then that's the deal. Put it in. If you're willing to fudge a little bit higher, then put it in. If you're representing the seller, although it's not as hot a market from what I'm being told as it was. It's still a pretty hot market, but more importantly, it's ambiguous. You've created an ambiguity to the contract, which if there's an ambiguity and the parties can't agree later what that ambiguity is, guess who gets to pick? The judge. Do you really want that? I mean, is that really something that you want to do? I just think it shows that you were either in a hurry, you don't know what you're doing. Well, that's it. You're in a hurry or you don't know what you're doing, because you really ought to fill that out.
Right. The other question, just so we can move on. The other question was, I mentioned at the beginning of a contract, you can put on day one, a 2-day notice to perform on the buyer to put their money into escrow. And then if they don't put it in by that 3rd business day, the 4th day, the seller can cancel that contract and move on to another buyer that they may have preferred accepting anyway, just to see if these buyers would perform. But the question came in, well, what about other contingency removal? Do we still have to wait 2 days after the due date to send notice to perform? You never have to, and we will address it this afternoon. You never have to wait till something comes up and nobody did it, whether it's seller side or buyer side. It can always be, for example, a 17-day contingency to release all contingencies, 17 days. On day 15, that notice to perform should go out if you have not received that contingency release yet.
Again, it's
using those.
It's right now, the market is such that sellers can be a little more aggressive. If and when the market changes down line and it becomes more of a buyer's market, maybe you don't want to be as aggressive.
Correct.
In terms of, but for right now, what the contract says is you got to give a 2-day notice to remove contingencies. That if the contingencies are to be removed on day 17, then 15 days perfectly acceptable. Same with demand to close. If it's 3 days, you can give that notice on the 3 days. So if you pick 45 days after acceptance, you can give that notice on the 42nd day if your seller is on board with that advice.
Right. And all it says in that form is the seller may cancel or the buyer may cancel. It doesn't says we're canceling you, because that's another form that has to be.
And when we get to that paragraph, we can talk a little about some other issues. So one thing that I don't know if we mentioned, that this is all coming out on December 14th or that week. We don't know exact day yet, but starting on the 14th, don't be surprised if you see this form on Zippy, because, and if you're going to write up an offer a day or two before the 14th, you may want to talk to the listing agent about how you're going to handle, because there's going to be that little uncomfortable transition period where, you know, you may write an offer on, say, the 12th to the 13th, and then the contract changes and all the forms change, and some of the forms aren't going to line up. So maybe you're going to agree, you'll accept the offer, but you'll put it on the new contract and re-execute. And those are things, but that'll only last a few days, and then you'll be back into a normal flow. But just remember, there's always a transition, and there's going to be some things you can control simply by picking up this thing. It's called a telephone. It's a very good device. It does more than just show you pictures of cats climbing ladders, and you can use it to talk to other people. So I would suggest you do that. So we are on
seller credit.
Page 2. We made it. We only got 15 more pages to go. So I'll go back to that one slide we just had up. Please. Where are we going? Where are we?
Seller credit.
There we go. Okay, so this is the paragraph on seller credit, and it could be for closing costs. That's what it defaults to. So again, seller credits are defined in 5E of the contract, and the seller credit, if any, to buyer, that's the title of the paragraph, and you're going to offer, you'd like to have in the original offer, and if the seller agrees, say $3,000, okay, as a seller credit for closing costs. But keep in mind, and you can put in a percentage, again, keeping in mind that whenever you're using the percentage, you've got to make adjustments, because the percentage could be countered with a different number if you get different numbers from the buyer, so, or from the seller, excuse me. Also, be aware of your lenders, if you're aware what your lenders' underwritings are. Because when you get to 5E, we're going to talk about lender allowable credits and contract credits. So they may be different. The other thing you need to remember is that sometime within that next 17-day period, plus or minus, you may get another request for a credit, which could be the repair credit. And you've got to add that. It's not separate. Or you can deal with that up front, but how are you going to handle that? So you need to think, because if you look at the contract body, which we haven't gotten to yet, obviously, we'll get to it sometime on Thursday. No, I'm kidding. But when you get to the body of the contract, it's going to talk about the phrase "unless otherwise agreed," and it's in caps, which means it's a defined term. So if you don't have something in writing saying that, if the lender will not allow whatever number you guys are trying to negotiate, then it defaults to the lender allowable number, and that could hurt the buyer if the buyer's for some reason needs to deal with these credits. And if you go over that lender number, if you agree to seller credits for repairs, you got to deal with that. So those are very practical kinds of issues. How are you going to deal with it if in fact it becomes a problem? Linda, anything to add, or shall we talk about what you would use those additional finance box for?
Yeah, I wouldn't know, because they've now taken what we would normally put in under additional financing terms. They've put it in its own little block on G1. So I think we can move on. How about verification of an all cash offer?
Can I ask a question though? So what I've been told by people like you is that under additional finance terms, let's say you're going to pay all cash, but it's going to be proceeds from the loan, or from a loan from a hard money loan, or it's going to be something like proceeds from the sale of in other words, it has to do with the money you're paying for the purchase price.
Yeah, but that would fall under COP, I would think, under L8.
Okay.
That would involve the buyer sale of a property or something, and those details have to go on the COP form.
Okay, but if it's, let's say I'm going to pay all cash from my pension plan. I had a case once where there's actually ended up being litigation, and then we got the litigation after the fact, and what happened was they were borrowing money from an insurance part of their annuity program, and they were borrowing that money. Well, that's not cash, obviously.
Correct.
That is additional financing, and you need to spell that out, that buyer intends to pay all cash once a loan from, and then if I recall correctly, this is actually, once you click onto it, it's a drop down box. If you need more space, there's a provision there for more space. Now I'm not going to even talk about that because I don't know what the details are to that, but there's apparently a magical person inside cyber world that will give you more space to write out if you need.
Yes, as a matter of fact, yeah, that is the additional terms kicks in. In other words, if you're in section G2, 3G2, and you're typing information like John's stating, it will go on to another form. Now, what you have to remember is zip forms, the way it's set up. If you want to change something on that form, you can't go directly to that form and change it. You have to go back to the purchase contract under 3G2 and go to the form that way.
Okay. All right, let's go to the next slide then, please.
Sure. Verification. Yeah.
Go ahead. Here we go. I love this change, Linda.
Yeah,
go ahead. This is one of the best changes that they put together, I think.
Right. Now, what we're finding in this market is sometimes listing agents, because the sellers are leery about the COVID situation we've been going through, that prior to even seeing the property, and I think some good things are going to come out of the COVID situation rather than the disaster that it caused. But I think some good things that the seller wants to see that the buyers looking at their property are well qualified. And if you're offering a cash deal, they may want to see the cash prior to even getting an appointment to get inside. That is lessening. We're not seeing so much of that anymore, but that was happening. And agents were complaining, but I said, well, I don't think that's all of a bad thing. So verification of all cash, sufficient funds. In other words, not only the amount of what they're offering, but also closing cost. You have to consider they have to have enough money for closing costs, but in their name is very important as well. Because, yeah, if it's coming in somebody else's name, that has to be addressed. Perhaps, John, under additional financing terms. That would be a reason to use that. So attached to the offer, or which it should be attached to the offer, or maybe there's a delay in the buyer getting their proof from somewhere. Maybe it's a court case settling or something. They may need additional time. You would check the block if it's 3 days that's needed, or add an amount of days that would be needed. That's a really great section now.
You're not going to use all three of these, obviously, because if it's all cash, you're not going to verify your down payment or closing costs. You're going to verify all cash. And currently, the contract provides that you'll attach it to the offer. So that's not a significant change. However, in verification of down payment and closing costs and verification of loan app, which would go together if financing is involved, they did make a change, because under the current contract, it says letter attached and you check it off. Now it's defaults to letter attached. Yeah. So you will verify, so you will send your offer. And now when the change on December 14th, you will also attach to the offer the proof of the verification of down payment and closing costs, unless you don't have it because you're behind the 8 ball in some way. And then you'll put in or 3 or so many days after acceptance. And remember, they're calendar days, not. And so if the day falls on a Saturday, Sunday, or holiday, you go to the next day.
Correct. So
verification of loan app, they made a really nice change. Yes. And Linda, you can talk about it, but sure. What kind of loan application? Is it a pre-qual, a pre-approval, or a fully underwritten pre-approval? Right? Again, unlike the current contract, which lets you do it 3 days later, this one says you will attach it. So you will already have pre-approved your buyers in some fashion, unless you haven't done that yet, in which case you would check off the box and fill in the days. But you will also tell your seller what type of qualification you're attaching. So I'm attaching my verification of down payment. I'm attaching my verification of loan application, which means I've already applied for the loan. Doesn't mean I'm going to get it. Just means that my credit looks good, and it's a reasonable amount. Keeping in mind, and this is something I know, Linda, you've seen, and I know I've seen, where it just means as of today, this person will qualify subject to all of these contingencies. The property will appraise, and so forth and so on. And it also means you don't lose your job, you don't file bankruptcy, you don't go out and buy a couple of SUVs to change your credit score. You keep things the way they are, and then you check off the type of pre-approval. And I think that's a very valuable piece of information for a seller to have right away.
Correct. And the seller may judge, pre-qualification can just be a letter that they talked on the phone. Pre-approval is usually credits run. They've seen all the 2 years of the tax returns. They've seen pay stubs. They've seen pretty much everything. They've run the credit. But the fully underwritten pre-approval, I understand that to be what they're asking for in listings is the DU, the desktop underwriting. So I think that's great options that you can check, and it's good information for the seller to know how far along in this pre-qual process is this buyer. So know if you're representing the buyers, get this process moved along. So when you write the offer, it'll look better to the seller.
I look at it kind of like when people go shopping for a car, they may go to their bank and the bank will say, you can buy a car up to this amount with so much down payment. In other words, instead of all of the contingencies, we've narrowed it down to just a few things that could screw up the deal, but most of the time you're going to have it okay. So I really like this change. Again, it's all explained in 5B, 6A, and 6B, which we will get to on Thursday. No, I'm kidding. We'll get to it this afternoon. Okay, moving on to the next slide, please.
Final verification of condition. That's buried in the contract now, but it's right here in the grid for you 5 days prior to close. And people ask me all the time when I'm training, why 5 days? Well, the thought process behind that is usually loan docs get to escrow 5, 4, 3 days before the scheduled close, usually around 5. And usually the buyer doesn't want to go ahead and sign their life away on loan documents until they've seen the property again and seen that the seller has made repairs. So we'll talk about this further on in the contract as well in paragraph 16, but that's the thought process behind it. We don't see this change very much. So
No, and the bottom line here is it also allows, in case there are repairs that need to be made, maybe when the inspection was done, there was furniture in the house and now it's been moved. I mean, there's a lot of good reasons.
a lot of reasons, yeah.
When we get to the form, again, like Linda mentioned, it's buried and it's always been buried. It still is in paragraph. Now it's paragraph 16. I think that's a new number, but still pretty deep into the contract because there's 32 paragraphs. So, and even further buried is 23, but that's a significant change.
Yes, Ron, you want to address that because that's law.
So here's the scenario. It can come up in one of a couple of ways. The ways I've seen them typically is I have entered into this transaction and I am buying it under the name John V. Giardinelli. But my accountant says, no, you need to put it in the name of your family trust immediately, or you need to put it in an LLC. Or I've decided, I'm thinking about, I want to buy this house, I want to make the offer, but I'm going to bring in Linda DiStefano to co-own it with me. We're going to be a tenant in common. And so I want to assign my rights partially before we close escrow for financing or other reasons to Linda. That's called an assignment. And the significant two changes are this. Number one, right here, you're going to do that within the first 17 days. It does not say that in your current contract. So technically speaking, you could do it anytime. And the later you do it, the more confusion it causes. This is not a big deal if I'm going to sign it to my family trust, right? There's no significant change other than the name of the purchaser. The other significant change is when we get to it, we're going to show you it's called a revised form because there already is an assignment form, but this one is so revised that it's, for all intents and purposes, Linda, I don't know if you agree. To me, it seems like a brand new form. Okay, so we're going to show you that form later. I don't know exactly when because there's 100 pages of stuff here, so I don't remember where I put it, but it's here. You can trust me, I'm a lawyer, it's here. All right, so those are the two in this section of the matrix. Anything else, Linda, you wanted to add, or are we going to the next one?
We're going on.
So here we go to the next section of the matrix.
Right, and if you notice in the dark block above this section of the grid, it's talking about contingencies now and time to remove the contingencies and contingency removed. So that's the lines going across. So
all together.
3L1, and it's discussed in paragraph 8A, the loan. And look, it's 17 days now. Remember, in the current contract, it's 21. So now it has been reduced to 17, or the buyer can ask for more time or less time as they write the contract on the or, days after acceptance, or they come in with no loan contingency at all. That's a scary thing. I don't know that I would recommend any buyer. And I think if we get to paragraph 8A, you're going to see that it's against the advice of a agent or a broker to remove loan contingencies when you're getting a loan. John, do you want me to talk about CAR put out some guides, and it's about releasing contingencies.
I love what you do. I think I've actually stolen your idea, and I tell other clients that, look, if you're going to waive contingency, any contingency, particularly a loan or an appraisal contingency, you need to put something in writing. And CAR does have a quick guide for contingency removals and waiving contingencies, and you really need to do that. I think, this is not for today's class, so if we do a risk management next year, we'll talk about it, but I think this is going to lead to some serious litigation. I was talking to Otto Katrina Laura had him at a retreat recently, and Otto's the new president of CAR. And I don't know where he got the statistic, but he said that they're showing that about 43% of people that are buying property right now are dissatisfied with their purchase. Now, even if that number is half, that means 1 in 5 buyers are not happy. And when people are not happy in California, what do? They sue. And so I think that's going to be a big issue. As far as appraisal contingencies, I don't know, Linda. I've been a lawyer for 44 years, starting in 2 weeks. 2 weeks, my anniversary. Red's my favorite color, and I wear extra large. So if anybody's looking to send me something. But now I think that but I cannot think of a circumstance under which, even if you're not getting a loan, even if you're paying all cash, I think, or you're not making it a loan contingency, you don't want to waive the appraisal contingency ever. There may be circumstances, maybe you're going to tear the place down and you don't care, but it's really got to be rare. So the appraisal contingency is based on the appraised value at a minimum of the purchase price, or, now here's what I want you to listen. This is a bit of an ambiguity. It wasn't meant to be, and it'll probably get fixed down the line. But let's say your buyer is willing to go a little bit under the appraised value. So the appraised value comes in and it's not the purchase price. It appraises at, oh, pick a number, 780,000. Okay. So you write 780 in there. Now what that means is your buyer is going to kick in another $20,000 in order to get this property. Could be more, could be less. The numbers are relevant to this conversation. However, what you need to remember is if there's a counter offer, you've got to make sure that you account for this number in a later document, because if I say I'm willing to go to $780,000 and the counter offer is at $850, you now are no longer kicking in $20,000. You may be kicking in $70,000. So you need to account for that. You need to think about how you're going to deal with that. And then you're going to remove this contingency 17 days after acceptance, like all the others. And then they've highlighted the fact that removal of appraisal contingencies does not eliminate appraisal cancellation rights in the government type loans, okay, the FEAC. And it says that there. So, and in the body of the document, 8A and 8B, it makes it crystal clear that the removal of the loan contingency or wavering does not waive the appraisal. They used to be connected. They've now been completely disconnected. Removing one does not remove the other. Then when we get to the body of appraisal, you're going to see that appraisal is based on certain criteria. Square footage is actually moved over into another, bless you, it moved over into another part of the contract. So there's a lot going on here. But from a legal standpoint, if you're going to remove an appraisal contingency, or you're going to be willing to pay a price lower than what the appraisal comes out at, which is probably fairly common, I would imagine, Linda, with all the up bidding that's going on, that you better be very precise, because you could get stuck in some type of a breach claim totally innocently, simply by not understanding what you're doing here. So that's a little bit of a ambiguity there, because if you put a number, you've got to take into consideration there may be a counter number, and that counter number then has to jive up with what if your client's willing to kick in 20 grand over and above, that's fine, because the lender's not going to be willing to lend on a number other than the appraised price, I would imagine. Therefore, if the counter goes higher, you better be dealing with it, because that's a lot of extra cash you're going to have to come up with. So just now, what do you think about investigation, Linda?
Well, investigation of the property, once again, it's 17 days. Informational access to the property is again 17 days. And then it states that the buyer's right to access the property for informational purposes only is not a contingency and does not create additional cancellation rights for the buyer. So that's an interesting statement there, but removal or waiver of contingencies. And once again, these documents that were created by CAR, these guides are very, very helpful. Let me go back to real quickly the appraisal or releasing any contingency because they tie in to one another on the guide. What we've done, we personalized the guides to our company and actually put signature and date lines down the bottom of the form. It's an idea for you brokers out there. And we use these when we list the property. The seller must understand them, read them. And it's not only the contingency removal we put out, we put the escalation clause also. And what an escalation clause guide is, the guide explains that somebody will say, a buyer will say, I'm going to pay $1,000 over your highest offer that you've received, Mr. Seller. Of course, the seller would have to show proof of that offer coming in at a certain price. But there's dangers there as well, which tie in with appraisal. So it addresses all these issues because we're trying to prepare our sellers for what offers may be coming in that are constantly coming in on our offer on our listings, removal contingencies, whether they be investigation contingencies or appraisal contingencies, and offering higher than the highest offer that the sellers received, just so they can get in there and get that property. So be very careful. We've put it in writing, and then we require as part of our disclosures that the buyer read it and sign it as well. So hopefully that helps us.
Let me just touch real briefly on something that comes up all the time. And I don't know if we have any questions. We don't, but let me touch briefly on something. I hear it all the time. And again, I sit on the dark side of the force. I don't get calls telling me, hey, John, just want to let you know, I just did 5 deals and they all were easy and no problems, right? I don't get those calls. I get the, oh my gosh, where people are talking about suing calls, or we have a problem call. And an issue comes up all the time. People don't understand, what is a contingency? It's a word. What does it mean? And so real quickly, it's actually a legal term. And the contingency is so you're going to put a deposit in, right? And you're probably going to initial the liquidated damages clause, which means that the seller gets to keep the deposit if the buyer defaults by not closing on time or canceling for an unapproved reason or something like that. So the reason that contingencies are important is it prevents the buyer from defaulting on the transaction, because a contingency, if you think about it as a condition precedent to the duty to perform, right? I have a contingency that says the property will appraise at the minimum of the purchase price. That's my contingency. Okay, I have 9, but that's one of them. If the property comes back at less than the purchase price and I cancel, I never defaulted on the transaction, because the condition preceding to my obligation to move forward was that the property appraised. Since it did not, and since I'm not willing to waive that contingency, then I should be able to get my deposit back so long as I act in good faith. Right? And that's really all that it means. It has to do, all this work and all these arguments have to do with the deposit. Because if I've removed the contingency and the property doesn't appraise, or if I remove the loan contingency and for some reason my loan falls through, or any of these other contingencies, the biggest one in my view is the investigation of the property, because that's where a lot of the arguments are. People discover things that the seller's not willing to repair. I get my deposit back, period. That's all. Okay, that's all that it means. And so it's a condition preceding, but there's that box, you can see it off to the right, where it says removal or waiver of contingency. It applies to, although it's really attached to the investigation and all of that, it really has to do with every contingency. And it says any contingency may be removed or waived by checking the applicable box above or attaching the contingency removal, which is the CR form, and checking the applicable box. Removal or waiver at the time of the offer is against the agent's advice. So here's where it gets a little complicated. Linda just mentioned the fact that her firm sends out these quick guides and basically explains, hey, buyer, you've told me you're willing to waive contingencies. So here's why I think that's a bad idea. But that's not what's really happening, Linda. You know that, and I know that. What's really happening is agents are saying to their buyer, if you want this property, you'll waive contingencies, which defeats the purpose of what CAR has done to try and protect you. Right. And so you better be thinking through, and this is not the class for today. That's like I said, we talk about that in risk management, but you better think through how you're going to deal with that. If you're telling your buyer, maybe it's true, maybe you're not going to get the house. The seller is saying, I don't want contingencies. That's basically the San Francisco model. If you're doing that, then you better have something in your file clearly explaining that this was the buyer's ultimate act, and this is why you made that recommendation, because that language is not going to help you. And again, and we're going to show the form to you in a minute, but the CR is the contingency removal form, and it again is a form you have to work through. It does not automatically, you got to check off boxes. But then there's also the review of seller documents, and you got 17 days now. They've added, thank you. They've added in these next 4 boxes what I think, Linda, is a really good change, because I don't have control. Maybe the seller doesn't really have control over some of the documents they have to send out. Maybe the preliminary title report is delayed. I personally never had that call, but you probably have. Maybe the HOA management company is dragging its feet, or maybe the company that leases the solar or something like that is dragging its feet. So what they've done on all 4 of these is they've said it's 17 days after acceptance or 5 days after receipt, whichever is later. So if you get documents on the 19th day, 19 plus 5 is 24. Last time I went to high school. And therefore, that's how much time you'll have, because again, they're trying to take into context the fact the seller isn't always the one dragging their feet, right? And so I think personally think that was a good change to help the deals go through. So they've made that change, and it's defaults to 17 days because they wanted to keep everything consistent, and that applies to all 4 of those boxes. I don't know if you have anything else to add, because I want to.
Nope. Let's move on to sale of the buyer's property. The COP.
You handle that one.
Yes, the COP form has changed drastically. It's gotten more involved, more details, but the bottom line here is, if there is a contingency for the buyer to sell a property in order to purchase the property, the block has to be checked. And if you're using zip forms and you don't have in your template the COP form would load. But I would, if you're working with a buyer with a contingency, please take a look at that form in detail. Lots going on there. We will address it in 8J, but I just want to say that when the seller's taking their property off the market, and it's rare in this market if they'll accept a contingency, but I've seen some who do a contingency for the buyer, the seller needs to be told, have you even started marketing the property yet? Or if you've started marketing the property, where is it listed? And the selling agent and listing agent have to do their homework. They have to see if maybe that buyer put that property in the multiple listing at a high price that it's never going to sell. Now they're asking a seller to take their house off the market so they can wait for the property to sell, and they'll still be waiting next Christmas for the property to sell because it's overpriced. So listing agents, do the comparable sales on that contingency and make sure that the people aren't kind of crazy out there. But also, probably the best scenario would be on the COP form that the buyer says, no, we're already in escrow and we're going to close at a particular date. Now, there's other items in that COP form that have to be addressed. Can the seller, if they get a better offer, can they cancel the contingent offer, and all those details? a buyer would go in and say, no, you can't come, check the block. No, you can't cancel me at all at any time. Sometimes the seller will say, well, I won't up to 17 days, and then you release the contingency by then. And there's so many different variables in that form. So you have to read the entire form, see what the buyer is willing to offer to the seller, and see what the seller is willing to accept. But it also states that if you are in an escrow, and if for any reason it falls out of escrow, the seller has an immediate right to cancel and move on to another buyer. So read the form. It's gotten more detailed because it was just touching the surface of what could go on in the past. Now it's very detailed. And I don't know that we won't soon get into a market where there'll be contingencies for the buyer to sell something in order to buy. So
when my wife and I sold our house in California, we sold it before we didn't make any contingency because we simply thought it would complicate the transactions too much. Two things on that. Number one, it defaults to no contingency. So if you are going to have a contingency, you have to check off that box where it says CAR form COP. And that form is an addendum. It is not just a form. It actually modifies and will control the conversation. So listen to what Linda had to say. You need to walk through that and ask yourself questions. I did a rant. Laura has, I think, most of the rants posted. I don't know. I'm pretty sure you archive them and so you don't take them down. And so I did a rant. I'm going to do another one because it's over a year old. And frankly, I've learned new things and I've heard new war stories and horror stories. And so I'm going to do another rant sometime early quarter of next year. I haven't scheduled anything yet. So I'll be told when, but I'm going to do another rant on the COP because I think it's so I think next to the new TOPA form, probably those are the two. I don't know, Linda, if you agree. I think they're the two most complicated forms that you guys have to deal with. Correct. Never be afraid to call a Linda or whoever is Linda in your world to get some help, because particularly if you're newer, because these are not easy things to deal with.
Yeah.
All right.
Talk about time of possession. And you
let's move on to the next slide, please.
Yep.
Can I say something? Oh no, before we do that, I put up, this is the contingency removal form. And you can see that back in in last year, they made some pretty significant changes to this form. They've, as you can look at number 2, paragraph 2, they've broken out a lot of the contingencies in terms of, for example, the buyer's investigation. There's different phases of investigation. So we're not going to spend a lot of time on this form unless Linda wants to, but remember, we're removing the condition preceding to the buyer's obligation to perform. This can be done now. It can be done 17 days from now. It can be done whenever the seller demands that it be done. There's no date. It can be done more than once. You can see that it's numbered. You can remove some contingencies. You can remove certain contingencies, or you can remove all contingencies. It doesn't matter. Again, go through this form. It's a really well done form, and just figure out, don't be checking off multiple boxes without knowing what you're doing. I've seen that. It amazes me. It actually sent me on a trip to Europe one time. Make sure you think through and check off the right box. I'm removing the loan contingency because my loan's been secured. The appraisal's in, we're good. I'm removing that one. We've investigated the property. It's great. We don't care. We'll fix these things. Whatever it is, check off the correct box. Or if it's a specific doc one, or again, we're removing all contingencies because we've done our due diligence and we're happy and we're ready to proceed toward closing. So, and then there's a place for the seller to remove its contingency, because Linda, there is a seller contingency. Maybe the seller has to find replacement property. And so the seller can use this form to remove at the appropriate time their contingency, or there may be a special contingency. And so they can use this form on the bottom for that purpose as well. It's a one-page form.
Right.
and you want to make sure you document it carefully. And again, it can be used more than once. So now we can move on to the next
And
slide.
there's some confusion sometimes, John, I see in our transactions. Somebody will send over a contingency release and require our seller sign the bottom of that form. That form does not get signed by the seller. That is only to be signed by the seller if they're removing a contingency that they have in the transaction. That's not a form that the seller has to sign. Contingency removal is just signed by the buyer or the seller, depending on removing contingencies.
Well, I love being your caddy. So here's the deal on possession, and then I'm going to let Linda talk about it. A couple of things, background information. Number one, when I buy real estate, I'm buying two things. I'm buying title, however that's going to be held. I'm either buying it in my name of my family trust with other people as a husband and wife, but I'm buying title, ownership, the pink slip to the house, right? I'm also buying the right to possess that house. That right is oftentimes not necessarily the same right. Maybe I'm going to buy title, but I'm not going to take possession for a short period of time. Maybe I'm not going to take possession for a long period of time. Maybe my plan is not to take possession at all. Maybe I'm going to rent the property out, or maybe I'm going to leave it rented out. So again, possession is a whole separate conversation. And because of the pandemic, Linda mentioned before, there have been a lot of good things that came. I'm one of the good things in the sense that the pandemic allowed for remote work, which allowed me to live where I wanted to live, not where I had to live, right? That's a big difference, right? Those are people all over the country are doing that. All my neighbors on this street are all from California. None of them work in Tennessee. They all work in California, except the pilot next door. So it's a great thing. But one bad thing that happened, particularly in terms of transactional law, is we've incredibly complicated tenant occupied property. Incredibly complicated it, to the point where I'm going to recommend to Laura that one of our panels be a panel with a fellow who specializes in landlord tenant. He's an attorney that works up at CAR. We've had him before. I think that it's time we have him again. But anyway, that's the background. And so time of possession is important, because when you're going to do it, maybe the property is still occupied by the seller. Maybe it's vacant, or the biggie, maybe there's a tenant in the property. So Linda, you want to go over some of this, or do you want me to?
No, I'll do it, because I see a lot of issues with this section. A lot of times the agent will put in 4 o'clock, 2 o'clock that the buyer wants the key on close. The reason why it changed from 5 o'clock, which it was for years and years and years, to 6 o'clock on date of close, is because at the recorder of deeds, the title company may be there recording the deed at 5 o'clock. And that's when the window closes, but they need time to get back to their car, to call escrow, to call all the parties in the transaction, so escrow can notify everybody. Escrow needs that extra hour till keys are turned over. Now, escrow doesn't turn keys over, the agents do, but they need to have it confirmed by escrow that it did indeed record. And that's why the extra hour was, escrow actually asked for that extra hour, that they're not getting 100 phone calls on one transaction because they can't, tell the agent, yes, it recorded for sure, because they haven't heard from. So please try not to change that 6 o'clock. It's there for a reason. Or on days after, like John mentioned in the next section, be careful with your lender. The lender may not allow, because of the way you check the block and how you're going to occupy the property. If you're going to occupy the property as your primary residence, the lender a lot of times are not going to allow you to lease back the property to a seller. Because if you notice under additional terms, 3M2, go all the way over to the right-hand side. We require the SIP be formed, and that's permission for the seller to remain in the property. After 29 days, it has to be a lease. So if you're going in, the buyer is going into the lender and saying, hey, I want to buy a property I'm going to live in. Oh, and here's the lease that goes along with my property and my contract. That's contradictory to the lender. Usually they will not allow anybody to stay in the property over the 30 days. Now, we are seeing some lenders are lightening up on that a little bit and allowing 60 days possession for the buyer because sellers are having a hard time finding properties to buy and to lease because of lack of inventory. So do talk to the lender. It is in the paragraph, explained in the paragraph when we get to it further in the contract, but I did want to touch on that. Be specific when the time of possession is, because the time of possession, the seller must keep all utilities on till the time of possession of the buyer. And the time of possession of the buyer is determined right here, not the buyer's going to move in 3 weeks because they're going to put new carpet in first. The seller doesn't have to keep the utilities on for that 3 weeks. Only till the time of possession in the contract of the buyer do all utilities have to remain on, and that is further in the contract as well. But seller occupied or vacant units, John keeps referring to the TOPA form. That is a new form, and it's going to be used with all tenants.
It's actually going to be coming up next.
Good.
A couple of things that are critical is again, I'm a lawyer, so I don't get to see the good stuff, but I will tell you that in the files I've looked at over the years, the SIP form, which has been around a long time, is not included. You guys basically, you got the agents that aren't taking the class today. Okay, what'll happen is you'll agree, it's close +3, close +4. It's fairly standard. I understand that. Right. But what you don't understand or don't take into account is every legal relationship changed on the day of recordation.
Yep.
The seller became an occupant. The buyer became the owner. There's an insurance issue. There are eviction issues. There could be lender related issues, as Linda pointed out. So, and in California, 29 days or less is an occupant. When I rent a hotel room or an Airbnb or something like that, I heard someone, and even in my own office this morning, he's thinking about moving to another place, and he's gonna take an Airbnb for 6 weeks. Well, that's not an Airbnb, that's a lease, right? That's a lease. And so I had to correct him. A good friend of mine, great estate planning, but that was wrong. Okay. So if it's going to be, say, your standard deal, what that, Linda, maybe +4, +5, something like that. So let's say 5 days after close of escrow, you check off that box. That's an occupancy. So you would use the SIP form, which is the seller in possession. It's actually not a lease, it's a license. It's like when I go to a hotel or when I sign on an Airbnb, right? It's different. Getting people out are different. And when you go through that form, and this is frankly, this slide could be a class in and of itself.
That's right.
That when you go through that form, for example, most of you don't charge for the first 4 days. That's okay. Part of the deal. But what happens if I don't leave, right? You ought to make that, there's a place where you could put a pretty hefty number in there.
Right.
A couple $100 a day, taking into account the buyer may now be paying for a mortgage and they're incurring interest and other costs. If it's more than 30 days, then you better be careful and maybe want to speak to a unlawful detainer eviction lawyer about what that means, because I know that during the pandemic, Linda, I've had lots of calls, you probably have too, regarding the issue of the seller refusing to leave. And now there's a moratorium, and how do I deal with all that, right? Yep. So there's all of those issues. The RLAS, which is the residential lease after sale, is almost identical, a couple of minor changes, but almost identical, and will be modified again to take into account the changes in the law that have occurred over the last couple of months and on January 1st. And it is a lease. So now I've gone from a buyer to a landlord. I've gone from a seller to a tenant, right? And there's all sorts of other issues. And then thirdly, and there's a box to check off. So those first two boxes, M1 and M2, deal with the relationship between the seller and the buyer. The third one introduces a whole new person, probably one of the most powerful people in the state of California, the tenant, right? And if checked, you automatically, so I've got a tenant occupied unit, which could be a single family residence. Anything 1 to 4 is what this contract is going to cover. If it's more than that, you're probably going to be using a different form. But so I'm going to check off the box. And now let's show you a form that will be out on sometime in December 14th that week. It's called the TOPA, the Tenant Occupancy Purchase Addendum. This is an addendum. It changes the contract. Let's go to the next slide, please, and introduce these nice folks. Oh, I'm wrong.
That's the SIP.
That's just the license form. I cannot tell you, I would say the majority of files I have looked at over the years do not have this form in it.
And John, the most important phrase or line on this form we found, and over time, it used to be when you closed escrow, the seller would say, oh, well, you know, I'm supposed to be out on Tuesday, but my buddies are coming over to help me move on Sunday, so the buyer can just wait. Well, there's a line right at the top under where it gives the license to stay. And it says, seller, if you don't move when you're supposed to, bottom line is there could be court awarded damages. And it seems ever since they put that line in, we really aren't having that much trouble. But we require this form. If they're staying 10 minutes after close of escrow, we require the SIP form.
And I couldn't agree. I think that's just being, frankly, personally, and again, I don't know this is the standard of care, so any plaintiff's lawyers out there, don't take my deposition and ask me to say something, but the fact is, I personally would not want to use a realtor that didn't know how to use this form if I was a buyer, because again, I'm paying mortgage now if I am, right? Or I'm making plans to move that don't include the Great Western Motel, right? Because all of a sudden I don't have a place to live anymore based on the fact that we've agreed you're out of there in 4 or 5 days. So this form is critically important. It's a form you need to go over with your buyer to point out exactly what his rights are, her rights are, but it also needs to, by those of you that are listing agents, and if you're going to stay and this form is being utilized, that say what Linda just said, that there's some severe penalties written into this contract if you don't move out when you say you're going to. Now let's go to the TOPA form. Well, that's the second page of this SIP. I did not put up the RLAS because it's too bloody long. Okay. Here's a form that is not available yet. It will be out on December 14th, plus or minus. Okay. Tenant occupied property addendum. And again, the tenant to remain in possession is the default, which means very simply that the landlord's being replaced by a new landlord, new sheriff in town, right? And that's important in terms of dealing with, you know, assignments of leases, transfer of deposits, all those kinds of fun things, right? But what if the property is to be delivered vacant? Or what if the tenant, so again, there's a whole section dealing with the fact that the tenant's is going to be removed when? What's the deal? And then how's that going to look? Because you know what? The seller may not be able to do it in 45 days, right? Maybe the seller hasn't given his 60-day notice yet. Maybe the jurisdiction provides for a few, for a whole other situation. You guys are in LA, they got all kinds of laws and moratoriums and stuff like that. What's the deal? Because again, this is a situation that has gotten incredibly complicated, particularly in some jurisdictions in California, where they have additional rights over and above what the rent control laws state. Maybe they have a separate relocation fee that's greater than what California law requires or whatever. And then of course, if the tenant is going to remain in the property, then there's all the pre-printed issues that go along with that. Tenant estoppel certificates and all kinds of cool stuff. So I personally think this is a class in and of itself, Linda. I don't know if you agree. And again, somebody that is, or it could be part of a panel or whatever it's going to be. That's really going to be Laura's call, but it's something that is critically important. There's a guy at CAR named Robert Bloom, who is as good as I've seen. There's also good lawyers, I'm sure, up in that area that can explain all this. Amongst the forms that are coming out in December are going to be, in addition to the forms related to the RPA, are going to be all sorts of COVID and notices to evict and all kinds of other forms coming out over and above the forms coming out relating to the RPA. So I think there's a total of 90, if I'm not mistaken, forms that are being, not just new ones, but revised and stuff.
John, there is a question in the chat and it says, if the tenant is staying a few days after close of escrow, what form would they use? I would say probably this one.
Yeah, I agree. I don't know that there's actually a form for that. It does, again, during the pandemic and in some jurisdictions, it didn't even matter if you signed a cash for keys agreement. The fact is that there was no remedy to get a tenant out if they had COVID related financial issues. It's changed a little bit, like in the Inland Empire, out in Temecula and all that area, and in Orange County, you're okay. I mean, you go back to 1482, which is the rent control law. You figure out if the property is going to be occupied as a primary residence by the buyer, then you can evict that tenant. You pay a relocation fee if it doesn't fit within for cause, and you move on your merry way. But again, it's like a kaleidoscope of issues. Once you got to figure out where you're at in that kaleidoscope, and then do the deep dive and figure out what notices and what forms. And if you're wrong, you start over again. The law is very clear that if the landlord doesn't follow the law, aside from potential damages for quiet use and enjoyment issues, the landlord has to start all over. You could be all the way into the day of trial, and if there's a mistake that's been pointed out, it's conceivable that everything to that point is void and you start from scratch after you write a check for the attorney's fees for the tenant. So again, really, really tough stuff. Really tough stuff. And that's why, again, they've come up with this entirely new form dealing with as many of the issues as we can. One more slide, please, Laura. As you can see, there's a whole second page to it. Even talks about seller, representations and all that. So again, this is a form that's not available to you yet. It comes out. So if you're dealing with it right now, it says simply that the seller will make the property available and could be in breach of contract if they don't make the property available at least 5 days before close of escrow. That's no longer the case. That's gone. That's gone. Okay, and we have this now. All right.
Yes, we're going to make the documents, fees, and compliance section. Seller delivery of the documents. Remember, this was section 14 before. Now it's 14A still, the explanation, but the statement that seller has to deliver all disclosures and documents to the buyer within 7 days of acceptance or another time. Maybe the buyer, and maybe it's going to be a 12, 17, 15-day escrow because it's all cash. You would shorten that a period of time and you would do the or maybe maybe 5 days. Then you go into the sign and return escrow holder general provision, supplemental instructions. That's 5 days, or if more or less time is needed, you put a time that the buyer would like to ask the seller if they would acquiesce to. Time to pay fees for ordering the HOA documents is 3 days. That's the only thing that I can really think of that the seller pays up front. Everything else usually can be billed to the escrow, but up front, prepare your sellers, if it's in a homeowners association, that they have to pay for those documents. How they have to pay varies per association. We see where they'll only accept escrows check. We'll see that they have to go into a portal and put their credit card. We see that they'll only accept the seller's check. It's very different for very different reasons for different homeowners associations, but indeed the seller has to pay that and get those ordered within 3 days. And John, I rarely see HOA docs come in within those 7 days. And technically, what the seller should be doing is asking the buyer for an extension of time if those documents are not ready to be delivered to the buyer within the 7 days. That's technically, according to the contract, what should be going on.
Right, and keep in mind that in the paragraph we just walked through, they give you 5 days from receipt. So the seller is automatically going to give the buyer extra time to remove the contingency if they're not in time.
Right.
Again, seller delivery is 7 days. That's not a big thing. Sign and return. This is, again, if you look all the way to the left where it says paragraph number, this is all over the map. These are things that have been buried in the contract here, there, and everywhere. But now we're telling you, you don't have to fill out any boxes, fill in any blanks, fill in any boxes. You're gonna provide, both parties are gonna provide the escrow holder with their standard instructions within 5 days. Okay, period, end of story. 3 days, as you mentioned, for fees. But again, let me ask you a question as a practitioner. I'm just a lawyer, okay? What we did is we've got the document. We knew we were selling. We can't, we were moving from Canyon Lake, which has lots and lots of documents. We got them ahead of time.
Get them.
Our realtor said, get them ahead of time. We lived there. I used to be the mayor of the city. We got all the documents.
Exactly. And
a bunch of them were online. We downloaded them because I'm cheap. And then the rest we ordered and paid the fee. So don't wait, do it, right? It's going to save you time and, more importantly, headaches and potential breaches down the line. And then something new, as I understand it, is they now want you to do the installing. It doesn't say who's going to pay for it. It just says that there'll be an installing of the smoke alarms, the detectors and the water heaters within 7 days after acceptance. So if you haven't done it already, you got to do it. These are legal requirements.
Yeah, and the reason for that is that what the buyers are suffering is a re-inspect fee, because they have to go back to the property to re-inspect for the smoke alarms, the carbon monoxide detector, and the water heater bracing. So now you have to prepare your sellers. This has to be done within 7 days of acceptance, if not prior. I would recommend you tell the sellers, once you list the property, to get these things done immediately.
Unless the buyer's going to pay for it, you're absolutely right.
Exactly. So, and watch out, because when we look at those sections where they're referring to, like 10B1, it may say the seller has to pay the re-inspect fee. Now that this item is in the contract already and it's in the grid. That
we'll point that out, or I'll point that out when we get to it, because it says it right there in black and white that you will pay a re-inspection fee, seller. So it's important. Now we're going to go to my favorite part of the contract.
Go for it, John.
And that's let's go to the next slide. And I love what they did here, right? You're selling real estate. You are not selling wine refrigerators or security systems or electric car charging stations, right? There's a lot of confusion. Fixtures mean things that cannot be removed without damaging the property. Well, all of these things, for the most part, may look like fixtures, like a refrigerator that looks like it's been built in, but they're not. They are personal items. Some of them are going to be included, some of them are not. It's important to note that they don't reference, they reference refrigerators as a collective. So unless you're going to, let's say you have, in my old house, we had 5 refrigerators, right? My wife decided I didn't want to bring any of them to Tennessee, so we left them all. So it was easy to check off the, what if I wanted to bring the one that was in the bar area, right? Or I wanted to bring the one in the garage or whatever. Then you have to make sure you deal with that here, because this says refrigerators and it defaults to all. Stoves that can be removed, older homes have those. And then of course they've added a whole bunch of other things like a microwave. You could have an additional item included, like a pool table or something else that you're leaving behind. And then you've got the smart house stuff, all the doorbells and the smart home and all the devices that go with it. Again, all explained in paragraph 9. And because apparently there's been hissy fits about bathroom mirrors, they automatically checked it off. And unless you've excluded it, you're not getting the bathroom. And then of course, above ground pool spas and potted trees. And then if you're going to exclude an item, and I know I've talked to you, Linda, about this, don't wait until you have a transaction. Right? Get rid of, listen, we had an argument, not Linda and I, but my client, they were selling a high-end property in a place called La Cresta, which is a high-end 5-acre minimum lots, really nice stuff. It had a beautiful chandelier. Well, they never bothered to account for it because it looked nice and it showed well. But when the offer came in, now all of a sudden nobody bothered to think about the chandelier. Now it's an argument. Is it a fixture or not? Personally, I wouldn't have wanted it. The desk was amazing. But what they should have done, and what people like Linda tell me, is get rid of it before you start marketing it, because the buyer may fall in love with it as well. Doesn't matter what. It could be a chandelier. It could be a dryer. I don't care. Right? If you're going to keep it, get rid of it. But if you haven't, you have to right there exclude it. Now, maybe I don't want those refrigerators, right? Or maybe I don't want something, but that's what this paragraph talks about, is items that are included or excluded. Because when you go to paragraph 9, it says what it says today, which is that it doesn't matter what you put in your flyers or in your MLS or any other marketing material, the contract has to reflect that. We had a fight one time. There was a waterfront property that was selling, and it included the boat and all of the furniture. Well, to my recollection, boats and furnitures are not fixtures. Now you get into a hissy fit, not only with the buyer, but with the lender. You know, how much of the purchase price is going to be allocated to the boat and to the furniture. So anyway, this is a new section that does electric car charging system and stations include? I have no idea. The question is, it's a great question. Does it include certain other things? And I'm going to say probably, because you know, again, if it's something that is a unit, right? That, you know, you can't have one with, like, for example, it talks about smart home control devices. What good does it have to have a smart home if you don't have all the passcodes and all the thises and all of that? So I would tend to say probably yes to that question that just popped into the chat. But I'm not familiar because I don't have an electric car, right? All right. Anything else to add to that, Linda?
Yeah, I do. Somebody asked one time about the in-ground plants, and the attorney said that they're already included. Anything already planted in the ground is included,
That's correct.
unless excluded. Now, what we train our agents is, at the time of listing, you should 3 places. Make sure anything included or excluded is in the listing contract, in the MLS, and in the contract between the buyer and seller, because it could be in the listing contract and it could be in the MLS. But if the buyer's agent isn't writing things in that the buyer wants or doesn't want, guess who gets to keep them? The seller.
Right.
So even though they put it in the MLS is not party to this agreement. So you have to make sure you read the MLS, see what's included, non-included, or excluded, and write it in if the buyer includes it, wants it included, or doesn't want it included. So you have to be specific about these items. When we get to paragraph 9, we'll talk more about this.
Not a lot more, because we're starting to fall behind a little bit. So
okay, so what we're going to do, John, probably we're coming up on noon. Let's look at the questions that are sitting here and see if we can answer those, and then we'll break for lunch. How long a lunch, John?
I'm on a diet, so 5 minutes is okay with me. But I'm sure that the people that are normally that have normal bodies are going to want a little bit more. I don't particularly care if it's. Does anybody have a problem with a half hour? I think that'll get us to where we get caught up, because I got to be honest, last time we did this, Linda, we finished with the matrix at the noon hour. This time we're not quite there
A
yet.
little behind.
But we
Okay.
know more now, so it's unfortunate.
Yeah, but we're also covering.
Okay, I like it. I like I don't know how to pronounce her name. It's a beautiful name. Requieta. Anyway, she doesn't eat lunch, so she and I are together. We can talk while everybody else is breaking. So then Sharon's on a diet too. So we've got some good people out there. I say half hour. Let's go to the questions.
Okay, okay. So we have a question. Let me move this up a little bit. All right. And somebody wants to make sure you do that tenant occupied property seminar, John.
Yes, I work for Laura, so she's going to make that call. And I'm not saying I'm going to teach it. There are better people than me that know more than I do in this topic, and I've kind of deferred to like Bob Bloom and some others to deal with these issues because they're really become very specialized. So I think class should be done. How it's done is going to be Laura's call.
Right. The question is, then sellers need to get the HOA documents. And I think we answered this. Yes, as soon as possible. And you can work with your escrow officer. Escrow usually is the one that orders the documents direct from the HOA. So work with your escrow officer as soon as you know you're going to list a property with an HOA. Get at least at a minimum, get the information for the seller, how much the cost is going to be. It varies anywhere from $300 to $600-700. So they have to be prepared for this because it does have to be paid up front.
As far as the question of what documents are ordered, there's a statute, it's 4225. It says that certain documents must be provided by the seller, things like CC&Rs, bylaws, those kinds of things. So we'll get into that this afternoon.
Right.
There's a specific form to use for that.
Right.
Let's see here.
Seller delivered to the buyer all docs of disclosures of disclosures within 7 days, and buyers still have not returned signed docs now into 12 days. Is there a time frame? Yes, there is 17 days unless that's adjusted. So the buyer is promising in the current contract within 17 days they'll return unless that time was adjusted and everybody agreed. So
right, because they were delivered late. Again, that's that 5+ days.
Yes.
But again, if you're not getting these signed documents, particularly things like the SPQ, the TDS, you can send a notice to perform.
On day 15. Day 15, you can send a 2-day notice.
Unless the documents were delivered late, that's correct.
Correct, unless the documents are delivered late. And then due to the electric car charging system, the stations include the level 2 or 240 volt outlet. Some cities consider that outlet as charging system and require a special permit to install one, like Rancho Cucamonga. That's a good information. Good information. Let's see. I don't eat lunch. That's cute.
I always like Laura's people. They're really good. So here's the deal. It is 12 o'clock. Well, actually, it's 2 o'clock for me. Yes. But it's 12 o'clock for you kids. So let's come back at 12:30 and we're going to go finish the matrix, and then we're going to walk you through the changes that are in the body of the contract. Okay. And we're going to point out some really incredibly good changes. So stick around, because I know it's hard to do this on Zoom because we're so much cuter in person, but we got to have some really good information for you coming down the road. So we'll see you.
Welcome, Carmen.
All right, we'll see you in a half hour, girls.
You and I.
Take care.
Great.
Okay. Done.
Is this the right page you guys want to be on?
Yes, ma'am.
Okay.
That's exactly where we want to be.
Okay.
No, actually, I want to be on a beach in the Bahamas.
But for this class,
I don't know, what's the weather like in California today? It's cold here.
it's chilly and a little dreary today.
Yeah.
Do me a
it's a little-
favor, Linda, since you're a Californian, define chilly.
It was about 56 when I left the office last night. It was pretty cold.
Yeah, that is cold for you guys. Well,
Yeah,
it's 43 here.
Let's
And
see.
it's gonna drop down tonight to 34,
Mm,
but clear.
right.
You win.
And then tomorrow it's gonna be 52. Shorts weather.
Mhm. It's 59 degrees here now in Diamond Bar.
Well, that's actually cold for you guys.
It
It's
is.
different. Like we had our tree lighting ceremony because I'm living in a Hallmark movie. I've been injected straight into Hallmark.
I
And,
love Hallmark movies.
Well, I do too. And I swear I felt like I was living in one on Friday night and Saturday afternoon.
Oh, bet.
Because Friday night, Franklin has a town square like most southern cities. And obviously there's new parts of town and we even have a mall. But in the town square, they do a tree lighting ceremony.
Right.
And big 50-foot tree and all that. And then they have performers. Well, a lot of performers live here in Franklin. So they always have a couple of, not A-list celebrities, but although Kenny Chesney lives here, he wasn't there. He might have been in the crowd, but he wasn't there. But they had, it's a guy named Matthew West, who's a 3-time Grammy nominee. And then you remember Tanya Tucker, the original bad girl of country? her daughter, who has a phenomenal voice, sang. And so then they light the tree. And then Saturday, they do the Franklin Kiwanis parade. And I went down there figuring I'm going to stand for 20 minutes and see a couple of cars go by and the mayor doing, this kind of hour and a half.
Wow.
It had all the high school bands from the area. And this is Music City, so music is a really big deal.
Right.
And they had, my God, it was phenomenal.
Cool.
And then I finally got to go to the Ryman. I hadn't been there before. The what do they call it? The Mother Church of Country Music.
Oh,
That was pretty special, actually.
sounds cool.
It was cool. I have become a hick. Actually, these people. I just got an email from Barbara Betts, and she's on a buyer advisory group, and they wanted to see. We have the forms are very similar here, and we have a mandatory buyer broker representation form. And so I'm sending her a copy of it this afternoon once I get it from my realtor. But again, it's a very sophisticated group of people. I was blown away because we all have stereotypes, and I've been coming back here a lot because my wife's family's here. This is why we moved to Tennessee. Is where my wife's from. And since I've been married for 45 years, I have no opinion of my own.
Right.
And so we moved here, but I'm starting to schedule my California trips. I'm going to be in it at least once every 6 weeks, if not more.
Cool.
I'm coming in.
John,
Yeah.
who do I talk to schedule you for next year? Is it Crystal or Linda?
Linda.
Okay.
We actually talked about that this morning. She's going to call you.
Okay, good.
She wants my vacation schedule first, and she's going to, you and Connie and Lori are her favorites. So that's who she's going to call first.
Okay. I'm glad I'm in the top 3.
Well, you're actually probably higher, but I don't want to make other people feel bad. No, it's been a glorious year. I mean, I'm getting used to living somewhere that I haven't, I've spent 7 decades in Southern California. I never lived anywhere else, born in Los Angeles. I'm really starting to like it. I'm slowing down.
I mean, that was the whole purpose, right? Of you.
Well, I don't want to retire. In fact, I talked to Phil about it yesterday, and I talked to Craig Martin this morning, and I still feel I'm useful. I feel like I know this stuff pretty well, and I have a purpose. I just don't want to have that purpose, 12 hours a day anymore.
Right.
We have no bills, and so, I don't have the urgency to work. But I'm like Linda, I gotta go. I'm getting Titan season tickets. I'm sorry, Linda. I didn't mean to bring up a sore subject, but I'm getting Titan season tickets. I was rooting for Buffalo last night because if Buffalo would have won, we'd have been the first seed again.
Exactly. I saw it. Yeah.
So I think we're number 3. I'm not sure.
I'd rather today talk to you about the Ducks, but we'll move on.
We beat you.
We're doing well. We're in the 3rd place in the Western Division, and we are 4th place in the conference. So we're doing good.
I'm going to my first Predator game with my 2 grandsons.
They have
My 3 grandsons.
They have 5 teams ahead of them.
I have heard that the atmosphere at the arena in downtown, because our arena is in downtown Nashville. Literally, it's the corner. It's the arena's on the corner where the honky tonks end.
Cool.
So it's a really cool place to go. And I'm going to go to. I don't know who we're playing. I think Colorado. I'm not sure. That doesn't really matter. We're going to take my grandsons, my son-in-law and I, and. They call it Smashville because they break up cars as to get the crowds pumped up.
Exactly. Well, let's move on. Let's talk about.
Is it 12:30?
Yeah.
I'll be done.
We're going to move on to allocation of cost. And this is a real important section here. Who's going to pay for what? And you get to check off what the buyer's asking the seller to agree to. Now, of course, the seller can come back and counter, but we'll start with the natural hazard disclosure. And if you see, it could be buyer, seller, or both. Now, John, I'll address this to you. When the natural hazard disclosure became law, I understood it to be the seller was to provide it to the buyer and the seller is to pay for it. In fact, I thought I read that that is actually in the law.
Which law now are you referring to, Linda?
Or the NHD natural hazard disclosure. And that if the seller won't pay for it, refuses to, that the listing broker has to. But now we see on the contract that there's a choice. The buyer could say, hey, I'll split it with you, so both would pay, or customarily, the buyer is going to ask the seller to pay for it. But the block's available that it may be the buyer wants the price of the house reduced so they can afford their mortgage payment and says, hey, I'll pay those costs going in if you'll reduce the price of the house. So there's all kinds of things that happen in negotiations. But I also would bring your attention to additional terms, the environmental. I think it's very important that you include an environmental report. And I want to touch on that real quickly, that is where you would find out if like gas transmission lines are running through backyards or front yards, and there can't be any digging there or other issues. Because you may buy a property, the buyer may buy a property that has a flat backyard, and the agent says, oh, this is a wonderful place to put a pool, and the buyer wants a pool, so they close escrow and they get down to the city or the county, wherever they have to go for their permit, and they find that they can't dig in the yard. Well, wait a minute, agent, you told me that I could have a beautiful pool here, so there may be some problems. The environmental report section of the NHD report would address those issues and make sure that the buyer, would be able to dig a pool in the backyard or other items.
Actually just settled a case almost identical to your hypothetical. My client bought 10 acres, 9 acres, 1 acre was, pretty much where the house, the barn, all that stuff, the pool. And then there were 9 acres, and he intended to clear those 9 acres and plant vineyards, which he was then planning on selling the grapes to the wineries and he had a whole plan set up, but he didn't bother to read his environmental report. And that's the other issue, not just get the report, but actually make sure your clients read it. Because what he didn't know, because he didn't read it, and why we didn't take the case, is that we mediated, but we weren't going to litigate it, is that it was in a multi-species habitat protected zone. So not only could he not grow the grapes, he couldn't do anything more pretty much than walk on the property or ride on it with his horse. I mean, it was protected. And so people need to understand, as far as the law is concerned, the law requires a natural hazard zone disclosure. The other things are subject to discretion and of course cost. And of course, who does those reports is also very critical. So when you look at that line, it talks about, what you're getting. Are there going to be additional reports such as a wood destroying pest report, which I would think, I'm surprised they didn't make that a default, but they didn't. Are you going to get a roof certification? So, and then who's going to pay for it? And if you're going to say both, I would put in, is it both 50-50 or both 60-40, something like that. And then I think it's greatly overlooked here and also in the preliminary title report, what company is going to provide the service? Because I think that makes a difference. Then as far as smoke alarms, again, who's going to pay for it? It's legally required that it be done, but again, in negotiating in today's market, sellers have a little more authority. As far as all these other things, the other thing, Linda, that I see, and I know people like you do, is if you're representing the seller, that not only are you agreeing on who's paying, but what are the costs? Correct. That one that I see up in LA is that government required point of sale corrective remedial. And if you're going to agree to pay for that, you better put a cap on it. Same thing with wood destroying pests. You remember that case we talked about up at CAR, $124,000 remedial wood destroying pest work, and hard to get happy after, you know, somebody gets a bill like that.
Right.
So all of these county transfer tax, you know, government is never going to have enough money. You guys know that. You're the most taxed state in the nation, and part of that is, you know, local tax, not just state tax. So who's going to pay for all that? And then, of course, the owner's title policy. Typically, the seller will buy the preliminary title report and the insurance. All of those things have to be addressed. There is a statute that does require that the seller pay for certain HOA disclosures, 4225. And so there's a form we're gonna show later, maybe on Friday, as this note, I'm kidding, but that, you know, again, when we get to it, where there's an HOA disclosure document. And then, of course, private transfer fees, which now have to be in the recorded. And so, and then lastly is that home warranty plan, which I think, I just settled a case. It was a major problem with the air conditioning, and in your area, air conditioning is important.
Mhm.
It is here too, but not quite as important, particularly if you live out in the Riverside area where, you know, you're basically in the high desert. And so, you know, who's going to pay for it, what's being offered, and what company is going to do it, because different companies offer different choices of what you can get covered. And so all of this page is very important and overlooked, but it can lead to some major disagreements because it can lead to some major expenses that were not anticipated by the sloppy agent.
Right. And I wanted to touch on, some people will put in section 3Q2 that the termite report, but it does not allow you much room to put any other details there. Also remember that the request for repair, now, if it's not negotiated up front, they can ask for termite in the request for repair. Because if the buyer gets a termite report and finds that there's some damage and they would like the seller to pay for it, they can put that in the request for repair. Just remember, any reports that the buyer get, any report, regardless of what it is, at no cost to the seller, the buyer has to provide a copy of it.
That's correct. And all you're agreeing to here is the cost to provide the report, the certificate. It has nothing to do with the repairs. That's a wholly separate negotiated issue. So again, this section, which is brand new, again, takes stuff from the body of the contract, because these are all negotiable items, and that's why it's in the grid,
Right.
because these are negotiable.
And under additional terms is where you would put, if there's a particular company, for example, I'll just use a company, First American, to provide the NHD report, or seller's choice. You'll probably see a lot of seller's choice go into these areas, but escrow holder has to be named there. Maybe the buyer has a particular escrow they want to use, put it down. Title company, same thing. And down the bottom, what home protection company do you want to use? Does the buyer want, maybe it's buyer's choice. But the home warranty plan, John, because we've all complained about this since the first draft came out, there's no place to put other options for the home protection plan, which would be 3Q18, and it's addressed in 10C. But home warranty plan, now they have added lines, and you may be able to type in there to include air conditioning, pool, spa, and everything. So I'm glad they did address those issues we kept bringing up. Also,
as I understand it though, Linda, what they did here is basically all I'm agreeing as the seller is I'm going to pay $500 towards home warranty. You, as the buyer, then go, you pick, you know, you put the company in there, but you decide, okay, there's a pool. I want pool coverage. I want air conditioning coverage. Maybe it's a solar panel, whatever options are available. And maybe that's going to end up costing $900. So all I've agreed to do is pay Old Republic $500 and then you have to decide everything else. Does the listing agent broker carry liability when they state home warranty? Then it went off. I didn't see the rest of it. We'll answer that question. Probably not if you do it correctly. So home warranty plan, like you said, there's boxes, but realistically, I don't care as the seller. All I know is I'm paying $500.
Correct.
You handle everything else. Where the buyer's agent can be valuable is to guide me, if I've never, particularly a first-time home buyer, is to guide me on what coverages I may want, and then not to oversell home warranty. You know, home warranty is a negotiable thing. I just negotiated with a home warranty company for some air conditioning, and there was a major disagreement. That's why I got involved, and we worked it out, fortunately, because it was a reasonable company, one of the better ones. So, but these are important issues. So I don't know if we've got anything else. We can move on to the next slide.
I just want to bring one thing up. The reason why this was so important to myself and to agents and to the home protection companies is that we're not in the negotiations. In other words, my transaction coordinator or an escrow officer is not in the negotiations. How would they know how to order? Because they're the ones ordering the report, you know, or the warranty plan. How would they know what the buyer wants?
Oh, I think it's a good idea to put what you want.
Exactly.
The point is, though, is the seller really doesn't care. You could want $1,000 worth of things. I'm only agreeing to pay $500.
Right, but there was nowhere to put that other information, John, for a TC to look at this contract and say, okay, I'm going to order the warranty with these coverages, regardless of cost. And the good thing is in 10C, as we'll see shortly, that says that the buyer will pay additional over what the seller's willing to pay, if anything. That was never in this current contract. It was always a crapshoot. Who's going to end up deciding who's going to pay for additional coverages?
I know that we, because I'd already seen, you know, this new contract. So I thought about that when I sold my house, and I told my realtor, this is what I'm willing to pay. I don't care what they do. They can spend whatever they want to spend. I'm giving them a credit of blank.
Yeah, and that's not a problem. The problem was that somebody else other than the negotiators here are ordering these plans. We needed it spelled out. What is there to, what's to be ordered?
And
So
that's why these types of contraptions are so valuable.
well,
You can call or you can write, you can do an email. I would stay away from texts only because I had this conversation yesterday, because the trouble with texting is it's harder to save a text to the file than than an email. That's just my personal preference. There's no legal authority for that statement. All right, you want to move on?
just wait, we have to catch real quickly other terms, and that's where you would place if perhaps you're buying.
That was the next slide, right? That's what I wanted to point out is that, you know, that's where you can, that's the catch-all. That's the safety net.
If they're related, the agents are related to the sellers, related to the buyers. If somebody's licensed in the transaction, other items that would go in this area would be maybe the buyer wants them to fix the fence before close of escrow. Maybe they want them to anything that the buyer may say when they're walking through the property. Surely the seller's going to do this. Well, surely they're not going to do anything unless you put it in writing. And this is the area where you would place it.
I call this the et cetera clause.
Mm-hmm.
You know, this is the famous et cetera, right? I mean, things that just are special to your particular transaction. You know, every property is unique and different. And so, and then there was a question that came in about, you know, again, I want to emphasize whatever the seller is willing, you know, the offer is going to be, hey, pay up to $500, maybe you pay up to $800 for home warranty. The counter would be, no, I'm paying $500. I don't care what you do with the $500. You know, I'm paying up to $500, and if what you want to have covered in the home warranty is more than $500, then you're right. Then the seller, or the buyer will pay the difference. Okay, let's move. We are now done with the matrix. Yeah, we're gridded out. So let's go to the next section that will require you to check off a box.
Well, we have to point out that there's no longer going to be a probate purchase contract, and there's no longer going to be a manufactured home purchase agreement. It will
Correct.
be used here. You will check these blocks if that applies, probate or manufactured applies, and you will, as you see, some addendums will be popping up in your zip forms if you are checking those blocks, and those documents must go along with this contract, but you will actually use the new contract for manufactured home and probate.
There's two addendums that have been available, because a lot of agents were instead of using the probate contract, they were using the RPA. And so CAR about 2 years ago, I guess, came out with a probate agreement addendum. And now they're sunsetting the probate agreement along with the manufactured home agreement. So if anybody is going to make, let's say you're making an offer on a property that's got probate jurisdiction. Well, obviously you can't sell it. You can't approve it without court confirmation. So you'll check off that box, you'll attach and I think I put it up. I think it's the next slide, I'm not sure. And then they've added the tenant occupied addendum, which we've already talked about. There's now a tenancy in common. And for those of you that have never sold property as tenants in common, this is like a partnership, basically. You, me, and Laura are buying a property. Well, we're not related. We're three separate people. I'm going to own 20%, Laura's going to own 30, and you're going to own the other 50, but we're still tenants in common. There's lots of issues there. So there's not only going to be a tenant occupied property addendum, which makes it part of the contract, there's also a tenancy in common advisory when we get down to that. Then there's the stock cooperative, which is technically, I'm not really buying real estate. I'm buying an interest in a stock cooperative, which then owns the real estate. So there's that addendum. And then the other addendum, maybe your office has its own addendum, right? And again, I see a lot of people trying to get those things signed after escrow opens, and you can't do that. It's got to be with the contract. So again, remember, addendums are part of the contract. It's not a form. Well, it's a form, but it's a form that changes the contract in some way and is the governing form. Any other comments, Linda? Because these are, I think I put up the property addendum just to show them what it looks like. That'd be the next slide.
Okay.
I did that. And I did. Yay. This is page 1 of 2 of the probate addendum. And again, for those of you that are doing probates, this is how you will deal with it. You will go through and check off the boxes, because it could be a conservatorship, it could be a guardianship, it could be, a regular probate. Then again, you check off boxes if it's being sold in a particular way. Court confirmation. My understanding, Linda, is that if you use this form, you don't need to use that separate court confirmation form. You use that one for divorces and bankruptcy. And then, of course, when's it required? I mean, you don't want to go on forever with this offer. When do I have to go to court and get confirmation? So all that's going to be included in this form, and again, then there's one for manufacturing and all the others. So I didn't put all those up, but I just wanted to give you a flavor of what these addendums look like. So I think it's a pretty good form. Then we have.
Well, John, we're getting questions regarding the RIPA. I haven't heard anything different, but I think it's going to be adjusted like this one. I'm not sure.
Which one?
The residential income purchase agreement.
No, I think what they're doing with all the other forms, Linda, as I understand, and I have to be perfectly honest because I'm a lawyer and we always are, I think what they're doing is they're changing all the purchase agreements to reflect the approach that this form is taking.
Got it.
Now, whether they're doing that in December or later, it's my understanding that everything's going to be pretty similar. So if you understand the RPA, it shouldn't be that big of a jump for you to figure out these other forms. But
RIPA. And what they're asking, what they're asking for is multi-unit and so on. Yeah,
Right.
This is for 1 to 4. This particular
This is a 1 to 4 contract. That is correct. This is even investment property. I'm buying this property. It's a triplex, and So it's technically partially, I may reside in one of them, but it's partially, which makes me think, you can actually check off 2 boxes in that intend to occupy. I intend to occupy, and it's an investment.
And lease it, correct, correct.
Now, these are the other addendums, and I've put almost all of these up so we can plow through them, but these are addendums. The one I'm worried about, Linda, is the addendum, because it's 3 lines with a bunch of other lines that the unwary agent can fill in, creating a non-binding contract that they didn't even realize they were messing up. Then you've got the backup offer, again, a very important document if there's a pending transaction that hasn't fully canceled yet.
Yep.
Septic, well, and property monument addendum, part of the contract. The buyer's intent to exchange. This is a renamed form. This form exists under another name. I don't recall the other name, but this is where I'm buying this property and I'm making it the second leg of my 1034 or 1031. And the same thing would be true. There's the seller intent to exchange, a very important form, because if I'm holding this property as an investment property and I intend to roll it over, I mean, I did a couple of 1031s when I left California, not left California, but when I sold everything I owned in California, because they were rent producing. And so very, very complicated, very, very precise. You got to do it exactly right. So there's going to be those forms. They already exist. They're being significantly modified and renamed. And then there's the other addendum. Again, if you have your own forms or a form local to some boards produce local addendums. I know San Diego has one, and we did one out in the desert as well. I think those are advisories though. Yeah. And so let's move on to the next couple of slides just to give people the flavor of what these forms look like. We're not going to dwell on them, but so this is the one that scares me, because this gives a realtor a lot of space to screw up. Be very careful about the use of this form. Perfectly fine for simple things, but don't create contracts on them. I saw one that said addendum, seller to remain in property for 2 years after the close of escrow, period. What are the terms? What's the lease? What does it all look like? So be careful about what you write there. The thing I like about it is that if something comes up, you've already sent in your transfer disclosure statement, and then boom, the seller finds out that all of a sudden there's a problem that they didn't put on their original TDS. You can check off that box. And this can be used, by the way, for the purchase agreement or for a lease. And you can then check off the box. It says transfer disclosure statement, and you can then make the amendment to the TDS without redoing all those other forms. So that is valuable.
Yeah, John, there is something I want to mention here, that if the agents are not aware, there is now an amendment, and why I like using the amendment rather than an addendum. If you're asking the other side, regardless whether you're buyer, seller, who you're asking, which side you're on, it gives a timeline like in a counter offer, rather than just making a statement on, for example, maybe the reducing the price because the house didn't appraise. Maybe that's what you put in an addendum. I would put it in an amendment and give the seller 3 days or less time or more time to decide if they want to reduce the price, negotiate in some other way. But there is no amendment.
I think this is a form that needs to be used very cautiously, because again, there's a lot of lines there. You could really make some major mistakes. To move on to the next one, because again, this form, to me, its primary function is to amend the TDS. That's its best use. This is the court confirmation form. You can use this for the probate to double check on that, but it's primarily now used for divorces where the courts retain jurisdiction, or maybe bankruptcy where the bankruptcy court has actually seized all the assets and everything has to be approved. Now, and the best part about this is that you don't start any of your investigations on the buyer's side until after approval, so that you don't spend a lot of money on investigating the property only to find out the court won't approve your sale. So I think that's a good use of this form. The next one is this is the seller's intent to exchange form. Again, you can see that, again, I personally think if you're involved in a 1031 exchange, on either side, whether it be the buyer side or the seller, you need to talk to an accountant or someone an accommodator, because there are some very strict rules. On Friday, I learned there had been a lot of talk that at the federal level, the Biden administration wanted to do away with 1031 exchanges, or at least cap them. And so far, according to the NAR federal guy, that's not going to happen yet. And so we can all hold our breath until Congress reconvenes or goes back into session, or until next November, where we see how the Congress shapes up. But the bottom line is for now, at least 1031 exchanges are okay as of right now, as of today. That doesn't mean somebody won't try to pass a regulation or something like that. So, but again, from a liability standpoint, if you've never done a 1031 exchange, get some help. Or just simply tell your client, you're going to handle the transaction. You're not going to give any advice, information on the 1031s, because there's some deadlines. There's some requirements for where the money has to go. If you're the seller, it cannot go into your own account. It has to be held by a third party. Can't touch the money or you're going to pay tax on it. Lots of stuff. So it's very, very complicated. Next slide. And then Linda, you can take this next one.
Okay, we're going to talk about the advisories, buyer and seller advisories. As you notice that several blocks are already checked. And what that means is they are in your bundle with the purchase contract. Now, what you will see, there's a new form coming out, or it came out, Wildfire Disaster Advisory. This is an advisory. And the buyer may want that document, so they may check that. They may feel like they're near a wildfire disaster advisory area. On that form, you have to remember, there is forms that are changing because of the devastating fires we've had. And if the property's in a high fire hazard area or in a very severe high fire hazard area, the form that gets used, the seller must answer the questions on the form. But we're recommending use it in every, because I'm in a property transaction now that it's near an area, and we're using the advisory, and it just states I'm not in one, but this is an advisory regarding those areas of fire and disasters. And there's been many in California, and that's why they're addressing this issue.
We're going to cover this on a newsletter, so film at 11. As soon as I know what forms are final, so sometime after the 14th, we're going to actually do a newsletter, and Laura will post it and all of that. One of the other things I want to point out, a couple of things. Read the wire fraud advisory so you know what it says. I read something from NAR that wire fraud in all forms, including real estate, has gone up in the hundreds of percents, because we've all gone now to, everything is done remotely. Also, in December, the California Consumer Privacy Act advisory is going to be significantly modified, because last year they didn't know what to put, so they just threw the kitchen sink in the form, and the current form that's being used is very long. This one's much shorter, much easier to understand and read. Fair housing, like I said, very, very complicated. You better understand it. Laura did we did a housing symposium the middle of this year. I'm going to guess she's going to do other things coming up in 22 for fair housing. I'm not sure if I'll be involved, but whatever it is, you got to keep up. And then personally, one last thing real quickly, personally, my favorite form of all of these, they're all good, but is the statewide buyer and seller advisory. Yep. I just think that form should have been checked off. I know it's 14 pages long, but it's really got a lot of good stuff in it. Go ahead, Linda, I'm sorry.
That's okay. I was just going to say, I recently myself had a listing and 20 offers, and half of them came with buyer's letters. And the seller had chosen, and she's licensed, she chose not to read any of the letters. And it's been coming to our attention recently that the agent should not even read these letters. So 10 of the 20 offers had buyer's letters, some with pictures, some with additional information with them. But like I say, when we countered, we sent an email to those who did not get considered by the seller for their offer acceptance. And we did send back the portion of the FHDA form that addresses the letters. And that was mainly not for the buyers, but for the agents. You have to be aware that FHDA form, you must read it, and it does address the buyer's letters. But you're correct with the SBSA, John, where our brokerage requires it to be sent with the offer. And we check it every transaction. Short sale advisories, that's in here as well, and probate. So these are the advisories. If they apply, check the block. The form that's required will be added into zip forms, and you use it and send it along with the offer.
And these are not part of the contract. They're just legal papers written by the CAR attorneys. I got to tell you, Linda, that there's a reason why the NAR legal staff, the CAR legal staff, and the association's attorney, me, all advise against the love letters. Not a question of reading them. It's a question of what's in them. And it's a fair housing issue. You know, we're a lot of them, you know, it's my picture along with my letter, which, hey, I'm white. You should sell to me because it's a white neighborhood. Or, you know, something in the letter that talks about how I share the values with my you know, spouse who happens to be not the same sex that I am. And I've seen these letters. I've had a couple of cases with them. It could be completely innocent, but the perception you're giving. So again, a whole nother class for a whole nother day. But I know that the MLS has some areas where you can put in there in your agent remarks, love letters will not be accepted, or you know, something like that. But even if it's if you don't tell your seller about the concerns and you don't read them, that's not going to help, because they're going to sue you for not telling them about these love letters. And it's a fair housing issue. In Oregon, they've actually banned them. And I was talking to your lobbyist on Friday, and he was saying that there are assembly people in California that would like to ban them as well, but they're worried about free speech, so they're waiting to see what happens in Oregon. So again, enough about those. I think we can move on.
It's actually, John, now addressed in the listing contract. That's
It is,
and
absolutely.
the seller can actually choose in the listing that they do not wish to have them, or wish that they do have them. So,
and I would strongly urge, just, you know, why buy? What there's a saying here in Tennessee, don't borrow trouble. You know, and I love these little homilies. That's a good thing to do. Basically, why invite in a problem unless you happen to be a racist or something like that? Then maybe this is important to you, and you know, please keep my card handy. Anyway,
we're going to go on a lot of these issues in these next paragraphs, John. We've already talked about the RID is going to be changed to the DID. That's in the increased deposit. Non-refundable clauses, reminders. We already spoke to that. Make sure that you are telling your clients to get proper help when they want to do non-refundable clauses or types of verbiage like that.
Just so you know, Linda, we've there are the advisories we put. We're not going to go through them. Just this is the wire fraud advisory. Read it. It's very good. Well done. Can be used for sales or landlord-tenant situations. Why? Because hackers are getting into accounts and stealing about $1 trillion worth of money so far. It's very lucrative. My son-in-law works for Google, and he tells me how they do it. It's amazing. These guys are smart. These are the guys that, you know, if in another time, another day would be robbing banks. They don't have to do that anymore. They don't have to get dressed. They just, steal your money from the comfort of their living rooms. So let's go to the next slide, which, if I recall correctly, is another advisory. Please, we're going to blast through these like in 2 minutes. This is the Fair Housing Advisory. It's 2 pages long, has some best practices. You should read this or not, your call, but it's going to be included, and there's a presumption that you've read it, so you ought to read it. And it's got some great suggestions in it. Next slide, please. Because, by the way, just so you all know, the #1 claim in California when it comes to fair housing is not race. It is disability. It is disability. Mm-hmm. So things like, great, healthy, active lifestyle advertising can, be careful about what you say. So this is the second page of the Fair Housing Advisory. Next slide, please. Now we're back to where you were. Okay.
Yep. So retention of deposits and such, if you're attempting to do anything like that, please have them advise them to seek legal help. All cash offer, we talked about this earlier. All cash offers is specified in 3A. Now, what I like about the new contract is the fact that on the grid, it refers to the paragraph that it would apply to. In the paragraph, it refers back to the grid. So you can't get lost here. It's referring to one another back and forth, which I think is ideal. Moving on.
Real quick, what I really like about this is look at A3, retention of deposit. The most common fight, according to June Barlow, who's the attorney for CAR, pretty much the smartest person on the planet, is that the biggest problem is who gets the deposit. Mm-hmm. Sellers think they get it, buyers think they get it, small claim judges don't have a clue, and it's always a problem. Read this paragraph number A3, and you notice it's in bold writing and talks about who is going to get the deposit. It also says, do not give opinions of issues relating to that. So consult with a qualified attorney. These are complicated issues, and it has to do with statutes and court findings and all that. So this is an important paragraph.
Yeah, and stay away from things like, oh, don't worry about it, you're going to get their deposit. The only thing you should be saying is you may have a claim against their deposit.
There's a case that just came down. I'm going to report about it. If we ever stop running out of new things, I'll be able to go back and report on some things that have been going on recently, but there's a case. So all the contingencies, buyer enters into a contract. All the contingencies are typical. 3 days later, buyer finds a house they like better and says, and there's a $72,000 deposit. So this is a pretty high-end thing, which means what? There are going to be lawyers involved, right? So there's a $72,000 deposit. The guy says, I like this house better. The agent says, well, you've got all the contingencies, you'll get your deposit back. Let's cancel, right? They go ahead and cancel. The seller goes, wait a minute. My lawyer told me you have to act in good faith. You didn't act in good faith. You never even applied for the loan or moved forward. You never even looked at the house for inspection purposes. The contingencies were there to protect you, but you did not act in good faith. Refused to sign the release of the deposit. They couldn't settle at mediation. They went to arbitration, and the arbitrator agreed with the seller, said, buyer, you did not act in good faith, gave the $72,000 deposit to the seller, and awarded attorney's fees. The total settlement was like $120,000. So don't give advice on who gets the deposit. Let's move on, unless you've got something more.
Amen. No. Down in paragraph, let's see where I am, 5C4, I addressed this earlier with the FHA VA loans.
Okay, and, let's move on to the next slide then. This is just the all cash slide.
Yeah. And then the FVA, there it is in the 5C4 section, and they're going to do away with the FVA form, and you can address any repair items in paragraph 3 of the revised request for repair. That's for FHA and VA loans. I do want to go up to the buyer's loan status and remember that the buyer authorizes the seller and the seller's authorized agent to contact the buyer's lender to determine the status of any buyer's loan specified in paragraph 3E. Once again, they're referring back to the grid. So know that you should be checking on that loan. You should be checking on behalf of the seller if you're on the listing side, and that gives you the right there in that paragraph.
And you can show that to the bank, because the bank's going to say, well, we can't talk to you about this loan without written authorization. Now you'll have it commencing on December 14th, excuse me, under 5C3 buyer's loan status. You now are authorized by the buyer to check on their loan status. So I think that's an important new right. It's new, brand new to the contract. So you now have the right. Also remember that just because you have the right to check doesn't mean the right you have to invade privacy and you know, helter skelter talk about stuff. You know, be careful about what you learn, but you do have a right. And of course, the buyer shall deliver any contact information within 1 day of seller's request. So if you're dealing with, you know, Mary Smith or Bob Jones over at ABC Bank, and I ask you who you're dealing with, within 1 day of that written request, you must provide me with that information contractually. Okay, next slide, please, Laura.
Okay, additional terms. Let's see.
Nothing really new there.
No, it's the same. Next, yeah, additional terms, limits on the loan credits. That's where John alluded to earlier. Maybe they negotiated, say, $5,000 closing cost. Then I have my agents come in and say, hey, Linda, the seller doesn't want to do any repairs, but the buyer's asking for about $3,000 worth of repairs. Can the seller just credit another $3,000? I don't know. You have to contact the lender. The lender is going to tell you how much credit the seller can give the buyer in a transaction. Okay, so, and it's stated right here under the limits for credits to a buyer. What they're trying to avoid is the buyer being paid by the seller to buy the house. They want.
And there's again, they haven't made any significant changes to this paragraph, but it just cleans it up and basically says, look, we've negotiated a credit, which is the contractual credit. We've submitted it to the lender, and the lender said, this is what we'll allow as part of the financing for the credit under our underwriting requirements, and that's called the lender allowable credit. And if the lender allowable credit is less than the contractual credit, then the contractual credit will govern, and unless otherwise agreed, the credit will be reduced to that number. Okay, so what you need to be thinking about is what happens if the lender doesn't allow your credit, or if you get to the 17-day period and now you want seller credits for repairs and you're already at the lender allowable limit, you're going to have to come up with a more creative way of getting those repairs taken care of.
And it may be reduce the price of the property. I've seen that.
Absolutely. Absolutely. Or the seller can do the repairs himself through and pay for them separately, and that's perfectly okay.
Correct. So next,
but you can't leave any money on the table if you're already at the limit.
Correct.
So, all right. And then verification down payment, you know, again, they don't have a form for what the reasonable verification is. So it, you know, hopefully, since it's now going to be attached to the contract, you're going to be able to, you know, if you get it, you're going to see it. And if it's not satisfactory, you can ask for additional information.
Correct.
Next.
The next one. Verification of loan application. Once again, they have to act in good faith and apply for their loan. And once again, it's referring back to 3E in the grid. So when you're looking at the grid, you see the paragraph that discusses the items in the grid. So if you're confused as an agent, go to the paragraph. And then if you're in explaining things to the buyer and you see, hey, refer back to 3E in the grid. So it's going back and forth, which I think is a great idea. The next one.
Next slide. Buyer stated financing. This This is actually almost identical to what's in your current contract.
Yes.
Basically, all it says is, look, you told me that you're in the document that you provided me, that you're going to, this document actually, that you're going to pay all cash, right? Or you told me it's conventional financing. I have a duty, and if you read this language carefully, it says basically that seller has no duty other than to cooperate with the loan that has been referenced in the offer. So basically, if it's an all cash, I've got to do all the other things. If it's a conventional, I've got to cooperate with your bank. But if you change the methodology, and this, interestingly enough, came about originally because of a Tri-County's director. Her name is Linda also. And she complained all the time that she was getting these bait and switch offers. So we sent it to CAR. This was way back when I still had a waste. And so they changed it. They said, look, seller has a duty to cooperate with the loan that's referenced in the offer, but not with any other financing. That doesn't mean you can't cooperate or you can't agree to amend the contract, but you don't have to.
Correct.
Period.
And John, if something happens with that amendment, in other words, they come in cash, they decide to get a loan, get the permission from the seller. But if that loan doesn't go through, they've got to go back to cash because that's how they originally took the seller off the market.
And the other thing is if your seller says, you know what, this is a great client, probably has been on the market, you know, he's paying a great price or whatever the issues are, not only are you got to go back and you got to look at all your contract, because there's probably quite a few things you may be changing. You may have to extend escrow because I'm not going to be able to get my thing closed because I'm not paying cash. I'm going to get a loan. Whatever it is, you got to think through all that. But that's what this paragraph is all about.
Right. Next one, Laura. Okay, occupancy, obviously, when is the buyer going to occupy the property? That's pretty then nothing's changed there. This next paragraph, though, I want to point out several things. This is where your as is clause is. If you see in the first line, as is, in its present physical condition as of the date of acceptance, that's the explanation of what as is. But they've added something here in this section, and I'll read it. And it's down a few lines down. It says, if items are not removed when possession is delivered to the buyer, all items shall be deemed abandoned. Buyer, after first delivering to the seller written notice to remove the items within 3 days, may pay to have such items removed and disposed of, and may bring legal action as part of this agreement to receive reasonable cost from the seller for obviously removing the items. Now, what we want to add here is there's a letter in the CAR zip form library that could assist you with this. And also, if you are dealing in property management or landlord-tenant affairs, this is a different law that applies to purchasing a property than if it's a tenant-landlord situation.
Correct.
And tenant-landlord is different. They must store the items for 20 days, but not in this case when it's a purchase. John, did you want to add anything?
No, I thought that was a brilliant handling of it. Basically, this is as is doesn't mean that you don't have to disclose. In fact, it means it means I'm selling you the property in the current condition. I'm going to maintain it. I'm going to keep the pool clean. I'm going to keep the landscaping and the grounds maintained. If you're the buyer's agent, you may want to take some photos so you can compare, because if you're 45 days down the line and there's a drought in California, you may have some issues. And I'm going to then, whatever I'm not leaving behind in terms of what we've agreed to, the wine refrigerator, the stove, the washer dryer, I'm going to take out, and then I'm going to broom clean it. You know, I'm not going to go and hire a super expensive cleaning service, but I'm going to make the property, I'm going to remove debris, I'm going to clean the property in a reasonable manner. And if I don't, you're going to give me a notice. As Linda mentioned, there's a letter, or you can simply send a notice that you've left behind this stuff, and this stuff. And if you don't remove it within 3 days, and delivery of how that 3 days looks is in the definition section, then I'm going to take you to small claims court. if it's less than $10,000, or I'm going to hire a lawyer and I'm going to come after you for, and I'm, you know, and if it's more than $10,000, you want to remember to send as part of your notice an offer to mediate, right? Because you're basically saying, I'm going to sue you after 3 days. Since it's more than $10,000, I'm going to take you to arbitration or real court, and I'm going to hire a lawyer, probably, and therefore I'm offering you a chance to mediate if you think there's something wrong with this picture. And you may want to, so what I would suggest you do is if the people that are telling you what it's going to cost to clean the property up, and it's usually going to be less than $10,000, if it's a regular house, then, but if you're going to take them to small claims, you don't have to offer mediation, and then take them to small claims court, costs you $12. Collecting the judgment may be a problem. I don't know. But, and then the next paragraph is equally important. What does it say? It's just another reminder that, and if you looked at the jury instruction, which we're not showing you today, it would say that the buyer has a duty to protect themselves, basically. So that's something they have to do. Okay, then next paragraph is closing in possession. We've already talked about that.
Mhm.
Oh no, we're moving along. We're going in the wrong direction. Okay. At the close, you're going to provide the seller is going to provide the buyer with all the keys, the fobs, the security systems, any passcodes, any intranet devices, all that, garage door openers, all that stuff. If it's a condo and you have keys to the laundry room or the workout room or whatever, you're going to provide those as well. Little tip, Linda, I don't know how you handle it, but if the seller gave the agent the keys and all this other stuff, have a little inventory list that as they're giving it to you, you can write it down so that.
You could put it in the verification of property condition, the VP, if they want.
That's a great idea. I hadn't thought about that. That's a great idea.
Mhm.
Yeah. Or however you do it, because I've had some hissy fits. We just settled one, this stupid case. The lawyer was, I don't know, I'm just like you guys. I get frustrated with other lawyers like you do with other agents. And this lawyer wanted to make a big deal about the fact that there was a gate with a remote. And he said, well, that's not a key. And seriously? And it ended up, he was just pumping up his client for money, because obviously this place had a guarded, not a guarded gate, but a gate to go to the property and all. He was trying to buy them time because they had horses to remove. All he had to say was, hey, we got horses to remove. Can we have a couple of extra days? But he was a jerk. So, make sure you understand that there are issues that do come up. They're usually not worth hiring a lawyer, but be very careful.
Yeah, but John, in the case where it's a homeowners association, a lot of times sellers have deposits on those keys. They will go to the association and get their deposit back, turn the keys in. So it does address the fact if it's a homeowners association, those keys necessarily will not be provided by the seller to the buyer. The buyer will be required to contact the association for those keys, like to pools and spas and areas like that. Remotes for gates to enter and things like that, because like I say, the seller probably has money invested in running, so to speak, those keys. So it does address that. We're going to move on to contingencies and removal of contingencies. Once again, it's addressing if the appraisal contingency is removed, and here's where it says buyers to act diligently in good faith to get their loan, and if there's no appraisal contingency or the appraisal contingency has been waived or removed, then failure of the property to appraise at the purchase price does not entitle the buyer to exercise their cancellation right pursuant to the loan contingency if the buyer is otherwise qualified to purchase the property and get their loan. So you've got to be very careful what you're directing your buyers to do when they're making offers. Releasing that contingency or for appraisal is a major, major situation.
And then the second section, the second paragraph talks about making sure that you understand that the property needs to be insured.
Sure.
And here's a little trap for the unwary. If you've already removed your buyer's investigation, contingency, and then you find out, let's go back one slide, please, Laura. And then you find out that the property is uninsurable. What paragraph 8A2 says is, look, insurability, if that's the right way to say it, is part of the buyer's investigation. Therefore, don't remove the buyer's investigation contingency, which most people usually think of as the disclosure, by a property inspector or all that kind of stuff. It basically also includes, go find out if this property and me are insurable. If it is, because there haven't been any claims or anything like that, then you're good to go. But if there's no insurability, you're going to cancel because it is part of your investigation, not because of some other aspect. And then again, if there's no loan contingency, that doesn't mean that you shouldn't do an inspection.
Correct.
So or get a loan and all that. So again, but the biggie here, I think, aside from the fact that they've emphasized a couple of things regarding appraisal and so forth, is the insurability issue. So let's move on to the next slide, please.
Correct. And we're back to appraisal again, and it keeps beating this to death, but I think it's real important in this market. That's why I say they've brought this contract into this market. And it says, for any cancellation based upon the appraisal contingency, buyer shall deliver a copy of the written appraisal to the seller upon request by the seller, because the appraisal is done for the bank. Bottom line, buyers a lot of times don't even get a copy of the appraisal, even though they pay for it. Buyers can obtain a copy of the appraisal upon request if it's not given to them by the lender, but the seller does not get that appraisal. So if a buyer is attempting to use it to cancel due to they did not release their contingency for appraisal, they have an appraisal contingency and they intend to use that as a cancellation, they must give a copy of the appraisal to the seller if the seller requests it.
Right. So if you're not sure that they're acting in good faith, ask for a copy of the appraisal. The other thing here that's interesting, and again, another little trap, is that if during the appraisal, the property does not measure close to the estimated or approximated square footage, you don't cancel because of the appraisal. You cancel again as part of your inspection contingency.
Correct.
It's a little complicated, not really, but again, you want to really look professional here. And you can, okay, the property was estimated at 5,000 square foot. According to the appraiser, it's only 4,000. That's way too small. You can go ahead and cancel. And the reason for cancellation is because of the measurement and the fact that the property inspection, the property is not what you told me it was. So there was really no meeting of the minds. All right, anything else?
I think we're done with appraisal after I just read what the attorney, when we were in our class, if the buyer removes the appraisal contingency and the loan cannot close due to that, that's a buyer issue.
Right.
I don't think anything more has to be said.
Look at this, we're at number 8 already.
Yep.
Of 32. All right, investigation of property again.
Right.
Just confirming that this is a contingency. This is a condition precedent to the obligation of the buyer to perform.
Next one.
Next slide, please. Review of seller documents. This agreement again is contingent upon a review, and of course the seller must deliver those documents. What are the documents, Linda? Do you?
Oh, yeah, it's going to be your, obviously, TDS, which is law. SPQ is not law, but highly recommended.
It's contractual. Yeah.
Correct. And then you have your WCMD, you have, I mean, there's a host of disclosures that come over from the seller side to the buyer side, depending on the type of transaction. So,
and you have 7 days to do that, right? You have 7 days.
Or QS, AS or QS, completely filled out on the AS, please, or it's not having the contingency satisfied for disclosure. And Laura, could we mute everybody?
Everybody, please mute yourself. Thank you.
We're getting a lot of feedback. So, yeah, everything that the sellers, and it's spelled out in the contract, exactly what the seller needs to do as far as disclosures go.
All right, next slide, please. Again, title, you're going to get, it's contingent upon the buyer getting a title policy. And so it's also contingent upon review of the preliminary title report, which must be delivered from whatever company the buyer wants, if the buyer's reference to company. And this is part of your fiduciary duty to go over the preliminary title report with your client. I'm going to touch on that today. Again, more risk management, but man, you ought to take what I do. Linda, I don't know how you handle it. What I do, because I don't get involved, like you do in day to day. But if we're dealing with a title policy, I always ask the escrow company to get me copies of any instrument numbers referenced in that policy, so that I can give those to the buyer. Maybe we need the engineer to look them over. Maybe we need somebody else. Depends on what it is, right? An example I saw recently was, hey, I want to build a pool in the backyard. Get the preliminary title report. You see there's all kinds of utility easements. Where are they? How do we chart them out to make sure I can still build my pool? That kind of stuff. So again, you're going to get a policy. It's going to show the easements and all that. If you do not, if all you get is the preliminary title report and you do not buy the insurance, you get nothing. The courts have ruled that a preliminary title report is nothing more than the abstract of what will be insured once the insurance is actually purchased at the time you close escrow. Okay.
Got it. And the other thing about title, we have a class coming up to teach our agents how to read a preliminary title report, because it's read by the TO, the title officer, then the escrow takes a look at it, but then the agent's supposed to look at it too. I had a transaction one time myself, and the TO and the escrow officer missed it. The property we were trying to sell was in bankruptcy. And it ended up, we had to go to court. Fortunately, it only took
minor detail.
Yeah, really. It only took a week to get it straightened out, but that could have been a nightmare for the seller, and it would have been up to the seller to fix that issue.
Many of the leading cases that we talk about when we do risk management arose out of a failure or doing it properly, either way, of going through the preliminary title report with your client. I believe that, and most people believe it is part. It doesn't mean you interpret it. You're not qualified to do that. It simply means you go over it and say, oh, look, you told me you're going to have a pool built. Well, there's a bunch of easements. Oh, look, there's a plotted easement, and it looks like there may be an encroachment over here. Let's go talk to an expert on what that means. And then this is one of those areas, Linda, where you have either 7 days or 5 days after delivery, whichever is later, to remove the contingency. Yeah.
Correct.
Next slide, please. Condos.
Well, we've dealt a lot with those today, and we won't beat a dead horse here. But yeah,
there's a statute. Yeah, there's a statute that says that the seller must provide certain documents. I think I put up a form here that I wanted to remind them about.
Okay.
Not yet. Okay, remove buyer review of leased or liened. Again, it's a 3-part contingency. Real quickly, number one is that you must, and again, it's, as Linda pointed out before, this subject is also covered in your listing agreement, where the seller is to tell you, hey, I've got a solar loan, or I've got leased pool equipment. Okay, so you've already know this, so you shouldn't be waiting till the last minute if you're the listing agent. But I'm going to tell you now within 7 days, hey, I've got leased or a special lien like a PACE loan or a HERO loan. I've got one of those. And here's the paperwork. That's part 2. I'm going to give you whatever I need to give you. And then part 3 is now the buyer has 17 days to decide if they can assume the lease. Does the bank require the loan be paid off? Because it was, not a loan that they really wanted to give. It was actually something given to them by the government or something like that. So it's a 3-part loan. All of this is actually in the seller property questionnaire. That's where you make the disclosure and then you move forward. I don't know if you have anything else to add to that, Linda?
Nope.
Okay, good. You can take the next one.
Already removal of the or waiver of the contingencies. This here warns the buyer, do your due diligence, do investigate everything, including the items that John just talked about. If you see a water softener system, ask the question, is that going to be here when the buyer moves in, or is that leased? Is it liened? Is it owned? What is it? And the buyer needs to do these investigations, because in bold it states, if the buyer removes or waives any contingencies without an adequate understanding of the property's condition or the buyer's ability to purchase, the buyer's acting against the advice of the agent. Now, I know
Right.
we talked about this before with John and at the state level as well, that why doesn't it say the broker, but they didn't change it. They said, no, it's the agent, because I guess the agent is the one directly speaking to the client and advising them, don't release contingencies unless you're sure of all the items that you need to be released.
And again, that's because the agent's the one giving the recommendations. But the reality is, if we end up going to court, the broker is going to be sucked into the lawsuit anyway.
Correct. So
Next
I'd like to take this one, John, because this is really
Oh, be my guest.
removal of the contingencies or cancellation. For any contingency specified below, buyer shall, with the applicable period specified, remove contingency or cancel. So when they're coming up to the 17 days and they're not happy, maybe with a response for repair, response for request to repair, the buyer has the right to cancel, but it has to be, like John pointed out, in good faith. But start using those notices to perform. You have to, when day 15 comes, do the notice to perform, put the buyer on notice. You need to release the contingencies and vice versa for any seller contingencies. I know people get upset. Buyers and sellers get upset when we recommend using the notices to perform, because I work with buyers and sellers through our agents every day. It's the agent's fault. When you're having these contracts put together, explain to the buyer how the process works. Explain, hey, you can expect, if you're not moving along when you should be in the contract according to the timelines, you're going to get a notice to perform, and vice versa for the seller. And that eliminates the seller saying, oh, I don't want to chase the buyer away, I don't want to do a notice to perform. Because if you're in a transaction, and I'll give you for instance, you're going through the buyer puts his money in escrow, not in 3 days, he puts it in on day 6, and contingencies were supposed to be released on day 17. Oh, they did it on day 24. Now all of a sudden the seller has to close escrow, so they put a demand to close escrow, and the buyer doesn't close in time. The demand is 3-day demand to close. The buyer doesn't close in time, and say that particular transaction goes to court. The first thing the judge or an arbitrator will do is say, well, wait a minute, it was no big deal when they didn't put their money in escrow in 3 days. It was no big deal when they didn't release. Now all of a sudden you want to close escrow on time, seller, because you may lose some money. Now all of a sudden you're putting demands. And from what I understand from the risk management attorneys that come and speak to us at our risk management meetings, they look at the whole contract, not just one specific item of the contract to make a ruling. So you better be following your timelines, and you better be using the proper documentation that is being told to you to use as you're going along through the contract. John?
Also, just one last thing, and I agree with everything Linda said, is that look at number 3. You cannot cancel as the seller without first giving the buyer a notice to perform, period. I've seen it time and time again where a seller tries to cancel, says, well, I don't need to give them a notice to perform. They're way over the time that matter. You have to first give a notice to perform, period, end of story. Don't argue with me, I'm a lawyer. And then you can cancel 2 days after that, or whatever period of time you've given.
They give them. And if the client doesn't do something for day 24 that should have been done, the seller has given them an extension by not putting them on notice. Now, putting them on notice doesn't mean they're going to cancel. It just says they may. And then what should be happening is the other side, whether it be buyer or seller, should be asking for an extension of time for that particular contingency.
And just so you know, the courts don't care how busy you are, right? So that's why I said, slow it down. They're going to look at this. Here's the deal. How can I say this? You've heard the story of the needle in the haystack. Plaintiff's lawyer is going to look for the needle, and that's going to be his case. And then the needle is going to have a really, really big picture. So they're going to find something you did wrong, and that's going to be blown up on the screen. So what you need to do, again, this isn't a threat or a warning. The bottom line is that litigation's actually been declining a little bit during the pandemic. So I suspect that's going to crank back up again pretty soon. But just be careful. It's not complex. You can't cancel without a notice to perform, period, unless it's the close of escrow. Then you can't cancel without a demand to close escrow, period. Just remember that. That's all you need to know. And then how you do it, Linda's going to explain later.
Yeah, and you can't make those notices any sooner than 2 days for the notices to perform and 3 days for the demand.
But you can send a notice on the 15th day.
Correct.
You can send a notice. It depends on what it is we're talking about. Or again, remember, this is one of those 5-day things where it's going to be 17 days or 5 days, depending upon when the paperwork is provided. Okay, let's go to the next slide, please. Here's the notice to perform. Not that complicated. How you deliver it depends upon what you've agreed to as to whether the agent's going to be involved or not. But again, on the left-hand side are all the contingencies and A through H. So there are 9 of them. Then, of course, if you've added a few contingencies, maybe the husband is overseas or the wife is traveling on business, or I don't really know, whatever it is. Then on the right-hand side are all those contract issues, putting in the initial deposit 3 days after, increasing the deposit, verifying all cash, which hopefully you've done with the offer. But all those things are not contingencies. They're contract promises. So if you end up getting canceled because you failed to do one of those, there's a good chance you're going to lose your deposit because you've breached the contract. And so which boxes are you checking off? Seller is, and then are you going to do more than one because they're numbered, and then you deliver it, period. Not that complicated, right? It's complicated because you lost track of time, and now you're on the 23rd day because you screwed up because you forgot to put a reminder to yourself that on the 17th or 15th day, you needed to deal with this and remind your seller. Now, if your seller's sophisticated, they've already done that. I know that when we entered into the transaction to sell our home, I knew exactly what day, and I was calling my broker 2 days ahead of time. Have they done this? Have they done that? Right? But most clients aren't going to do that. You got to keep track. I asked one of our favorite people yesterday, Linda, so I'll ask you the same question. Mm-hmm. I'm guessing there are programs available to the agents that will help them keep track of time.
Yes, we actually, in our company, we use SkySlope, and the tasks are done by the transaction coordinator upon her getting the contract in her hands. So she gives specific, and you can go into the task bar and look at specific dates. Everything needs to be done according to that particular contract. It's not just any contract, it's according, because they may shorten the timing in the contract or lengthen the timing. So the date, it is required. And then we try to tell the agents 2 days in advance, you may want to do a notice to perform. This date is coming up. So we kind of give them a heads up. So I know
my program, which is different, obviously, because we're lawyers, but this is the same concept. I get a reminder. I just got a reminder that that Monday, I'm supposed to provide the edits to my newsletter. I got a reminder today that I'm going to have to do that. So I can put it on my list of nag things that I got to get done, right? So that I can keep track. Then if I'm not going to be able to get to it, I can say to somebody else in the office, hey, can you handle this for me or get me an extension? Because you know what? I can't be in 2 places at the same time. Now, for you, that means picking up the phone with the other agent after you've talked to your client and saying, hey, you know what, my contingency period is coming up in 3 days. Can we have more time? Then you do an extension of time addendum.
Correct.
You get that all squared away. All right. Anything else?
And
Linda?
just one other quick thing with the notices to perform. I've had agents say to me, well, I put 2 notices to perform on them. Only one is required. If you put the notice to perform to release contingencies, say on day 15th, they don't release until day 17, and the seller's so inclined to give them another week. To cancel them, they don't have to do another notice to perform. After that time, they can then send a
You
cancellation.
can actually refer to that on your extension of time addendum. You can say we're extending the period of time to, and now you can use a specific date because you know, right? You can say till Monday, the whatever Monday's date is, the 12th of December, whatever it is.
Correct.
If you fail to perform by noon on that day, then I will have the right to cancel at my discretion. Okay. And then the only other time you might want to renotice a notice to perform is if there appears to be a waiver where you send a notice to perform, then things happen. But again, you're going to have to play that one by ear. But that's the form you're going to use right there. Next slide, please.
Got it. I think we've taken care of that.
And I think I've put this form up. There it is. This is the sale. Again, go back one slide, please, Laura. I'm sorry. I want to see what that said.
The sale of the buyer's property.
Right. This is again, it won't be applicable to every transaction, but because it defaults to no contingency, right? But if you have a contingency, go to the next slide, please. This is the contingency. This is the COP form, the contingency for sale of buyer's property.
And it's been extended to a 2-page document and lots of details. You have to read it, have to pay attention to how you're protecting your buyer or your seller. You have, and just because this comes in asking for the world or the moon doesn't mean the seller has to agree to it. The seller can go back and say item number so-and-so is to apply. Not
I'm going to pick your brain, Linda, and then I'm going to do a rant for Laura to put on the associations, whatever you do with my rants. So I think this needs to be revisited. This is one of those forms. I think this one and the TOPA form, the tenant occupancy form, are, in my view, the most complicated because you're trying to figure out what's gonna happen.
Exactly.
Right? You know, it's the crystal ball form, this one in TOPA, because you really don't know what's going to happen yet. You know, are you going to go into escrow? Are you going to, what are you going to do? So again, I think this is a very complicated form. So for those of you that are newer, get some help. Talk to the Linda DiStefano of your office. Get some help because you don't want to make a mistake on this if you can possibly avoid it.
Right. You don't want the buyer to lose the property or the seller to be stuck in an escrow that's endless.
This is a form that is not referenced in the body of the contract. This is for you listing agents where you're going to represent a seller and the seller has said, I have not found replacement property. Now, my wife and I knew we weren't going to need this because we were getting a house built. Well, let me tell you what, I lived in a hotel, Laura knows this, I lived in a hotel from mid-March to the end of April with 2 golden retrievers. It was not fun. And so you don't want to get stuck in a situation where your seller is, I won't call it homeless because that has another connotation, but is homeless, right? And so this is a contingency that is there for the seller. You should note it in the MLS remarks that my seller is going to want a contingency for the defined replacement property. And then this one gives them choices. Is the contingency satisfied when they put the property on the market, when they make an offer and it's accepted, when they close escrow, when? So, you know, they've added some things to this. So take a look at this form. This is for those of you that list property and the seller has not yet got a target property in mind.
And John, I think the most important part of that particular form that I see is that the buyer should know that they should not start spending money on a house they may not be able to buy because the seller by day 17, if it defaults, if you use the default time, by day 17 can't find a property to replace.
And this form defaults to that. This form is, the seller is saying, you don't have to start until I remove this contingency.
Correct.
Give me a notice, and then one day, I think it's one day after, and this contingency can be 17 days, it can be until I go into escrow or until I close escrow. That's the seller's choice. And so basically you got to think about the time elements of that, because if I'm a buyer and my seller has said, you know, that I'll remove this contingency upon the close of my new house, that could be a while. That could be a while. So be careful about that. Let's go to the next slide, please. I don't remember which one this is. Let's see.
Items included and excluded from the sale. I think we've already alluded to this as well.
Right.
Make sure it's 3 places: in the listing contract, in the MLS, and also it has to be written or indicated somewhere in the purchase contract between the buyer and seller, because the other 2 documents are not party to this agreement.
That's exactly right. And that's really the bottom line. Like with the allocation of costs, I'm not agreeing to who's going to fix it. What this one is saying is, I'm advertising that it's including the pool table, but until it's in the contract that it includes the pool table's not included, or the chandelier or whatever it is. So, and again, when you sell the property and those items are included, like for example, if you're going to include the flat screen TV or a washer and dryer, and there's still a warranty in place, then that's also assigned to the new buyer.
Right. And the bottom line there is any items included herein are components of the home and are not intended to affect the price. All items are transferred without a seller warranty.
And see right there in the second to last line where it says, or as otherwise agreed. And otherwise agreed is capitalized, which those of you that are English buffs know you don't normally capitalize the phrase otherwise agreed. That's because when we get to definitions, it's a defined term.
Correct.
Whenever you see capitalization, it's either a proper noun or it's a defined term. Okay, moving on. Moving on up the road.
Okay, items included in the sale. Obviously, like John pointed out earlier, when we were in the grid and there were additional things that the sellers and the buyers can agree to leave or take or whatever, this is being more specific than it's ever been. And I want to share with you, I had a situation where one of my agents was buying an investment property, and the listing side insisted that the curtains on the rod did not go with the property because they slid onto the rod and they became personal property of the seller, which I knew was not the case. So I called, long story short, I called the CAR attorneys because the buyer, one of my agents, wanted the curtains because they matched some other items in the property. So the agent sent back a description of what a window treatment is and all of this stuff. And the broker got involved and said that maybe the buyer, which was one of my agents, buying an investment property, could maybe give the seller a nice gift card so they'll leave the curtains. And I'm thinking they belong to the buyer, which they did. Well, now, if you look at the existing items included in the sale existing, because I'm sure I wasn't the only call to the CAR attorney regarding this, window coverings now after it in parentheses says, which includes the blinds, the curtains, the drapery, the shutters, or any other materials that cover any portion of the window. So if you were previously giving bad advice regarding what a window treatment or a window covering is, it's specifically spelled out in the anything that's on the window or around the window stays with the property, unless it's excluded and everybody agree.
And all of you have your own idiosyncrasies or issues that have come up. I know Lynn and I have a mutual friend, and she's always concerned about the brackets and those kinds of things. Again, you need to read this page. It's a great definition of what stays, what's included, what the fixtures are. It expands now. This is all new. It expands definitions of what the security systems are and all of that. There's a page or paragraph number 4 now talks about home automation. You know, this is a brand new house just been built where my wife is just finishing it because it was one of those you can move in and then customize it. And the house is smarter than I am. Well, that's not hard to do, but you know, I got stuck outside the other day because I couldn't remember how to use the locks, right? All this stuff. I have to have my grandchildren show me how to use the TV. I got 27 different remotes. So all of this stuff is really important nowadays. Non-dedicated devices, all that stuff. Then there's another section, which is 6, which talks about the leased and the liened items. All of that, by the way, disclosures can be found on your SBQ. And then it talks about, again, seller represents that all items included in the purchase price unless otherwise agreed. So maybe we don't agree that the chandelier is included or the this or the that. But again, some things, you know, in the mind of the buyer, I'm buying the house with all that stuff. In the mind of the seller, I'm going to have a garage sale and sell it all, or I'm bringing it with me, or whatever. You know, again, and you guys need to understand that the basis of all contract law is the meeting of the minds. And you need to get those minds met, or you're going to end up with issues that very possibly you're going to pay to solve. And so you want to take care of that at the very beginning. It's not complicated. It's a great contract. Says it all. You got to read it and then deal with it.
Yeah, and John, want to point out the 9B2 section talks about even the light bulbs. Remember, now we have smart light bulbs, and buyers are going in properties and the house is equipped with all these smart light bulbs. They move in or they go to the walkthrough and the seller took all the light bulbs out and put all the regular light bulbs.
They're expensive.
Creating problems, major problems. And you don't want unhappiness at the end of your transactions. You want everybody to be on the same page and understand these things.
Right.
So explain them to your sellers so they don't do these things, and explaining what the buyers should expect when they go to the walkthrough. Also, items should be listed as being included or excluded per paragraph 3P, taking you back to the grid, or excluded by a seller in a counter offer. So it also says that.
Again, Linda pointed out before that it's really important that you have your buyers read this stuff. Get it to them ahead of time. Put together a package of things your buyer's going to want to see and your seller's going to want to see. You know, those packages are important. But they've really expanded this area. They've cleaned it up, and it flows much better now. And it talks about all the different issues, again, as much as a standard form contract can. Now, you may need to modify it a little bit, simply because there's a unique issue in the transaction you're dealing with. But if you understand and read this stuff more than once, I know, Linda, you've probably read this contract at least, I don't even want to fill in the blank. I'm so tired of it, frankly. And I'm not really tired of it, but it's, you know, it's getting cumbersome. But it's kind of like this. You know, people say if you read the Bible much times, you're going to see something new every time. It's true with this contract. Every time I read this contract, I see something new and something I didn't notice before. So read it over again and again and again.
John, I've started saying at the beginning of all my training, if you know nothing in this business as a real estate agent, if you know nothing, you better know this contract, because you don't only need it to write it with a buyer, you need to explain it to the seller what they're agreeing to. So you need it whether you're a listing agent or a selling agent. You need to know this contract. And
in a lot of ways, brand new agents are better off than old agents.
Correct.
Not old agents, but more experienced agents, say, because they don't have to unlearn anything. Correct. Right? This is a brand new contract. Everybody starts at the starting place pretty much at the same time. All right, let's move on to the next slide, please.
Because this next slide is going to show you that the contract has changed in this area. Brackets now go with the TV.
Right.
In the current contract, they don't. The brackets attached to the property, not the TV. So a buyer in the old contract thinks, oh, I don't get the TV, but I get the bracket. Well, in the new contract, no, they don't. So brackets now go with the TV. And it states here in bold, unless otherwise specified in paragraph 3P1, back to the grid, brackets attached to walls, floors, or ceilings for any such component, furniture, or item will be removed, and the holes or other damage shall be repaired but not painted. So you got to give the heads up to your sellers. If they're taking their TVs, they have to repair the wall.
Okay. All right, next slide, please.
You want to check this one, John?
Basically, inspections and reports, this simply says what we've been saying before, that until otherwise agreed, all you're agreeing in the allocation is that you'll go get the reports and that somebody's going to pay for them. And again, our agreements for payment can be covered on the forms referenced there, the request for repair, the RRRR, the ADM or the AE. I don't remember, what is ADM and the AD? I don't remember what those are.
An addendum?
Probably addendum.
And then, yeah.
Again, we can look that up, but I would use the RR. That's really where you're going to most of the time agree who's going to pay for the repairs, so that you get your wood destroying pest report back, or you get your environmental report, or you get whatever you get, your inspections. Whoever's paying for them, that's all you've done. So even if the seller agrees to pay for them, that's all they're agreeing to do. That's the thing to take away from this paragraph. So we can go to the next slide, please. We are a third of the way through. This is the request for repair form.
Yeah.
This has been revised a couple of times.
Yep.
I don't think it's being, I don't recall.
Yeah, it is. It's being revised because the FVA form is going away, the FHAVA form. So that is going to now be included in here. Any required repair items per the appraisal for FHAVA loans. So there's going to be a section that'll let that FVA form go away.
Okay, so again, I didn't put it up. Apparently, my paralegal didn't see it and I didn't catch it, so I apologize. But that's the current form. You're going to get a new one with a modification. By the way, one other form we didn't put up today is the SBQ. That's also being modified. They're taking some of the stuff and they're rearranging the flow of it, so just be aware of that. While I'm thinking about it, I wanted to say that because I don't think we put up the SBQ. Okay, let's move on.
That's
and this is the RRRR. And again, this is the 1218 version. Is this one being changed to, Linda? I don't recall.
I don't recall anything about that.
I have the list. While you're talking about it,
Okay.
I'm going to look it up and see if it's being changed.
Yeah, you have to remember when you're using this RRRR, and they refer to this as the pirate form, like you're going RR like a pirate. But anyway, the seller's response for the buyer's request for repair. Always remember on the request for repair, you have to refer to this document. So the seller may have to check the when they're responding with the RRR. On the RR, they have to check that, hey, see the RRRR for our response, or the seller can just agree, I'll do everything for you, buyer, and check that block. But most times they are responding with the RRRR. The RRRR will say they agree to replace or repair or fix or credit. Or any other decision that the seller has decided to make. Then the buyer then has to reply to the request for repair to the seller. So it's a back and forth form.
Make yourself a note. This form is also being modified in the manner that Linda just referenced. So I apologize. Apparently,
so the FHA-VA situation.
So there's going to be that minor revision to it.
That makes sense.
Yeah. Okay. Next slide, please.
Okay. Government required. John, you want to take that with being legal side?
Well, there's something totally unrelated to the contract that I say all the time, and Linda, I know you and I have had this conversation, and that is because government is getting more expansive, good or bad, you pick. I'm not a political comment, it's a fact. Government is getting more intrusive, particularly in areas where the housing stock is older, and they're making more requirements for point of sale inspection, for remedial action, whatever it may be. It's a reason why you want to be very careful about moving away from jurisdictions you're not familiar with. You should know what those requirements are in the community where you primarily practice. But if you move out of that community, particularly into an area that is more government centric, say I tell this to my people in Temecula and Orange County all the time. Be very careful, because if you're going to go to LA or God forbid San Francisco, you have a whole nother world of government oversight. And that may be a good thing in your mind. I'm not going to comment on that. But again, there are legally required installations. Okay, what are they? This talks about the fact that it's got to be done within a certain period of time, 17 days after acceptance, not any longer, before the close. There are point of sale requirements, right? Sometimes you have to notify the government to come out because you're selling, and they'll do some type of a request to fix or simply do a report. Who gets the report? Who pays for the report if there's a cost? All that's going to be taken care of in this paragraph. They've added, as Linda pointed out earlier, a reinspection fee paragraph, and that is 10B3. And 10B3 talks about the fact that the seller may have to pay for a reinspection. If there's a government requirement for some type of an inspection, and then the government guy has to come back out again, then this provides that the seller is going to pay for those costs unless otherwise agreed. So you better be aware of that. And then again, buyer and seller are advised to seek information from known sources, because this goes along with that idea that you're not responsible to check permits, offsite, and other types of things. Why? Not because it shouldn't be provided to the client, but because you're not qualified to catch everything. I was on a city council of a city that was formed from an area that had been part of the county for a very long time, which meant all the records for all the houses that had been built prior to that time had to be transferred from the county of Riverside to the city of Canyon Lake. And let me tell you what, it was a mess, right? It was a mess. Documents were everywhere. And so you want to be very, very careful about those kinds of statements, but you also want to make sure your client gets the proper information and that you understand what reports are going to be needed and what kinds of inspections are going to be required. And then, of course, invoices will be provided to escrow and all of that. You can read this paragraph. There hasn't been a lot of significant changes, except I think they added the reinspection fee requirement. Okay, moving on then.
John,
Okay,
one second. There is a question, and before we get too far away from the request for repair, I want to answer it for Jin Wu. Does the RR have a time period for the seller to respond to it? And they had a case where the seller didn't respond to the RR, and I'll get into that in detail. And then the buyer received a notice to perform. Well, let me explain. And my agents laugh at me when I put my hand up like this, but the seller has choices when they get a request for repair, because they're selling the property and the buyer's buying the property as is. The seller, as a response to the request for repair, can say, yes, I'll do everything. No, I won't do anything, or vice versa. I'll do some things, I won't do other things. I'll give you a credit towards any repairs if the lender allows and it doesn't exceed the limit. And what's the fifth thing? That the seller can respond. They don't have to respond at all. And it's in writing in the contract. So the seller's selling the house as is. They don't have to respond. So your answer to, does the new RR have a time period? No, because there's no response the seller has to give. Now, as a courtesy, we always, for our sellers, always tell the seller as a courtesy, respond, say no. And if they don't respond, the answer is no. So does the buyer, because they didn't hear back from the RR, have the right to cancel? Yeah, perhaps. Perhaps they do. If they're not happy with the house, the way they didn't know that everything was broken, everything looked like it was in good condition, the inspector went in, everything was broken, and the seller's not even willing to respond to them, and they haven't released contingencies, that sounds to me, John, like they have a good reason that they may want.
I was saying, sarcastically, I would say a notice to perform is pretty clearly a rejection of everything. I'm doing none of it, but I agree with that. I think, I wish they didn't do that, because Article 3 of the Code of Ethics says you have a duty to cooperate with each other for the benefit of the client. But the contract specifically says I don't have a duty to even respond. Now, and so I think that creates a little hole. I mean, you can always put in your request for repair that please respond within X number of days, or we will deem it a rejection and we'll act accordingly, right? I mean, you can do that. And then, of course, you need to be having an adult conversation with your buyer. What are we going to do if they do one of the things Linda said on her hand, right? And so that's something, again, I love this device. It does all sorts of cool stuff. And you got to communicate with your clients and document your file, right? We spoke about this. If the request for repair comes back with less than whatever it is, you've advised me, and I'll confirm it when we get it back, but you've advised me you intend to cancel. Okay? And that's the bottom line.
Right.
Okay. Anything else?
Next one, nope. Home warranty, I'll take this one. Home warranty, this is where I had a lot of issues with the way they laid out the grid regarding this, but they did give us some lines. Now we can write in whatever it is that the buyer would like to have as part of their plan. But here is where you're going to find that it now says the buyer shall pay any cost of the plan chosen by the buyer that exceeds the amount allocated to the seller. So it's in writing now. It is not in the current contract. It leaves it up to negotiation, and which can be an issue. The buyer says, I want the air conditioner, I want the pool, I want this, I want that, and then only ask for $500. Well, that in this day and age, that's not going to cover it all. But then what? Seller, you said you'd offer me the home warranty, but now you're not agreeing to pay all of what I want. Well, now it's specific. If it exceeds the amount and the buyer wants these items, buyer, you pay for the addition over what the seller's willing to pay, if the seller's willing to pay anything.
Okay, I agree. Yeah.
And it did, the attorney did say that the agent should help the buyer, letting them know what the options are. And what I would recommend, and what we recommend here at our company, is give them a brochure from a few different home protection companies, because they don't know what a home protection plan covers. And this will give them all of the items and the cost.
And don't oversell, because again, they exclude a lot of stuff. Okay, moving on to the next.
Statutory and other disclosures.
Well, yeah, but before we do that.
Yes.
Here's the deal, because we're not going to spend a lot of time on this, because we're going to probably do, I'm not speaking for Laura. She may tell me I'm wrong, but I have a risk management class. It's my least favorite class to teach, because it is the most complicated class to teach, because risk can come from anywhere. I think this is one of the finest forms CAR has ever produced. Why? Agents don't know what to tell their clients about how to fill out disclosure forms. These are incredibly legal, complicated things to do. So they've given you an out. Because agents are, if 85% of lawsuits arise post-close because of disclosure, I would tend to put my money on disclosure if I were a betting man, which I'm not. This form is the form that you would give to your seller as soon after you get the listing as you can, so they don't have the excuse, I didn't have time to read it, right? And you're going to tell them that when we get an offer, we're going to, and if it's accepted and we go into escrow, you're going to have to provide at minimal 2 disclosure forms, a document called a transfer disclosure and another one called the seller property questionnaire. Even if the contract is exempt because of some other statutory reason, we're still going to have to provide what is called the exempt seller disclosure. And here's how you need to be prepared to fill those out. Boom. You give it to your clients, you say, read this over, and then I can answer questions. If I can't answer questions, our company attorney can answer them, or your attorney can answer them, right? Because these are inherently legal documents that lead, and the failure to do them properly lead to substantial litigation. And it talks about an introduction of what we're talking about, talks about how to prepare to deal with your disclosure obligation. It talks about instructions for completing the disclosure forms. Moving on to the page 2 of 3. It talks about completing the TDS, right? There's sections of the TDS. You have section 1, you have section 2, you have section 2B. Each one of those has specific requirements. People fail to check off boxes. They leave things blank. They don't understand what that a disclosure doesn't mean you're agreeing to fix anything. There's a place on the form to say, you know, I get asked this question all the time. What if I never lived in the property? There's a place on the form to deal with that. And this tells them all that. Then it talks about the seller property questionnaire, which is a much deeper dive into disclosure. As Linda pointed out before, the TDS is statutory, can't be waived, can't be waived. Let me say it again, can't be waived. Whereas the SPQ is not a statutory form. It is a form created by CAR, and it arose out of a form that was originally introduced down in San Diego for many, many years, and they just made it better, right? And so it talks about lots of things in the SPQ, and it's contractual, so it can be waived, although if you get a counteroffer waiving the SPQ, put up a really big red flag, right? A really big red flag. So assuming you're going to do it, then this tells you how to complete the SPQ. And then the last section talks about how to complete a exempt seller disclosure, which of course will not be applicable if the TDS and the SPQ are applicable. This is for banks and things like that. So again, this is a really good form, but it's only a really good form if you do 2 things. Number 1, read it. Read it, right? Read it again and again and again, so that you can know when you should answer questions and when you should refer them to somebody else. Number 2, give it to them as early in the game as you possibly can, and put something in writing in your listing package or however you guys do it that says, this is a really incredibly important form. Please read it very carefully because I cannot fill these forms out for you. And then don't ever fill out the forms for your clients, right? Anyway, enough about that. Or better yet, don't do any of that. And then keep my card handy, right? All joking aside, you're going to get sued. Most likely, post-close is going to arise out of the issues relating to disclosure. Okay, let's go on to the next slide, please.
Yeah, and John, you mentioned the TDS several times, and what Neil said at the time we were going through our class is the TDS is only complete when first section 1 is completed, and 9 times out of 10, you're going to check the no substitute disclosures block. If nothing's checked in that section, it is an incomplete TDS and it is not legal, and that's a legal form that needs to be used.
Right.
Also, when the 2 agents in the transaction, they're at a minimum complete page 3 of the TDS, or like our broker requires an AVID. So the TDS is not considered complete till all of those plus the seller in their own hand answers the questions, and they have to complete every question, not just fill out what they like to fill out. They have to answer every question. So the TDS then needs to be complete by day 7. We get agents on the other side of the transactions that say, oh, we'll get that AVID over to you soon. No, you need to have it there within 7 days to complete the TDS. And
Well,
that's a law form.
There's a couple things there. You made some really, really good points. Here's the deal. Number 1, if I send an incomplete or inadequate form, then I haven't satisfied the statute, which means the buyer retains the right to cancel, period, end of story. Okay.
Correct.
Number two, if I rush it first, if I wait till the 7th day, which is perfectly okay, then the buyer has the right to cancel, unfettered cancellation, regardless of whatever else they've done, maybe not provided the down payment or some of the other form. They have an unfettered right to cancel. So why wait till the 7th day? If you've taken a listing, then you want to get these things filled out as soon as possible. Then as far as if your office doesn't use the Avid form, which the box says, check off the box and see attached Avid form. How can I say this sensitively? Because I know Laura's here and she's my boss. You're stupid. Okay, it sets the standard of care. That really does set the standard of care. That's why they did it, because every office was doing their reasonably competent, diligent inspections differently. What they did is they brought it all in under one umbrella and said, this is the way we do it in California, right? Do it this way and we're going to be pretty good, right? Not perfect necessarily, but pretty good. Yes, I do, Sherry. A big problem, and we can talk about it offline. I don't know who Sherry is, but anyway, I just really think you use the Avid form. I don't know. I've not heard yet. And I don't know, Linda, if you disagree with me or not. And I really didn't mean stupid. That's not a good thing to say. Really dumb would be better. But I think that the Avid form is as mandatory a form as you can possibly use, even though it's not mandatory. Sherry's broker does not have to require it.
No,
I can say don't use it, but boy, he better have a good reason, or she better have a good reason. What do you think?
I agree. Totally agree. The AVID is the best thing that they could have done with that TDS to assist us agents, and don't diagnose. That's another whole seminar, John.
Yeah, there's a whole seminar on.
Don't diagnose, just state what you see. Another thing in this section, and it falls under 11A1, the last section, and it's your fire hardening and defensible space. That's law as of May 2021.
Right.
Just know that
changing again in July of 22.
Correct. Yeah, changes are coming, but you have to remember, more than likely, I know our brokerage uses this form as an advisory at minimum, but they have to check the block if the seller is not in a fire hazard area. But if they are in a fire hazard area, again, that seller has to, in their hand, answer those questions on the form. Please do not be checking blocks for sellers. Then it becomes the agent's disclosure to the buyer, and I wouldn't want to be putting myself in that briar patch. But anyway, they also alludes to the fact that the FLD form is changing names. Finally, they're going to name it lead-based paint disclosure is exactly what it is, and it's going to be the LPD form. So that is also a statutory form. But if the property is built in 1978, do not have that form as part of your documents. It's prior to. Don't put a form in your transaction that's not required or it's not involved in the don't be, because it's a disclosure, I want to over disclose rather than under disclose. That's more of a problem than under disclosing, actually. So don't just randomly send disclosures. Make sure that they're the correct disclosures and the ones that are required, especially the ones by law.
I think the key word here is statutory. Every one of these forms has a statute, whether it's a state statute, which is most of them, or a federal statute, which is the lead-based paint. And that means that just because I'm exempt from a TDS doesn't make me exempt from a lead-based paint. What makes me exempt from a lead-based paint is the house was built after 1978, right? And so you've got to understand that. And when you have questions about this particular section, then you have your broker contact his lawyer or her lawyer, or you deal with it, because these are statutory. And it tells you when you can waive it. It tells you how to do it. And so I think they're critically important. We can go to the next slide, I think, because these are risk management issues and they're critical. lead disclosure, as Linda mentioned. There's a new form coming out, and it's going to clean things up a little bit. And again, it's recommended that the buyer do again, if it's a 70, a December 31st, 1977 or sooner property, that you do a risk assessment, because you know what, maybe the house was painted, there's no risk. Maybe it's still the original paint, and you got little kids and lead chips are not good for them, right? So you want to know that before they close escrow. And this is a new paragraph in the contract, right? Revised paragraph and a revised form as well. Home hardening, Linda already mentioned, and there's going to be some additional disclosures. And again, we're going to do some new law highlights in a newsletter. But again, this stuff is very important, and there's going to be some changes to the to some of the whole concept of how these disclosures are made as we move down the line. That's very, very complicated. And this defensible space is going to be a change in July, but for right now, this talks about how to do it, and they've modified some of the forms, and of course the fire hardening disclosure. And then there's going to be an addendum, and sometimes it's going to be the buyer that's going to take care of some of this stuff post-close. So again, without going into a risk management class, just understand that they provided for in the contract, but these are really separate disclosure. I suspect, Linda, that sometime before July 1st, they're going to modify the RPA, because there's going to be that new appraisal. There's going to be a new appraisal discrimination disclosure requirement that's going to say to the parties, if you believe your appraisal was done in a discriminatory manner based on one of the protected categories, you must, this is how you should report that. That's a mandatory disclosure that's coming out sometime not sometime, it's coming out on July the 1st, which means I suspect that they'll change this contract or provide a separate disclosure before that date.
Right. John, why don't we take a break, 10-minute break now, and then we'll come back and complete it. And I think we'll get through it. Not a whole heck of a lot left that we haven't talked about, but we have to finish on. So,
and again, I just want to reiterate this so we can start with the next slide, but you can't waive if the contract, if the law requires a TDS to be done, you can't waive it, period. I don't want a TDS. I'm just going to tear the house down. Too bad. Too bad. I'm buying this as an investment, and I don't need a TDS, but there happens to be a single family residence on the property. Too bad.
Too bad.
Too bad. You cannot waive it, period, period, period.
And John, I get the question a lot from my agents. Well, Linda, it's only 3 units, and 5 and above doesn't need it. Do we need? Yes. 1 to 4 need a TDS for each unit.
There's a case, Richmond versus Hartley, I think his name. Don't quote me on that, but there's a case where the buyer sucked the seller into more than a year of extensions and lies. And it was a commercial transaction. They didn't even use CAR forms. They used the commercial forms, and it was a large piece of property. On the property were 3 units, right? Then the buyer canceled. The seller sued him for breach of contract, and we're talking about a significant amount of money. Significant amount of money. The court ruled in favor of the bad guy buyer because he had a better lawyer. Because the lawyer pointed out, hey, wait a minute, this property contains 3 single family units. The statute says you do a TDS if there's 1 to 4. Never did it. The court said, then unfortunately, Mr. Bad Guy, you retain the right to cancel because the TDS is a 3 to 5 day cancellation right. Don't think you can waive this contractually. You cannot.
Right.
All right. See you guys in 10 minutes.
Yeah, 10 minutes. We'll see you back here.
Look forward to it.
John,
Yes, ma'am.
I'd like to take this next section, the withholding taxes, because we deal with this a lot.
Please.
Okay.
And then we can skip over a bunch. I noticed that,
Yeah.
that in
because
terms of the changes,
Yeah.
let's see, we're on 11E now.
Mhm. Yeah, there's not a whole
Yeah,
lot.
there's
There are,
nothing in 13. And then you go from 14 to 21 and there's nothing.
okay, but there are some items I wanted to address on the next page, which would be
Okay, you got an hour and a half to do it.
Okay, contingency removal is going to be updated. And these are just quick things, but yeah. Okay, we'll just touch on the items that are changes in the next few pages.
Okay. All right.
Linda,
Yes.
Bina texted me. She asked a couple questions that didn't get answered. So I
Okay.
told her to unmute herself and just ask you guys the question.
Sure, as we go back in, which we'll do that right now. Let's get started because we have a lot more to cover and a very little amount of time in comparison. So Bina, can you unmute and ask your questions? We'd be glad to answer. I'm sorry I missed them.
Oh, okay. It's a.
No worries, no worries. My question was going back to home warranty.
Mhm.
Does the listing agent broker carry liability when they on CRM on MLS state that the home warranty to be seller's choice versus the buyer would like to choose their home warranty provider?
Yeah, see, what we hear from sellers, and I'm coming, remember, I'm coming from practitioner like you. John's coming from legal. So I'll answer first, and John, you follow up if you will. I would say no, because they're paying for it. And that's what sellers say. Look, I'm paying for the thing. I should get the right to say what the company is. But John, would there be liability in the seller in that case?
Well, liability means that I have been negligent in some fashion, and now I have a duty to pay damages to the party that's bringing the claim. And I don't believe, unless you're steering for some benefit.
Other reason, yeah.
So like, let's say, and I'm going to pick on them, I know, because they're friends of mine. Say Old Republic is giving you something under the table, and as a result, and I've seen it as little, frankly, as gift cards.
Yeah,
you know,
yeah, that's
that could raise liability, not because of any other issue other than, the argument is going to be you're steering them to me, and you failed to disclose to me that there could be, that you were making money.
Yeah.
Or you knowingly send it to, but again, these are big companies, so it's not going to be the case. So that'd be the only thing that I could see. My personal belief, Linda, and you could argue with me and be 100% correct. I believe that that if there's a debate, the seller should get to pick escrow because it's still their house. And as long as everything is on the up and up, and the buyer should be able to pick the title company because they're the ones being insured, and they should be able to pick the home warranty company because they're the ones being insured. But again, some of these things are no big deal, but there are differences in those things. Again, whenever I get asked the question, is there some legal? No, there's really not. It's just a question of negotiation. And frankly, in today's market, if the seller wants to pick, the seller's probably going to get to pick. But I do believe that I'm looking at I don't care about who pays for the service. But who's benefiting from the service? Well, both parties are benefiting from escrow, but the seller still in control of the house. But the title company is issuing a policy to the buyer.
Yeah,
I understand there are cost differentials.
Yeah, and John, a lot of times before we put property, just to fight on the seller side, naming title part. Just to fight on the seller side. There's a lot of work that gets done before we put a property on the market. And it's usually our title rep that's doing all the running and the fixing. I know myself, I personally right now have a manufactured home in escrow, and my title rep did all kinds of jumping through hoops and helping me get that property on the market. It would be unfair that he now get paid for his work. And that's just where a seller I would come from.
And that, I just finished a case with the Department of Insurance. Because again, I look at things differently than you guys do. And, obviously there's not going to necessarily be uniformity of agreement on some of this stuff. But I know that in the case I just finished, the Department of Insurance was sending out letters, including to my client, because this title rep was providing stuff to agents in exchange for which he was expecting to get business.
Yeah. Well, this was
the Department of Insurance was not this was a this was a title, they have jurisdiction over title insurance companies here in California, and they were not happy with that. So again, it's rare that it becomes an issue, at least in my world. But I don't think to answer Bina's question. And hi, Bina, how you doing? I hope you're well. I don't see any real liability unless there's some steering involved.
Correct.
For a financial benefit.
Agree.
Right,
Bina,
and that's what I have seen when I've spoken to the listing agent, because I'm on the same page with you, John. It's really the end user. While the seller may pay, end user may get the short end of the stick. And honestly, I have homeowners who are now buyers that have already had experience with XYZ home warranty company, and they don't want to use them.
Yeah.
And the listing agent says, yeah, but I've been doing business with them for a long time. Well, that's fantastic. But you're not the user of that home warranty policy.
correct.
So
that's my belief.
That's my concern.
Correct.
It's a subject for negotiation. Maybe you give there and you take somewhere else. But again, it really depends upon your negotiating skill. But all things being equal, if everybody's being nice, which happens probably in 1 out of 100 transactions, then what you're doing is you're saying who's the end user and who's going to benefit from the service. I personally, for me, when I negotiate, I do have title companies that I want to use because I've dealt with them for 40 years and I know how they operate, and you may disagree, from your perspective. I look at it from purely legal. So it depends. Are there any other questions that are that we can answer, or can we move into the last phase of our report? And then Sherry, send a text. I don't want this published, but Sherry, you can call me. Laura can give you my telephone number, and I'll answer your question about the Avid form. I'd rather do that offline because I don't want to challenge your broker. I was kidding about the words I used. Probably not the best choice, but I really think that the Avid form should be used, and I've never heard a good reason why it isn't.
Mm-hmm.
Yeah, you're recording the class, so I only get paid for this one shot. So I'm going to have to sell something to be able to eat.
Laura, could we go to the next withholding taxes?
Yeah, you're taking that, Linda.
I am.
Okay.
Keep going. We went over that one.
We're almost skipping. Are we going to withholding now or not? Okay.
I thought we were. That was the next.
I thought it was.
There we are. Correct.
Okay.
Withholding. Now, everybody understands that, remember, seller has 7 days to get all documents to the buyer, all disclosures, all documents that are required in the contract. Then one of the most important ones is the FERPA form. It's the AS form.
Mhm.
And what the contract states, that the AS form has to be complete. There has to be either a social security number or a TIN number filled out. All the sections of that document need to be completed. I'll give you a heads up. We were told by the attorneys at CAR, if you as an agent say to a seller, if I were you, I wouldn't fill out that form and put my social there with all of this identity theft going on. Guess who's responsible to pay the taxes due in the transaction? That would be the agent. So don't advise them what to put on the form. Advise them that the form needs to be completed, every section. Also, if they do not want to, if they choose as a seller not to complete the information on that document, and they have an agreeable escrow company or title company that will complete a QS, which is they turn all the information over to that entity, either an escrow or a title company, you as the agent must provide the QS form because they don't have access to zip forms because they're not realtors. So either side of the transaction can supply the QS, preferably the listing side, but they need to have a QS to complete and sign that they have indeed accepted the information from the seller and they are or are not a foreign investor. The taxes could get pretty heavy for a foreign investor. But they need to, by federal law, put the social security number or their TIN number on that form. I don't know how many, I mean, probably 9 out of 10 transactions we do here when we're representing buyer, that the AS comes in incomplete and we get a fight from the other side. And it clearly states in the contract that every answer has to be on every form that's being delivered from seller to the buyer. So know that this is the section that we are referring to if you're having issues, as well as we are, regarding this form, because it's not understood. It's 11H section, and it clearly states all the information that I just gave you. They do have to fill out the form, whether they're a foreign investor or not. It's the only way the buyer can determine if they have to instruct escrow to withhold taxes. And how that works is, and what I tell my transaction coordinator when she's pulling her hair out, that she can't get them to give her the completed form, I tell her to have the buyer call escrow and tell them withhold taxes. Watch how fast the AS completed comes into your office for the buyer. So any questions on that, please put them in the chat and we'll move on. John, you want to go for?
All right, so I'm going to hit a few of these real quickly because there's been no changes to any of them. So let's move on to the next slide real fast. Megan's Law, real simple. There's been no change. That the law is really simple, that absent special knowledge, your duty is to disclose the existence of the database. Contract does that for you. If you have special knowledge of a sexual predator, then you got a problem for your lawyer to deal with. And so usually they deal with vicinity and things of that nature. So again, very much of a risk management issue. Next slide is the gas and hazardous liquid. Doesn't really apply to Southern California. There's an explosion up in San Bruno, tragically killed a bunch of people. So the legislature passed a statute requiring that certain disclosures be made. If you're doing a transaction in Northern California, this might apply to you. You need to be very careful, but in Southern California, this does not apply. Next slide, please. This is a form that if you are, those of you that live in a homeowners association know that it is very different than living in a non-homeowner association. Even one like the one I'm living in now, where we have a little common area and the architectural control rules are very stringent. Other than that, we've got no amenities of any kind. Everybody has their own pools, etc. So, but the fact is that there are unique issues. So for those of you that are representing a buyer who is moving into any type of a homeowners association, whether it be a big one, a small one, anything in between, you should provide this advisory. It is the buyer's homeowner association advisory. It emphasizes to your buyer why they should read the documents. They're going to get stacks of documents, CC&Rs, bylaws, rules and regulations. They're going to get minutes of the last 12 months of meetings of the board of directors. And I know Linda and Laura, you guys go to lots of board meetings. Lots of stuff happens at those meetings that, if it had to do with home ownership, could be important. Mm-hmm. Discussions of special assessments that haven't been voted on yet, things of that nature. Financial information. If you're going into a homeowners association, why you should understand what a reserve study says, because the homeowners association pays for a lot of stuff. So all of that is important, pending or future assessment issues. Special emergency assessments. Litigation that's pending. Next page, please. Very important issue today, which is restrictions on short-term rentals. And I represent Palm Springs, and that's a huge issue out there. Investors moving in there thinking they're going to, use the place a couple of times a year, but then rent it out to Airbnb, only to find out the HOA has restrictions, lending restrictions, and noise issues, common area issues. Parking and storage. I got an RV. I want to park it. I can't. Why? Because the association doesn't allow it. Again, special needs. How does the association deal with issues relating to my child's special needs and all that kind of stuff. Very important form. I urge you to consider using it. Again, it's a risk management issue, but it's also a really good form because it takes the place of you giving incomplete advice, right? CAR took the bull by the horns here. They put together an excellent document. I would urge you to use this. Next slide, please. Get ready, Linda. I think I'm coming back to you. Again, in a planned unit development, no real changes that I'm aware of in this section. It simply indicates that you're going to disclose within 7 days. If the property is in an HOA, you would use the SPQ form for that purpose. And then it talks about all the things I've just gone over that are in that form. You know, what I'm entitled to. Are there pet restrictions? Remember, companion animals and service animals by law in California are not pets. I don't care what pet restrictions you have. If, again, you have a whole separate issue if the animal is for purposes of service, which would primarily be dogs, and if it's a companion animal, which could be anything, frankly. If you've been on a plane lately, you know that to be true. So again, there's going to be this just goes over what I just talked about, what the buyer is going to get from the seller, and then, you know, who's to pay for it. Next slide, please. Again, and then of course the natural hazard and disclosure forms, and, you know, again, just simply talking about what Linda's already covered, who's going to get what and what forms to use. Again, more of a risk management issue. No changes to the body of the contract. Next slide, please. I'm going to catch us up. Known material facts. This is basic California law that within 7 days after acceptance, it says here the time in 3N, but trust me, it's 7 days after acceptance, unless otherwise, that the seller will provide the buyer with a disclosure regarding all known material facts and defects affecting the property, including but not limited to the insurance claims we talked about earlier that were made within the last 5 years, and that primarily arose because of mold related litigation, that the buyer will give permission to contact the lender, and there's a form for that if necessary, and make any other disclosures required by law. So this is the mandatory disclosure. Next slide, please. Buyer's investigation, unless otherwise agreed, buyer within the time specified, which is going to be 17 days, is entitled to make pretty much any inspection that they want to make. It's unfettered. There's no change to this in the contract. Now there is a change in B, so let's go to B. What they've done here is and I think, Linda, they've done a great job of laying out in much more detail what those inspection rights are. A general inspection, a lead-based paint inspection, inspections, and this is what's left of your wood destroying pest addendum, right? This is the paragraph that talks about, okay, we're going to get a wood destroying pest inspection. Unless I've agreed to pay for it, you're entitled to do one, and it will talk about you know, whether or not there are problems with the property, including roof coverings, or shall not include roof coverings, excuse me. There's certain restrictions regarding shower pans and all that. Doesn't talk about who's going to pay for it all. It just says I can do the inspection. And then, of course, any other specific inspections or physical conditions regarding the land that are kind of unique. And it could be, for example, septic, it could be a well, it could be monuments, it could be something like that. And then, of course, all other buyer investigations, such as insurance, not specified. So basically all the rights that you have, and then a right to, within that same period of time, to review all those reports. Going on to the next slide, please. But again, I like this because they expanded and defined what these inspection rights are. This is a restriction. It's the only restriction that you are not allowed, subject to some minor exemptions, because when they take pest control, they chip away at this and they chip away at that. But you're not allowed to do any invasive or destructive investigation, except for minimally invasive. And unless there's a law that requires a government official to come out, you do not call for a government building or zoning inspector. Now that may change. I just got an email from my office during the break about some problems that are coming up with zoning as it applies to the home hardening and the special wildfire zone issues. So that'll be filmed for 11. I got to talk to my office one tomorrow, and we'll find out what that's all about. Next slide, please. Again, buyers shall make the property available for all inspections, complete all the investigations, and now they have said that at no cost, you will deliver, as the buyer, copies of all of the reports, all of the inspections that were done, and that this delivery shall not include appraisals except as appraisals are received in connection with FHA. But again, go back to that other paragraph that says, but if I cancel because of an inspection or because of an appraisal, then I can ask for a copy. So you don't automatically get a copy of an appraisal. You do get a copy of an appraisal, however, if I cancel because of it. So that's, they kind of sort of negotiated out the argument that goes back and forth is, why doesn't the seller get a copy of the appraisal? Well, now you do if I canceled. Otherwise, what do you care?
Right.
Right? What do you care? So let's move on to the, before I go to this paragraph, and then Lynn, I'll let you handle this one because I'm tired of talking. But here's the issue that comes up, and Linda, you and I have had this conversation multiple times with our good friend Barbara Betts, is, okay, now I've got these reports. We can't agree on repairs. What do I do with them? You disclose them to the next buyer.
Absolutely.
Period.
In fact,
Don't argue with me.
right.
I'm a lawyer. I'm Italian. You don't argue. Linda and I are both, you know, she's Italian too, so we're both obviously all knowing. And you do not keep that from another buyer. Now, you may not be able to actually provide a copy of the report because the report may say this report was prepared for Ms. Halverson. No one else can see it.
Yeah.
That's fine. But that doesn't mean you don't disclose what's in it. So if you don't do that and it's discovered, like, because your buyer may, or your seller may say, let's keep this quiet. I didn't have this done. I don't agree with it. If you do that, then the next buyer comes along, buys, doesn't find out the same information, then later on suffers some damages because of whatever is in that. You're going to get sued and you're going to pay money. Okay. All right. Go ahead and talk about indemnity if you'd like. And there's really no change to this paragraph.
Right. But also with that, John, there's 2 times when a TDS would be updated, or 3 or 4 or 5, depending on how many times the property gets sold. Because we've had a lot of buyers coming in and investigating and then canceling. Then another buyer comes in, another buyer. The seller is obligated to update the TDS after they've received reports from buyers about the material facts of the property. So you have to have your sellers updating that TDS. Now, also the TDS has to be updated. We had a situation here where we had a condo listed and water dripped down from up above unit. And the TDS, everything was already delivered to the buyer, but the leak happened in the unit above the one we were selling. And if you read the contract, it specifically says if something happens to the property during an escrow or during a listing period, the seller has to update and give the new updated TDS to the buyer. So there are times when that TDS and SBQ need to be updated. So know that you're following the contract with that.
I couldn't agree more. What I tell my clients in the brokerages that I represent, including John and other people, I say, look, you tell your agents that if they're taking a TDS pretty close to the time they take the listing, you gotta ask the question before that 7 days is up. Do I need to have this refreshed? Have there been changes? Is this still a valid document? And frankly, as we talked about before, if during escrow you discover things, you may need to go back in. And that's why you can use that addendum form to check off the box and update. You don't need to update a TDS if the buyer discovered the issue.
Correct.
The contract says that.
Correct.
You don't have to go back in if you get a bunch of documents in that transaction and then update them all. You do not have to do that. But in a new transaction, as Linda just said, boom, you're updating. Okay, anything, there's no change to this E.
No, buyer indemnity didn't change. In other words, if somebody, the inspector or something who the buyer sends in breaks something, which has happened, that's the responsibility of the buyer, not the entity that went in there. Now, they can settle up with the entity later, whether it's the roofer, they went to doing a roof inspection or whatever, but the buyer is responsible to the seller for any damage done by anybody they send to the property.
But be careful of overstating this paragraph, because again, indemnity is another word for insurance, and if the buyer has no money, the buyer is not indemnifying because the buyer has no money from which to indemnify. So if you're allowing, and I believe usually a mistake, if you're going to allow the buyer to go in before closing and do a bunch of repairs, then you need to understand what this notice of non-responsibility is. And again, that's really a legal issue. Talk to your lawyer. But if for some reason the buyer is going to make repairs ahead of the close of escrow and then doesn't pay, the seller is going to be faced with a mechanics lien. I have a case just like that pending, and my seller now is selling the property. It's a complicated situation, but in order to be able to close and still dispute the mechanics lien, he has to leave in escrow twice the amount of the mechanics lien. So again, you don't want to be in that situation. Let's move on to the next slide, please.
So we'll go to title report. If the seller's responsible, obviously, to pay for the preliminary title report and provide it, it needs to be done within 7 days. Maybe the buyer says, I'll take that responsibility. If they do, and they're responsible for paying, the buyer shall act diligently and in good faith to obtain such preliminary report within the time specified as well. So
there's been no change to this. My best legal advice: never, ever, never, 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 ever, ever, never, ever, never give advice on how to take title. You're not qualified. Frankly, I'm not qualified. If I have a question in a transaction I'm dealing with, I'll pick up the phone and call our estate planner and find out, is there an issue here relating to title because of an estate issue or a divorce issue or something like that. So be very, very cautious about giving advice on title and vesting, other than going over the preliminary report as we talked about earlier. Let's go to the next slide, please.
And one thing, I want to mention here in 13, well, B, there's no changes. So go to the next one. 7 days after request to give the escrow holder any information regarding clearing title.
And so that's what's going to happen is I'm going to talk to my lawyer, talk to my accountant. Again, a lot of the title companies, Linda, they have sheets that define each way of holding title, and that changes periodically. There's going to be another change coming up. So you don't want to give that advice. I've litigated a couple of cases where that issue came up and the agent gave bad advice, caused a lot of trouble. And the problem is, a lot of times the problem doesn't surface until somebody's dead, and then you can't fix it.
Right.
So just be very, very, very careful about, just stay away from that. You're not doing your client a service by telling them how to take title.
The next.
Okay, one thing real on that last, go back real quick. I want to point out, although this is not a change, that there are things that the seller knows about that are not of record, right? And so you have 7 days to notify the buyer, hey, there's something off record. Maybe you've agreed with your next door neighbor to allow an encroachment that isn't of record, or something like that. You got a short period of time to notify the buyer, hey, you're going to get a title policy. It's not going to talk about this, that, or the other thing, but I'm going to tell you about it now, and do it in writing. Okay, next slide, please.
The next one is important regarding if you see in the center there, the geographic targeting order, GTO. This was to avoid money laundering per the title company. So the title company wanted that in there. So that's been added, GTO. And then the bottom of the page, if you go one more slide, it says the manner of taking title may have significant tax consequences. That's in the current contract, and again repeated in this one.
Right. And again, don't do it. It just, first of all, you're not qualified. Frankly, I've been a lawyer for 40 some odd years, and I'm not qualified very often to give, other than to say, well, joint tenancy means this and tenancy in common means that. But I don't know how you should take title because I don't know your tax situation. I don't know your marital situation. Maybe you have children from other marriages that you want to make sure inherit. All those things are very, very critical. And frankly, the subject of a whole nother class. Linda, is that title class you're giving? Is that through the board, or is that just your
No, just one of our title reps is coming in to teach the agents how to read it, to prelim, things to look for in a prelim.
Laura?
We do have that class a quarterly at Tri-Counties.
Cool.
Good. It's someone, I think it's as important. I took a title class in law school from the attorney that was in-house for First American Title at the time. And I thought it was one of the best classes I ever took. And to this day, I use title to solve so many problems. And frankly, to understand how it works and what kinds of special endorsements you can get is valuable, beyond value in solving problems for yourself. Next slide, please. Look at this, we're on 14 of 32. We're almost halfway. Again, you're going to get a title policy, and it's a good one. And it's been the same one you've been getting for years. No change here.
Correct. No change. Periods, it's same 7 days, but all contingencies will be released by 17 unless it's agreed otherwise between buyer and seller. But
Correct.
The 17 days, there is no longer 21 day for loan contingency removal. It is 17. If they need more time, please explain to your buyers, and we run into this at our office, please explain to your buyers, they are not going to get anything in writing from a lender that says on day 17, oh yeah, we're going to give you that loan on day 30 or 40 or 45. They're not going to do that. And buyers expect that. So they're very reluctant in releasing the contingency for loan because they're expecting to get a firm something in writing, and it's not going to happen. So explain that upfront to them. Then you don't have the issue on day 17 when they're threatened to be canceled because they won't release the contingency.
And again, there's a paragraph in here that basically says that it is the seller's obligation to get everything, and that the buyer's duty to remove contingencies is conditioned upon the seller providing what they're required to provide in a timely manner. So here's the deal from a lawyer's perspective. If the seller doesn't provide what the seller's required to provide, the buyer, pursuant to the language of the contract, can either cancel or waive. But there's a third option that's not referenced in the contract: sue for specific performance.
Mm-hmm.
I will record a list pendants. I will tie your property up. I will then get an attorney's fees award after I win the case, and you are toast. So don't mess around with this. Once you go into escrow, your property can get tied up for a very long period of time. And if your seller's playing games, you're likely to face that. Frankly, this 14 has not changed in a significant way. There are a couple of minor changes I'll mention, but here's the bottom line. You provide everything you're supposed to provide in a timely manner. If you don't, you face the risk of a lawsuit or cancellation or delays. Number two, the seller cannot cancel without first giving a notice to perform. So it doesn't matter that everything says 17 days. If you don't give a notice to perform, then everything continues. Once you give a notice to perform, the buyer has 2 days to waive or to cancel. If they waive, then they assume the risk and responsibility for everything that we've been talking about all day, absent fraud. And if they cancel, they get their deposit back. In fact, if the seller sends in a cancellation instruction, it says, I'm authorizing release and delivery of the deposit, although that will require mutual instruction. I just pretty much described paragraph 14.
Yes, you did. I did want to point out that CC form and CR form, both the contingency release and the cancellation form, will be updated when the new contract comes out. So there are changes to both forms.
Correct. And if you're going to send A notice to, I have a client who's almost to Linda's level of competency. She's really very sharp and she's mean. She's a mean person. And what she does is when she sends a notice to the buyer to perform on behalf of her client, she'll send a blank CR and a blank CC. And what she's essentially saying, you pick, right? I'm giving you 2 days, you pick, fill out that form or fill out that form, or we're going to cancel. And she has a standard kind of form letter that she does that with. And so again, what I want you to understand is that it's while it's a little complicated, I know a lot of people don't do notices to perform because they get confused. It's really not that complicated. If you don't do a notice to perform, then the buyer retains the right until 3 days before the close of escrow to cancel and get their deposit
Get
back.
their money back, yes.
Absolute bad faith. Okay, next slide, please.
And once again, we're talking about the same things over and over here. Time periods, buyer review of the documents. If the time period is coming up 2 days prior to, get those notices to perform out. And what strikes me strange is agents look at me like I have two heads when I say, did you do the notice to perform? Did you do this? Did you do that? And they look at me like I'm crazy. It's repeated over and over throughout these paragraphs of what exactly the sellers and buyers are obligated to do in order to cancel or remove contingencies. It spells out exactly what to do in these paragraphs. Buyer, you need to review the documents, release contingencies in a timely fashion. If, like John pointed out earlier, if a document's given at a later date, they have 5 days to decide whether they want to cancel or not. They get the open right to do that. Say the preliminary title report didn't come in and everybody missed it, and it comes in on day 24. The buyer gets 5 days to decide if that preliminary title report is sufficient for them.
Right.
Otherwise, they can cancel and get their money back. So just
But there haven't been any significant changes to this paragraph. So assuming you're familiar with the current form, you're in pretty good shape.
you got it.
Take a look for number 4 does say continuation, and it reinforces what I've said, which is that even though 17 days says it in the contract, we're going to continue them on until you give me a notice to perform. A strong suggestion. Look, that's sloppy workmanship. Frankly, you should be keeping track. And if the buyer needs more time, do an extension of time addendum.
Correct.
Okay, next slide, please.
Linda, there's a question in there. Do you want to answer it real quick?
Sure. For non-independent escrow, can they fill out a QS form? Yeah, in fact, I understood that broker-owned escrow should not fill out a QS because it is a conflict with the brokerage.
That's correct.
And that's when I remember when I said the QS form, I said escrow or title. That's where the title company would come in. So non-independent, that would be, you meaning broker owned? Yeah, broker owned escrow should not be completing QS forms.
That's
There's
correct.
a conflict of interest.
That's correct.
And there's one more question. It's the last one from Chris Bravada.
Oh, okay. Hi, Chris. Does this apply to new construction as well, John?
What are we talking about? I don't know what this is. I don't know when that question came
What you
in.
guys were just talking about.
Removing contingency?
Yeah, I believe it was this one.
It's a different set of laws because
Yes.
the TDS SPQ removal, all that is governed by this contract. Most of the new home construction people have their own contracts. The contingencies are generally going to be much different. That really is a risk management issue, Chris, because if you're involved with new home construction, or I know Zillow uses its own forms, all of that, you need to be very careful because, well, you get training on this form, and this is a pretty neutral form. It doesn't favor the buyer or the seller. It's meant to be more of a mutually beneficial contract. Those forms don't. They favor the builder, or they favor the client of Zillow, usually the buyer. And so you need to be very, very careful about using forms because you may be practicing law without a license. So no, to answer your question, I can't ever answer a question in a short manner. But no, The answer is no, it does not apply to new home construction because it's going to be a completely different contract.
And John, this question came in. I had a transaction where the title rep refused to sign the QS when it was a broker-owned escrow. That falls back on the seller, I would say, because it's really the seller's obligation to give that information from the seller to the buyer within 7 days of acceptance of the contract. If that information is not supplied either in a QS or a completed AS from the seller, I would instruct the buyer, as the contract states, call escrow buyer or email escrow, put it in writing that they need to withhold the taxes. So the buyer, because there's only two entities in an escrow, whether it's 20 sellers and 20 buyers. If the seller's not paying the taxes as a foreign investor, guess who is? The buyer. So to protect the buyer's interest, I would tell them to contact escrow, tell them withhold taxes, and watch how fast the AS comes in completed to the buyer.
Okay, next slide then. Let's rock and roll. All right, again, time period, just again, the buyer's right to cancel, seller contingencies. So again, these are all based on current contract form. There's no changes to it at all.
Same. Is it still repeating? We're back in, let's see, E. Aha.
And there's the cancellation, which is going to change. This is not the current one, unfortunately.
No.
The one that was revised back in June of this year. I don't know that they're changing it again.
Yeah,
This-
he said it is changing as of
Okay.
December.
I have a list here, so I just got an email from my office. I'm writing a new forms and I'll go over that list with everybody and get that to Laura before the end of the year.
Okay, once again,
And
it's-
once contingencies are removed, then you put the deposit over to the seller's side of the sheet. And now the seller gets to keep the deposit if the buyer can't close. And obviously there's some exception to that for fraud, but the bottom line is once the buyer and the seller remove their contingencies, there are no longer conditions preceding to the obligation to perform. Next slide, please. Now, although it's really it should be a standalone. The bottom line is that sometimes courts don't like it when people forfeit their rights. And so what CAR did is it said, look, if the parties don't work together, I mean, a lot of times you guys close without anybody sending a demand of any kind. But for purposes of making sure that your file is properly documented, you can serve a demand to close escrow, and you have to do it 3 days before escrow has to close. So if I want escrow to close on time, I will give it 3 days before whatever the scheduled date is, always keeping in mind that if days fall on if a day of performance of anything falls on a holiday or a weekend, you go to the next working day. Okay, so if you're given a notice to perform, or excuse me, a demand to close escrow tomorrow, then really it's an escrow demand to close escrow by Monday. Okay, and you should put a time in there, because otherwise it's going to go to 11:59 p.m., which means really the next day. Okay, again, effect on cancellation simply indicates that, once canceled, everybody gets their deposit back if there are mutual instructions, absent any fees or costs that the escrow holder has to pay, and that if a party acts inappropriately and says, the seller says, you know what, I'm keeping the deposit regardless of the fact that you had a right to cancel, then there's a possibility of $1,000 fine.
Mhm.
Okay, and attorney's fees, frankly, if it's more than $10,000.
Correct. The legal judgment here, John, is where it says note on that last page.
Right. That's the statute that talks. I'm just trying to catch us up here. So
That's okay.
yeah, that's the statute 1057.3 that says that if somebody is not acting in good faith, then the court. And this usually applies to small claims. So if it's a $5,000 deposit, the seller is going to be required to pay escrow will release the $5,000, and the seller will be forced to pay an additional $1,000. Repairs, the repairs have to be done in accordance with statute. There is a bill pending to raise handymen. Right now it's $500. It hasn't been passed yet. It's going to be discussed in the upcoming session, along with the other 49,000 bills that, no, what is it, like 2,000 bills, I think. So again, you make your repairs, do it in a good workmanlike way. Again, another major cause of litigation is when repairs aren't done correctly. Using licensed contractors where appropriate. $500 for a handyman is the max, including materials today. It may go up. Again, there's lots and lots of issues. You provide the buyer, if the seller's doing the repairs, with invoices, receipts, all that kind of stuff. And there's no change to this paragraph. In fact, there's no changes till we get to paragraph 21.
Right, right. Final conditions still the same.
Still the same. It's not a contingency. The purpose is to make sure the property was properly maintained, to make sure that the repairs were done correctly and all the other stuff. And so here's what you want. That's the form. There's a place on it. If your buyer says, you know what, I'm going to waive the walkthrough, there's a box to check off that they should sign saying you're doing that against my recommendation. Okay. And that's under number 2. Next slide, please. Again, what are you looking for? Well, you're looking for these issues. I mean, these are the things I've seen. Linda, you could probably add another 10 things to this list. The thing that I see though is trash left behind. Scratches that were caused when the movers moved out. Not done cleanups. And then the big issue that I've seen, we just settled the case where you don't move things around when you do inspections and all that. But when they made the property vacant, all kinds of things have been covered up. Okay, so that became a litigation issue post-close. Next slide, please. Prorations. You prorate because nothing ever closes on the 1st or the 30th, right? All right, next slide, please. Again, this is just confirmation. I don't know that it's been tested in court yet. Basically confirming that the payment of your commission is a joint instruction, but that doesn't mean the parties can't get together and mutually cancel this provision, but it gives you some level of protection that you're going to get paid. Hopefully it's working pretty well.
This next one's pretty important for the agents to read. It's
Right.
the scope of your duty, and it's very important to read this. It's not changed, but
No, not at all.
a lot of agents haven't read it.
Actually, if I recall correctly, this is the old page 2 of the buyer inspection advisory. But the thing that's important here to understand is these are general principles of law. You can change them by getting special knowledge, right? If you know of some issue, this basically says if you're not aware of anything that would affect price, if you're not aware of the condition of the property other than what you can see or what the inspections reveal, et cetera, if you're not aware of boundary problems or this or that, then your general duty is as specified in 18B. However, if you do become aware because of special knowledge, then you must disclose that information, and that's a whole topic for a whole nother day in terms of how you do that. But this is basic law. Linda's correct. And the next slide, I believe, and again, these are joint escrow instructions, okay? That means you don't have, and the reason for that is really simple. Back in the day when escrow was separate and you had to write escrow instructions, what would happen is Linda would write up a contract. She'd then send it over to escrow. Escrow would interpret some things and write it maybe a little bit differently. And now the question is, which governs?